Hello, everyone. Hi. Hello, everybody. Hi. Fancy seeing you here. So we've got day 22 of Carry On Red. And I hate how my damn... you put it on and then everything goes haywire with your hair. So, anyway, we've got Carry On Red and her trill. So, we'll see how this goes. YouTube notified me about the blog. Good. Have you ever farted in court? Oh, yeah. I've done a couple times. Never a ripper. Always silently. And then other times you just hold it in, and you have to hold it in to the point where like you get cramps and it starts stabbing at you. And yes, I've done that. Those are the worst. Did I see the Metal Gear Solid trailer? No. I'll take a look for it. So here we go. Am I going to cover Riley's arrest? Once I get documents, I will. Until then, there's no point in covering it. Because I know Dick's going around mauling and screaming at everybody. But until we see the documents, it's not really helpful. And Riley's not as big a draw. So, like, if we get him, we'll go over him. So, yes, Sergeant Bukaki is still on cross. And also, I've heard Trooper Proctor comes in. But I haven't heard what he does. And also, apparently somebody's learning how to fly a helicopter because they are, like, very low over the neighborhood. So I apologize if you can hear that. I promise the police are not coming after me. So let's get started with Carry On Red and her trill. Now, guys, at the beginning, there's going to be the motions regarding, we covered this last week, the motions to exclude experts. So here we go.
So we're here on the Commonwealth's renewed motion. Can we turn off one of those air conditioners, please? The Commonwealth's renewed motion for reciprocal discovery and the motion to exclude the defendant's newly provided expert, Dr. Marie Russell. I will hear you on your motion, Mr. Lally.
Morning, Your Honor.
Oh, I'll hear you, Ms. McLaughlin.
Essentially, the Commonwealth is just seeking that the defendant produce what the Commonwealth is entitled to under Rule 14 and what every criminal defendant in the Commonwealth of Massachusetts must produce to the prosecution. It was not until the day prior to trial on April 15, 2024, that the defendant provided notice of all their experts. During jury impanelment, the Commonwealth filed a renewed motion for reciprocal discovery, and the defendant was ordered within a week to produce the expert opinion testimony that the Commonwealth is entitled to. We are now entering, I believe, week 8 of the trial. The Commonwealth has not received any intended expert opinions, anything that those experts, any written reports, opinions, or anything that those experts have based their opinions on. Essentially, the defendant's strategic decisions not to retain their own expert, but rather rely on the U.S. Attorney's Office investigation does not alleviate them or relieve them from their Rule 14 obligations. As it pertains to Dr. Marie Russell, the Commonwealth did not receive notice that she's an intended expert until about week 6 of the trial on May 21st. And it wasn't until May 30th that the defendant provided a brief synopsis of what her expected testimony would be. Essentially, and looking at the balancing tests set forth by the case law, the Commonwealth was extremely surprised by this disclosure. And further, the Commonwealth would put that the defendant's delayed decisions to produce reciprocal discovery is in bad faith. It is intended to ambush the Commonwealth and conduct a trial by surprise. We are still receiving reciprocal discovery. Over the weekend, we received additional photographs that the defendant intends to use. The Commonwealth is extremely prejudiced by these delayed disclosures. So looking at all the balancing factors, exclusion of Dr. Russell is really the only remedy that's appropriate given that we are in week 8 of the trial. The Commonwealth cannot seek a continuance. The Commonwealth has their hands tied with how to effectively prepare for cross-examination of that witness as well as all the other witnesses. We don't have any materials. We don't know what the experts' precise opinions are and what they were testified to. And it's essentially, it is in bad faith and there's no less severe sanction. So the Commonwealth would move to exclude Dr. Russell.
Hey, Jim.
And at this point, we are essentially just seeking the reciprocal discovery that the Commonwealth is entitled to be able to effectively prepare cross-examination of these witnesses so late in the game. Thank you very much.
All right, who's arguing this for the defendant?
There's no mic at counsel table, so I'm going to go to the podium with the court's permission. We need to be heard on this.
Okay, so the big issue here, if you guys don't understand it, is the issue we talked about before with experts. You have to give expert reports and expert opinions in advance so they can examine it and then decide if they need to go to their experts. Now, part of the issue here is the state's claiming, well, the defense is using experts the FBI used and the Department of Justice is using in their investigation. And you could do that. You can cheat and use someone else's work. You still have to get that work and give it to the prosecutor. The prosecutor is not imputed to be in the same vein as the FBI or the DOJ. We've talked before with the TUI letters and the TUI process. There's a separate, it's not just set that easy. So if that's what they've done, that is playing fast and loose. But let's see.
That's why we're here, Mr. Yannetti.
Thank you. I'd like to start with the most outrageous and false assertion that the Commonwealth made in its motion.
Can I just ask you, there's no jury here. Can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay. Because I don't need, the hyperbole.
I need to.
She just told him, like, knock off the theatrics, but he has the right to fucking speak. He has the right to defend his client. And they're claiming that he lied to the court. And I think he has the right to defend himself.
Make my argument in the way that I think is most effective for my client. I will keep this brief and succinct, but I have points to make that I need to put on record.
Okay, and I'm the person you are trying to convince, correct?
I understand that. The Commonwealth, in a public filing, wrote the following on page 3 of its motion. Quote, during a pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is false. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm sorry?
I don't have that in my motion.
It's on page 3, Your Honor.
I have the Commonwealth's renewed motion for reciprocal discovery, a motion to exclude defendant's expert, Dr. Marie Russell. I don't see your name at all, Mr. Yannetti.
Uh-oh.
I'm on page 3.
Sorry, it's not page 3, it's page 4. My apologies.
Okay, I've been that guy before. Your Honor, it's right there on page 6. I don't see it. And you look, you're like, oh my God, I don't see it. And you're like, wait, did I mix this up? And you're like, did I imagine this? You flip, you're like, page 7. Or you're like, page 5. I've done that all the time. That happens all the time.
My name is right there on page 4. It says exactly what I just argued to the court. It's about the 5th line down. It starts during a final pretrial hearing on February 15th, exactly
Okay.
as I said.
That's kind of an issue then.
Okay.
All right?
Sorry.
We pulled the tape
Sorry, guys. I don't know why I clicked start. It double hit us on that.
from that February 15th hearing. Here is what was actually said. This court asked me the following, quote, while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that? I replied, no, I think this is the only outstanding DNA issue. The court then replied, okay, so all right, we're not dealing with canine DNA. And I said, no. There is nothing in there, contrary to what the Commonwealth has represented to this court in a public filing, that I said there was no canine involvement. There is nothing in there, contrary to what the canine represented to this court and to the public, that the defense was not pursuing such a claim. Can you imagine the nerve of the Commonwealth to spend that interaction?
This is the hyperbole I don't need. Could you please get to the point?
Your Honor,
We've got a
of course.
jury coming in 15 minutes.
I understand, but this is
Wow.
my integrity has been attacked. There have been allegations of bad faith that has been attacked, and I
Wow.
need to defend myself and my client. We were only discussing at that
Got some
time
balls.
whether canine DNA was still outstanding, and I succinctly replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our
Wow.
right to argue that John O'Keefe's arm injuries were consistent with a dog attack. And I ask you, have they no shame? I'm sure it's not lost on this court that this false filing by the Commonwealth comes on the heels of their nefarious attempt to pass off an inverted video, a false video, before this good jury hearing this case. Never once during the direct examination of Sergeant Buchanan did they inquire or mention the fact that the video might
Can we please, all right, I'm going to stop you. Please direct your comments to Rule 14 and the reciprocal
Ooh,
discovery
well.
obligations that the defense has. That's what this motion is. I know you have a speech you want to make, Ms.
It's
Giannetti.
not Your Honor, it's most respectfully, it's not a speech. It's
Okay,
a
so-
defense of being alleged to have committed bad faith.
So you've moved on.
Okay, I get his point, but she also has a point too. We got to address the Rule 14 stuff. Great. They called you a liar. You're saying it's bullshit. Fuck them. Cool. We get that. I do think she's got a point. You do need to address the rest of it. I think you need to navigate it a little better, Yannetti. But I understand. You fucking hot under the collar. I've been accused of shit, and it's fucking annoying. And nothing, like, the prosecutor says you've done something in bad faith, that's makes you want to fucking break shit.
On from that. So please just focus on Rule 14 and let's do it in two separate parts. So you've changed, you're not calling Frank Sheridan,
No,
right?
we
You've
are
got,
calling Frank Sheridan.
all right. So you've got a new medical, Dr. Russell. We'll do that part of it separately. Tell me about what you've provided the Commonwealth on Chris Van E.
They've gotten his CV and they've gotten the substance of his opinion from us. And they've had that for a long time. And the court, I believe, has already suggested that voir dire will be done prior to his testimony.
All right. So it's starting to look like we might need a whole day of voir dire, and I'm trying to avoid that. So is the Commonwealth satisfied that when did you provide anything recently since the filing of the Commonwealth's motion, Mr. Yannetti?
Not on Mr. Van Eden, no.
What does the Commonwealth have on Mr. Van E?
On Mr. Vanny, all the Commonwealth has is what's contained, the synopsis on page 2, the first full paragraph. We do not know what his opinions are. It says he'll testify regarding his opinions and conclusions about reconstruction and EDR data obtained in connection with this case. He'll testify to chronological data derived from the EDR, including key cycles and triggering events from the time period in question. I have no understanding or information about what chronological data he's going to testify to, what his ultimate opinions are, anything beyond that relatively vague synopsis that does not comply with Rule 14.
Okay.
Similarly, what's outlined in the rest of the motion, that's all the expert evidence the Commonwealth has received from the defense is contained within the Commonwealth's motion.
Okay. So the defense needs to provide, I'd suggest you listen, the defense needs to provide what chronological data Mr. Van E relied upon and exactly what his opinion is. All right, by the close of business tomorrow.
That's fine.
All right. Now, regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I
I
understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
And you have not complied with your Rule 14
we
obligations.
can't, Your Honor. We can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in voir dire, right?
Yes.
We need to do that well in advance.
That's not a good okay, yes, guys, I get it. Bev is a bit of a bitch here, but she does bring up a good point. Like, you haven't even talked to these people. You've read their expert reports, and that's it. That is a bit of a problem. That's a bit of a problem. I understand there's other stuff going on there. But ultimately, that is not a good thing. That's not a good sign.
Of their
Okay,
testimony.
that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER doc. Is she an ER doc? I haven't seen her. She's not a pathologist,
Well,
correct?
she's a pathologist, but she has a lot of experience in an ER, which is why she has the experience of having seen dog scratches and dog bites and dog attacks.
All right. So this is not somebody that was involved in the federal investigation, correct?
Correct.
All right. So you need to provide immediately. I want a voir dire of her this week. So we can get her here Wednesday. And we want the other folks up here from Pennsylvania this week as well.
Okay, well, we'll make those calls.
So we need to pick a day. How long do you expect the voir dire of each of these witnesses? If in fact the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect the voir dire of each of these witnesses to take? I went and told the jury last week, last week that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
So
Yeah.
Yes.
you promised a lot of shit. It's your fault. Just saying.
At least with regard to the, of course, at least with regard to the ARCA witnesses, that's my co-counsel's bailiwick. He anticipates that unless there are, a substantial number of objections during the voir dire, he anticipates being able to accomplish that between 45 minutes to an hour with each of those three. With regard to Dr. Russell, we anticipate a half hour. Oh, I'm sorry, there's only two from ARCA, that's right.
You're only calling two? Which two? Are you calling the two that are certified as accident reconstructionists?
Doctors Richler and Wolf. Yes.
What the fuck? Why are we losing sound?
Reconstructionists?
Doctors Richler and Wolf. Yes.
Okay, that's not us. They lost sound on their end. They lost sound on their end. I don't know what happened, chat. Okay, so they have to show up everybody and get the witnesses going. So here we go.
Yay. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court in Floyd County of Norfolk. Do I need it? Give your attendance and you shall be heard. Do I see the Commonwealth of Massachusetts? The court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed.
Good morning, attorneys. We all met here at 8:30 to try and streamline things. And as a result of what we did this morning, it looks like there'll be some day this week that we will all meet to go through things that we need to go through, but we will excuse you. I just don't know quite yet when that will be. We'll know by the end of the day today. And also on the 21st, originally we said we'd be off for the 21st, but again, you know that we don't want to take up any more of your time than necessary. So we will meet on the 21st, but just in the morning because I have a long-standing afternoon that we cannot cancel. So the 21st will be a half a day. So we'll let you know more as the day progresses. All right, I do have to ask those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left on Friday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, read anything about this case since we left here on Friday? No. Thank you. Everyone said no or shook their heads. Thank you very much. Can we get Sergeant Buchanan, please? You have that flash drive? No. The flash drive that I gave you.
You solemnly swear the evidence the court hearing the case out here, the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, Mr. Jackson.
Thank you. So when we left off on Thursday, we were discussing the Sallyport video that was introduced by the Commonwealth on Wednesday during direct examination. Do you recall that?
I do.
When he introduced that video, Mr. Lally asked you several very specific questions about the video, including if you recognize the video in general, correct?
Yes, he did.
And you said you did.
I did.
He also asked you whether you recognize any of the individuals in the video at a particular time where he paused the video and you used your green laser pointer to point out a couple of individuals that you recognize. Do you recall that?
I do.
And in that pause, you indicated at that time on Wednesday that you recognized Trooper Proctor and what you thought was yourself, the person slipping at the front of the SUV, correct?
I indicated that Trooper Proctor and myself were in the video, and there was an individual slipping in the front of the vehicle.
And you then on Thursday, you corrected that to make sure that we were clear about it. The person slipping was actually the tow driver, not you, correct?
That's what it appeared, so yes.
Okay, I'd like to take a quick look at that with the court's permission at 4:46. May I publish
Okay.
that?
Yes.
This is 4:46. It's the same video that you were shown by Mr. Lally. We're at runtime about 5:37 and 05 p.m. I'm sorry, I said runtime. I meant time of day. Thank you. As a matter of fact, the time of day would be most easily seen right down here, although it's pretty small from where you're at. If you can't see that, please let me know.
I do not see that, no.
Okay, Your Honor, I'll hold off on that question. And I may ask the court for relief in just a moment. If we can play this for just a quick second, and I'll ask you so you can pause it. Go ahead and pause there. Okay, Sergeant, this is the basic video, the point at which it was paused when Mr. Lally asked you to identify the individuals in the video, correct?
I believe it was a different time, but I'm not sure.
Do you remember using your green laser pointer, pointing at the person in the back and identifying that person as Trooper Proctor, and then pointing at the person in the front, screen right, mistakenly as you? You remember that?
I remember indicating where the individuals would be, yes.
Okay, and so do you have the green laser pointer with you?
I do.
Could you point at the location where you see Trooper Proctor?
I do not know specifically right now if that is Trooper Proctor behind the vehicle, but when Mr. Lally asked me to indicate where we would be, it was in this location here.
You're indicating toward the rear of the SUV.
Correct.
On Wednesday, and I just want to draw your attention back to your testimony on Wednesday, you used the laser pointer and pointed at two different individuals, person toward the back, and you identified him as Mr. Proctor, as Trooper Proctor, correct? On Wednesday.
I indicated that Trooper Proctor and myself would be in the shot in the rear of the vehicle. And then I indicated that I'm wearing a olive drab baseball hat and Trooper Proctor's wearing a winter style knit black hat.
Isn't it true that on Wednesday, what the question you were asked from Mr. Lally is, Ms. Gilman, from Mr. Lally, Ms. Gilman, if you can just pause there for a moment as the sergeant's almost falling in the video, and the court said, keep your voice up, Mr. Lally. Do you recall that?
I do not recall that, no.
Do you remember Mr. Lally saying, Sergeant Buchanan, with reference to any of the individuals you see in this video, do you recognize any of those individuals? And you responding, I can recognize Trooper Proctor and myself. And you use the green laser pointer in doing so.
Yes, I did.
And that was on this area, may not be to the frame, but this is where the video was paused when you made that identification, correct?
It was approximately at this time.
Okay, so you were then asked after you identified, and at that time you did identify Trooper Proctor, and again, mistakenly, yourself, correct?
I directed the laser to the area where we would be.
Okay, and Trooper Proctor is the one toward the back of the truck.
Again, I cannot tell you which individual. There are multiple individuals there. I do not know at this point in time where it's frozen if that's exactly Trooper Proctor. I know we were present at that location, and I know what he was wearing for a headdress and what I was wearing.
All right, so you have to move along from this point.
Then why did you, one more question, Your Honor, then why on Wednesday did you indicate very clearly the person toward the back of the SUV was Trooper Proctor? If you don't know, why did you say that on Wednesday?
During the frozen frame, I could tell there were two individuals back there, and I was at one point in time in that location with Trooper Proctor.
That appeared to be Trooper Proctor in the back of the car.
From where the video is frozen right now, I cannot tell.
So you're changing your testimony from Wednesday.
Objection.
Are you changing your testimony?
I am not changing my testimony, no.
Okay, next question, Mr. Jackson.
You then asked whether the video was true and accurate as in terms of its depiction of what you saw, what you observed in Sallyport that night, correct?
I indicated the video is true and accurate to the location.
And you were then asked whether or not, in looking at that video, watching it, either you or Trooper Proctor approached, manipulated, touched that right rear taillight at any time, and your answer was never, correct?
That's correct.
And while you testified, this is the video that was displayed for the jurors, correct? And it was this orientation, the front of the truck facing right, the rear of the truck facing left, correct?
That's correct.
And for all appearances, it would appear that the right rear taillight of the SUV is the one facing the jurors, if you will, facing the viewer, right? From appearances. You didn't know anything different.
Can you rephrase that question, please?
Sure. Just from the appearance of the video, as it is now, the appearance of the video looks like the right rear taillight is the taillight that's facing the jurors, facing the viewer, for the rear of the truck, correct?
As it is frozen, correct.
And on Wednesday, I want to move through this relatively briefly, Sergeant. On Wednesday, you did not mention that this video was inverted, did you?
It was not brought out, no.
Not brought up by, I mean, that's a passive way of saying it. I'm asking you directly. Did you mention that this was an inverted video?
Not on Wednesday, no.
On Thursday, Mr. Lally finished his questioning on Wednesday, then came back on Thursday. You continued on direct examination under questioning by Mr. Lally again to start the day, correct?
That is correct.
And during that testimony on Thursday morning, you also, under direct examination, did not mention that this video was inverted, did you?
Did not know.
And then it was my turn to ask you questions. You recall that?
I do.
And then I began asking you questions about the accuracy of this video. And at that time, for the first time, you said it appears that it is a mirror image. It's an inverted video, correct?
I advised you that it is a mirrored image at that point, correct?
Would you agree with me now, as you sit here, that this video, as we're looking at it, is not a true and accurate depiction of what you viewed in that Sally Port that night?
I would not agree with you, no.
Do you believe that what the jurors are seeing right here is a true and accurate surveillance footage of the Sally Port that night?
Yes, it's just mirrored.
Which means what's left is right and what's right is left, correct?
Correct. If the jurors were actually standing where the camera is recording, which it's recording all accurate depiction of activity and events taking place, the back of the vehicle would be on the right and the front of the vehicle would be on the left, but all activity is accurately depicted in the video.
So in point of fact, everything in this video, every bit of it is reversed, correct?
It's just a mirror image.
So it's not accurate, is it?
It's an accurate depiction of what is taking place.
Sergeant Buchnick, if I were to ask you, let me give you a hypothetical. Let's say you were investigating a circumstance in which a suspect was being identified by 5 witnesses.
Except it's not accurate. The accurate version is flipped over. That's the accurate version.
Based on a tattoo on that person's left arm. And then you go show that witness, or those series of witnesses, an inverted version of a photograph of that person with the tattoo appearing on his right arm. And those witnesses all say, no, that's not the guy. I remember the guy. The guy had the tat on the left arm. Would you think that that's an accurate depiction of the person with the tattoo?
Objection.
Sustained.
Do you agree with me that an inverted video is not accurate? It's inverted by definition, right?
It's an accurate depiction of the events taking place.
You've reviewed this video in its entirety, you testified, correct?
Yes.
About how long would you say this video is in its runtime, from start to finish?
I did not take note of the length of the video.
All right, I'm going to ask you, Mr. Bates, if you could, with court permission, can you just pull the cursor back to the beginning of the time of day for this video? And pause it there. Can you see, and this is not an eye exam, can you see the timestamp on the lower left-hand side?
No, I cannot.
Your Honor, with the court's permission, I could do this.
I'd like to see it sidebar.
Why is she stopping him? Why is she stopping him? Wait. Why? Why is she stopping him? It's either fair or it's not. She's hammering on it. Like, he's hammering on him. He's not asking anything impermissible. Like, this is just obnoxious. This is just fucking obnoxious by the judge now. You know what I'm saying? What is even the point of this? Just showing that the video's been fucked with and that if you flip it around, somebody is messing with that side of the vehicle that Karen struck with the hit John's car with. So that's what this is. Trying to show that they fucked up the investigation. Oh my God. Come on, you guys.
Then jurors, sometimes lawyers have what we call stipulations rather than prolonging either testimony or calling an additional witness. Lawyers agree as to certain facts. So what the lawyers have agreed to here is that this video begins at 5:30 and 23 seconds, 5:30 p.m. and 23 seconds, and it ends at 5:48 and 15 seconds. And the total runtime of the video is 5 minutes and 51 seconds. All right, your questions, Mr. Jackson?
Thank you for that, Your Honor. Sergeant Buchanan, given the fact that the beginning time, the time of day, is 5:30 and 23 seconds in the evening, and the end time of this video stops at 5:48 and 15 seconds, would you agree with me, without doing the math down to the seconds, that's about 17 minutes and 50 seconds or so?
In real time, yes.
In real time. The actual time of this video, the runtime of this video, however, is only 5 minutes and 51 seconds, less than 6 minutes. You'd agree with that?
That is what's captured.
So that means that about 2/3 of the video is missing, correct?
It's not missing, just not recorded.
It's not there.
It was never there.
I'm not saying it was ever there.
What?
I'm saying I don't know if it was ever there or not. Neither do you. I'm saying it's not there, correct?
It was never recorded.
Well, you
Which means it's not there. Currently, we do not have that, correct? Well,
don't know what has been when happened wasn't recorded, do you?
Objection.
I'll let him answer that.
Do you?
I can only speak to what was turned over and what we received, and based on the evidence that was produced, the video that was produced is what we got.
I understand. So based on that answer, you acknowledge you don't know what may or may not have been recorded without your knowledge.
No.
Right. Did you notice that there were obvious portions of the video that in which individuals just seem to appear or apparate out of nowhere?
It's not a smooth recording of the events. When the motion triggers the recording, the video appears as if a person appeared in the video.
Apparation.
But that is due to the triggering of the recording.
Well, you don't know what it's due to because you're not an IT person who actually captured the video, correct?
Objection.
Sustained, ask that differently.
Sure. You're not the IT person, the technical person who captured this video, correct?
I am not, no.
You don't maintain this
how do you
video
know how
system.
the
do
camera
you?
works?
I do not know.
You don't know the inner workings of how the video system was originally installed or how it operates, correct?
Based on my training and experience, I know that certain systems, due to the restriction of the storage of the system, they try to save the storage and trigger the recording only by motion or certain time parameters. So in this video footage, I could tell you that the video is triggered by motion to record.
Well, how much storage did this system have?
I do not know.
What was the level of storage at the time that this video was taken? Was it 60%? Was it 99%? What was it?
I do not know.
So you actually don't know, Sergeant, the inner workings of this system, do you?
I do not know all the inner workings of the system.
But you do know that there appears to be portions of this video missing and portions of this video in which people just seem to apparate out of nowhere.
It's not missing. It just was not recording.
Let's move to, I think it's 5:37. 2 seconds. Okay, if we could, with the court's permission, can we play about less than a minute?
Yes.
Pause it. Did you see where the person that was toward the back of the vehicle went in this video?
It appeared they went behind the vehicle.
Which would be which area of the vehicle, the right or the left? In real life, not on this video.
In real life, it would be the right rear portion of the vehicle.
Toward the taillight area.
That quarter panel, correct?
Let's go ahead and play it. Pause it. Did it appear that someone just seemed to appear out of nowhere toward the rear of the vehicle just now?
Due to the triggering of the motion.
I asked you why. I asked you if.
There was already?
Appear if someone
It's motion activate. There's already a guy walking. How can you reactivate double motion? A guy was already walking along going, da 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 da, and this guy just bow right in the middle. How does that work? Your name's Sergeant Bukkake. That doesn't mean you have to be literally like loving Bukkake.
just appeared out of nowhere in the back of the theater.
That's what the footage represents. Yes.
Can we go ahead and play this? Pause it. Did you see that the person walking away from the vehicle that you earlier on Wednesday identified as Trooper Proctor appeared to have a notebook, black portfolio in his hand?
Yes, I did.
And can you see from there, I'm going to ask you this, basically knowing the answer, can you see from there the time of day on the lower left side as that person leaves the screen?
No, I cannot.
Would you disagree if I indicated to you that was 5:38 and 7 seconds in the evening?
I would have to see it for myself. I cannot agree with you based on your statement.
He's literally making it up. That's
You want to
why.
make me approach briefly?
Sure.
It's clearly bullshit. Somebody walked by already. That it doesn't have this separate, like, oh my god, that's an ugly purse color. But no, like, one person can't be walking by and the camera's like do, and then the other person starts walking and goes, oh my god, I didn't see him there. Like a T-Rex. That's not how it works.
You are unmuted.
All right. So, Sergeant, we're going to ask you to go take a look at that, okay?
Thank you, Your Honor.
And please don't speak until you're back in the witness stand. Thank you. All right, Mr. Jackson?
Thank you. Sergeant, did you have an opportunity to look at the time of day at the point that the video is paused right now?
Yes, I did.
What is that time of day?
5:38:07.
5:38 and 7 seconds, correct?
That's correct.
And remind me about how far of a drive in time is this location at Canton PD from 34th Fairview?
With no traffic, no adverse weather and road conditions, several minutes, four minutes, maybe 5 minutes, depending which route you take.
Your Honor, I have a flash drive that I'd like to have marked.
Is this a different flash drive than we had on Friday?
It is, and I can explain it sidebar if the court wishes.
All right. Are you just marking it or do you intend to show it?
I intend to show it with the court's permission.
All right. So we'll mark it for identification and then I do need to see you. Yes. Thank you.
Maybe approach.
Yes.
Let's just keep going here, chat. We're kicking the jury out. Interesting. Karen's like, oh my god, this is retarded. Why is this not loading? There we go. It's going to cheat here. All right, so we're in fan mode. There we go.
Does counsel need to see me or are we all set?
I think we're all set.
Okay. Right ahead, Mr. Jackson.
Thank you, Your Honor. As a matter of housekeeping, I would ask for the admission of the last item that was marked for identification.
XX. Was it YY? Oh, it was back again.
I didn't say
Okay.
that.
All right. So
That's
that will now be
Amelia
what, Madam
24.
Court Reporter?
With
Perfect.
the court's permission, I'd ask to display that video to jurors.
Okay.
If you could move that to a runtime of 1 minute and 17 seconds, so thereabouts. And go ahead and pause that. Sergeant, do you recognize what's depicted in what's just been marked as Exhibit 542?
I do.
How do you recognize that?
It's an inversion of the video provided from Canton PD Sally Point.
It's actually, again, that inversion corrects the perspective. Would you agree with that?
I would.
Okay, so now we're looking at what we've always been looking at, but it's clear that we're looking at the driver's side of the vehicle, correct?
That's correct.
And everything is properly oriented, is that right?
It's an accurate depiction of what is taking place.
Meaning right is right and left is left in this video.
The vehicle came from the right into the left. The driver's side is visible and is closest to the camera.
If we could go ahead and, thank you, Sergeant. If we could go ahead and play this for just a few seconds, please. Pause it. You saw the person that was toward the back of the vehicle that you earlier on Wednesday identified as Trooper Proctor moving toward the right, I'm sorry, yes, the passenger side taillight area in this video, correct?
I observed the person walking that way.
Let's go and play it. Awesome. And you see the person toward the taillight area moving out of frame just now, correct?
I did, yes.
And that person had the that black portfolio in his hand.
That's correct.
I'd like to ask Mr. Bates if you wouldn't mind moving the cursor back to the beginning before the video, I'm sorry, before the SUV was actually in the Sally Port. Okay, pause that. Do you see what's depicted in the video now at runtime at the beginning of the video?
I see the still frame. I'm observing the still frame.
Okay, fair enough, fair enough. Can you see from where you are, sir, can you see the chyron at the bottom of the video in blue, indicating the date stamp and time stamp? Can you see that from where you are?
I see the blue color. I don't know what exactly it is.
Are your eyes good enough to see that that is completely inverted?
They are not.
They're not inverted?
They are not good enough.
That was a good answer to a bad question on my part. With the court's permission, would it be possible for the sergeant to approach the screen and take a look at that timestamp?
Can you do that, Sergeant, please?
Yes, Your Honor.
Were you able to, may I inquire?
Yes.
Were you able to see that timestamp?
Yes, I was.
Sergeant, did that timestamp appear to be inverted?
The blue writing appears to be backwards.
So in this version of the video, which has been inverted from the version shown by the Commonwealth, the timestamp also was inverted, correct?
What appears on the screen is inverted.
Thank you. I'd like to zoom in on, just with the court's permission, on a portion of the middle of the video.
Okay.
Sergeant, I want to direct your attention to an area of the video right above the hand truck. Do you see that area?
I do.
Do you see that white object just above the snow line?
I see something there. I do not know what it is, if it's an object or it's more snow.
Can you tell if that's a sort of dirty white rag?
I cannot tell what it is.
Fair enough. Thank you, Mr. Fish. We can take that down.
Just say you don't know. Don't know what the hell's going on in the crime
We've seen
scene.
a corrected version of that Sally Port video from that camera. There's also another camera on the opposite side of the Sally Port, isn't there?
There is.
And that one,
Or that'd be a great
for
movie.
lack of a better phrase, that one came out pretty grainy.
Oh
Would you agree?
no. No.
Yes, it's not perfect quality.
The other view would show, given the fact that it's on the opposite side of the wall of this video, that actually would show the right rear portion of the SUV as it was parked in that Sally Port, would it not?
Yes, it would.
Let's take a look with the court's permission. This has already been marked as 446. I believe it was introduced last week.
Okay.
Can we display that?
Yes.
Thank you. I know it's very hard to see, Sergeant, but could you tell me, as the video is paused right here at the beginning of the timestamp, can you see the outline of the antique police car?
I can make that out, yes.
And it appears that there's no vehicle in the foreground this side of that antique police car, correct?
That's correct.
You also can see that this video is in fact not inverted. It's the correct orientation, right?
That's correct.
And obviously it's pretty lacking in quality, but you can make out the fact that there is an outline of a vehicle there, correct?
Correct.
We could play, may I approach the screen briefly?
Yes.
If we could, with the court's permission, begin playing at this time, this is about 5:07 and 10 seconds. That's time of day. We can play for about a little less than a minute.
Okay.
Sergeant, did you see what was depicted on the videos that just ran from 5:07 and a few seconds until it was just paused?
I did watch the video.
And how much time would you estimate elapsed as you just watched that video in real time?
15 seconds, maybe.
Okay. And do you see something? You see something in the foreground that just sort of appeared there next to that antique police car?
It appears that the SUV has now pulled into the Sally Port, and there's an individual standing behind the SUV.
And do you see what the time of day is on that timer?
I do not.
Can you see that it's paused at 5:50, 50, and 46
You notice that
seconds?
this
I
video
cannot.
is garbage now.
This is the last time I would ask unfortunately, I cannot zoom on this, Your Honor. With the court's permission, would the sergeant make one more trip to the screen to give us the exact time that this is paused?
This is the last time, Sergeant, would you please?
Thank you, Your Honor.
Thank you.
What was the time? What is the timestamp where the video is paused?
5:50:46.
5:50 and 46 p.m. Correct?
That's correct.
So it appears that this video in about 15 seconds jumps 42 minutes to the 5:50 mark. Correct?
I don't know how much it jumps.
Well, from 5:08 approximately to 5:50 approximately, how much time is that?
Approximately 48.
42 minutes, right?
Excuse me, 42. Yes.
That's okay. And this reads vehicle, which shows the right rear taillight portion just appears, correct? At 5:50.
There's a vehicle that appears. There appears to be an individual standing behind the vehicle. It's not just a taillight that appears.
But Sergeant, the exact time that would show what Trooper Proctor was doing at the right rear taillight, that is missing.
Objection.
Sustained.
The exact time that would show what the person who you identified on Wednesday as being Trooper Proctor, that video is not there, correct?
Objection.
Sustained.
This video, Sergeant, you will agree, if that 42-minute period existed, that would have been the only video that would establish the actual condition of the taillight the moment the SUV arrived in police custody in that Sally Port, correct?
Objection.
You can ask that differently.
Is there any other video other than this one that would show the exact condition of that taillight as it pulled in to the driveway, to the Sally Port? Or is this the only one?
From that location,
Correct.
that is the video that captures that time frame.
And that's also the video that captures that area of the car, correct? The right rear portion of the car.
Correct.
And that 42 minutes, from when the car arrived until 5:50 in the evening, that portion is missing, correct?
It's not missing. It's just not recorded.
It's not there, Sergeant Buchanan. I'm not splitting words with you, splitting hairs. It's not there. It's gone, correct?
It's not. It's not on the screen now.
It's not anywhere, is it?
I do not know.
That's all I have, Your Honor.
Okay.
Thank you, Your Honor.
Morning, Sergeant.
Good morning, sir.
So how this video was played before the jury on Wednesday during your direct testimony, the condition of that video, the view of that video, that's how you received it from the Canton Police Department, correct?
That's correct.
So nothing was done to alter it, change it in any way, shape, or form from when you received it to when it was played before the jury.
Objection.
Sustained. You can't leave, Mr. Lally.
What if anything was done to alter or change that video, received it to the time that it was played before the jury?
Objection.
Ask it differently one more time.
He has no idea what was done. But
As
something
far as
clearly
the
was
condition
done.
when you received it, and the condition when it was played for the jury, what was different?
There was no manipulation, alteration of the video between
I'll allow the answer.
when we received it from Canton Police Department, when I played it, and when it was played for you.
Now, as far as the cameras are motion activated, correct?
That's correct.
And as far as the skipping that you observed at various points of the video, was that something that occurred once or more than once?
More than once, repeatedly.
And was it one specific portion of the video? And by that, I mean, was it only at the beginning or only in the middle or only at the end, or was it sort of throughout?
It's consistently happening when there's lack of motion. The video does not record because it's not triggered to record.
How do you know that? You don't know that.
Now, from the video, at least as far as you've seen, the one that you were shown on Wednesday and the one that you were shown today, or the portions that you were shown today, what, if any, difference did you note between the content of what's contained in the video?
The content of the video is accurate depiction of what's taken place. The only difference that I noticed today is that the version played was actually inverted from the original version that I received and which was produced.
Your Honor, with the court's permission, I would ask that the entirety of that 5 minutes and 51 seconds of video be played for the jury.
Okay?
May I have one moment, Your Honor?
Yes.
The entirety of it. We're just going to sit here and watch a video. Darcy. Whoa, hold on here. Okay, in the Young Thug trial, apparently Judge Glanville is holding Steele in contempt. Like, is he getting arrested? Like, is he throwing him in the hoosegow? Damn. Also, I do want to say thank you for the super chat, Darcy. God, we're getting serious out there. We are getting serious. Oh my gosh, what did I just... Oh, that's why I heard stuff. The UPS guy was outside. Yeah. So, wow. Okay. Yeah. So it sounds like he might be getting arrested. We'll have to check up on that in a second. Let's see what's going on here, guys, real quick. The tubing of views. We're gonna check on this real quick. That's going on right now. All right, you guys, we're going to switch over to this real quick. Okay, somebody's being accused of influencing a witness. All right, here we go. Day 88, a Young Thug. That's kind of funny if you 14. We'll just leave it at that. We'll leave it at that, guys. So let's go here. Let's see what happens. We're going to catch up with this real quick, guys. This is the Young Thug trial. So if he's going to throw a guy in the jail, we're going to watch this. Bailiff is standing behind him. Oh, wow. But thank you, Darcy, for the super chat.
All right, do we have everybody with here? Sergeant Ingram?
Yes, sir. Everybody's present.
Okay, Mr. Steele, would you take the podium, please, sir? All right.
Okay, guys, this is a contempt hearing.
All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, I'm just.
But in order, you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, and that's
What? Oh, shit. Oh, wow. Wow. Apparently, he got information about a, he got info. This is Young Thug's lawyer, Brian Steele. This is Young Thug's lawyer right up there right now. It sounds like he got information privilege like from the judge's chambers.
That's why I raise it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
No.
How did
that is a very valid issue. The prosecution and a witness met with the judge. Oh, he has every right to know what that conversation was about.
How did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're saying, you're threatening me with
the
contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it, but if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not sure.
I don't want to hold you in contempt, but this is that serious,
Judge.
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. And I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody
parroted that information
Wow.
to you. So,
Wow.
but you're assuming something because I told you already.
Well, then,
I
other than
answer
if
that
you were
under
sitting,
attorney-client.
unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a.
What I got this information.
I'm not going to have any further conversation
Well,
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your I'm going to deny your motion. I'm going to deny your motion.
I understand.
This is a fucking G move, chat. This is a G move. Fucking G move right there, chat. That is a low-key flex. No, that's like dragging your dick in the dirt energy. Big dick energy right there. Wow. Fucking homie.
That you spoke with a
And
witness outside our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to.
You admit to having the ex parte conversation with the witness? You stupid fuck. Why would you? Well, I'm glad you admitted to it. But yes, mistrial. What? None of the defense knew about it. Ooh. Ooh. Wow. Look at this. He's getting cuffed up, chat.
Have that all in the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another
exclude
day.
In the first place? I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it supposedly.
The state wishes to be heard.
You said it supposedly.
Yes, John.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something or
maybe he's really freaking smart too. I don't know. But you have no idea. You need to go do your mole hunt, Glanville.
Ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information.
They were sworn.
So
Your Honor, but that's the issue, isn't it?
Well,
Why aren't we
I'll
entitled
let,
to the-
I'll, you know, that's,
But isn't that the
leads,
issue?
that needs to be, that
Yes,
needs to be
you're
told,
correct.
but.
But they,
do you
but
have
right
anything,
now, we don't know
Mr. Steele.
why we were excluded from that.
Mr.
And I
Steele,
want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right on the
Just stop.
Georgia Constitution.
Just stop at this point in time, because,
Article 1, Section 1,
because you did,
paragraph
you've
12.
already said that. You've already
The
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes. Madam, Ms. Lowe?
Oh, I'm sure she's gonna be all indignant now. This is so mean,
Your Honor.
Judge.
And
Defense
I
man
know I said
bad.
this previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh,
Ms. Lowe.
okay, excuse me.
Okay. All right. Yes,
Wait.
ma'am.
Your Honor,
Wait, he just threatened him with jail and he didn't jail him. He just threatened him with jail and he didn't jail the guy. He's like, I'm going to cuff you up. And then he didn't cuff him up. What the fuck? What? Like he threatened to cuff him up. The bailiff walked over and now the bailiff walked away. Glanville's all bark, man. What a G. What a G.
am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsels took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned We have observed a number of actions on the parts of a number of people that I am
including the
not
state.
comfortable stating publicly at this time, but that
You don't feel comfortable?
would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he
wait.
obtained the
There's
information.
nothing to strike. The jury's not around. He made his statements. If it's stricken from the record, like, you're going to erase that? It don't work that way.
That was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested.
We're going to have to cover this Thursday, guys. Holy
1.6
cow.
has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Now, here's the difference, guys. This is Rule 1.6 for the Georgia Rules of Professional Conduct, okay? So he said comment 5. The principle of confidentiality is given effect to two related bodies of law. So right here, you guys should be able to read that. Okay. So we get down to the rule of attorney-client privilege and attorney-client confidentiality applies to situations other than those where the evidence is sought from the lawyer through the compulsion of law. 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. A lawyer may not disclose such information except as authorized or required to by the Georgia Rules of Professional Conduct or other law. The requirement to maintain confidentiality of information gained in a professional relationship applies to government lawyers who may disagree with the client's policy goals. Steele got it on the money. Steele's got it right, chat. Steele's got it right. Man, Steele's got ice water in his veins. Freaking OG move right here.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained
Okay.
from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but
Damn! Wow, this dude's like, yeah, Adams. My God, he just stood there and he's like, "Listen, if you're going after my homie, you better come after me." Like, these guys are straight up savages, chat. Straight up savage. That's a savage move. Knowing your buddy's gonna get lit up, and you're like, fuck it. You know what, Judge? You know what? I'm gonna lace up my boots too. I brought a toothbrush. You're gonna have to take me down as well. Man, that's some baller shit. This is OG stuff right here, chat. Fuck, if I am ever in that situation, I hope I fucking man up too. I hope I man the fuck up. I mean, really, I hope at that point I fucking step up like that. I hope I could step up like that.
I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not.
Now, this is interesting. He needs to be up. Now, I think they were smart enough they could use him and say, I don't know what you guys did. Now I have the right to know what you did. Now he's able to say, I got clean hands, Judge. So you tell me what the fuck you done.
Not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this may have also, this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations.
We'll get to
But I
this
do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, are you same thing? You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the same.
All right.
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr.
All these guys are stepping
Okay.
up.
We are also adopting all the arguments.
Gangsters,
All right,
one and
sir.
all.
Still by Attorney Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also are, we were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an communication that was had, that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. T. Williams? All right, thank you, madam. Motion's denied. Mr. Garner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
He's really going to do it?
Yeah, we're going to continue. I'm not caught nothing.
I'm not going to participate in the trial without the Steele.
You don't have that luxury at this point in time, sir. You don't. You don't.
This guy here, I don't know his name, but he is awesome. Brian Steele's got a set of balls, but this guy he's standing up in front of the machine gun and screaming, "Hey, shoot at me too." That I think is a bigger set. That's a big set of balls too. He says, "I'm not going if you take him away." Like he's like, it's like backdraft. You go, like, you know, you go, we go type of moment. You know, if you go, I go. And I don't blame him, but it's funny. He's like, I had the same information too, and the judge is like, I don't fucking care about you, which I think shows bias. But holy shit.
You don't have that luxury. You don't have that luxury at this point in time. You don't. Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again? Respectfully, I will not. I cannot. Sir, you have to. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are.
That is not extortion. That is not extortion. Holding you out for what you've done that's violated the rules is not extortion.
What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that. If there is any accuracy to some of the information that we. But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been. And the only
okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Now he's doing it the right way. When they say cuff up, it's cuff up time, chat. There ain't no time to fight. You take it like you take your. This is a great example of it. You take your fucking pinch like a man, and Brian Steele's taking his pinch like a man. Fucking baller. Fucking baller. We'll get to your guys' questions. We'll get to your questions.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of
Okay, all right.
Wow, chat.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Fucking A. Like a champ, chat.
We're going to be in recess for the next 5 minutes.
This is an OG call. Who lad? Who lad? All right, we're 17 minutes behind. We're going to catch back up. Here we go. We're going to catch up, guys, here. Here we go. Now we're almost live. I got to change the title.
Is Mr. Adams in the hallway over there? Could you get him, please?
Chat, this is insane. This is insane. It never goes this far. It never goes this far. Wow. Man, like I said, when it comes my turn to do that, welcome back to the page of history. You got to be that dude, man. You got to be that dude.
He's refusing to come in. Is he refusing to come in?
Wait.
Tell Mr. Adams to come inside and put some stuff on the record, please.
Also, if you guys were not aware, he is Brigadier General Glanville in the U.S. Army Reserve. He is a JAG officer, Judge Advocate General officer. So, pretty interesting. Let's see where we're at here. Come on, they're getting ready.
Justice Adams is present.
Just hang tight, sir.
So what are we doing? Come on now. Let's get to it. Judge Glanville, I'm putting together this thumbnail for you, buddy. You better not leave me. You better not blue ball us. Although Brian Steele's playing it right, man. That, as we talked about. So if you guys are not aware, in the Young Thug trial, and we'll start off with that, because Young Thug's got his RICO trial going, and we're going to mute it for a second. In the Young Thug trial, one of the witnesses refused to testify on Friday. He came in today and agreed to testify. At some point, Young Thug's attorney, Brian Steele, learned of information that the judge, the district attorney, And this witness all talked without anybody else present. That's an ex parte communication. What happened from there? Well, at that point, Brian Steele learned of the conversation. He's Young Thug's actual attorney. Now, it doesn't, the witness was not sympathetic to the state, and he'd already been sworn in. It's pretty clear how he got the information this meeting happened was the witness told Brian Steele, the word got to Brian Steele from this witness, hey, the judge basically told me to go testify. Oh, we're back talking now. Okay. All right, hold on. So real quick, we're going to pause. So with all that being said, the judge's first reaction to getting caught having an ex parte communication wasn't, you're right, that was wrong. It was, who told you about it? He was more mad at the fact he got outed than what he did. Brian Steele, under the threat of contempt, refused to tell him. And why? Because of the rules of professional conduct in Georgia, it's specifically Rule 1.6, Comment 5, this one right here. It says, this applies to not matters implicated in confidence by the client, but also information gained in the relationship, whatever its source. So Brian Steele is saying, I have no ability to tell you what are the rules of professional conduct. The Rule 1.6 is the one you take all the way. You don't ever breach it. And there may be times where you have to, but this isn't one of them. And the judge said, tell me you're going to jail. And Brian Steele says, fuck you. I want a mistrial. The judge said, fuck you. We're not doing that. Well, Brian Steele said, guess what? He's like, fuck you. I'm not, fuck you. And he pulled a Nick Ricada, except this is justified. Fuck you. I'm not going to do what you tell me. And he did it like a fucking G. He asked for a mistrial. All defense counsel asked for a mistrial. And it's funny because Keith Adams, Young Thug has two attorneys, Keith Adams and Brian Steele. Keith Adams stood up and said, Judge, I have that same information too. So therefore, you'd better hold me in contempt as well. That guy stood up in the line of fire and was standing there screaming, I dare you to shoot at me. And Judge Glanville said, no, I'm not shooting at you. Only Brian Steele. After that all happened, after the state got to have their say, Brian Steele once again asked for a mistrial. Judge said, are you going to tell me? And he said, nope. And the judge just had him escorted in the back. That's where we are. That's where we are, guys. And that's why we're doing this right now instead of Karen Reed. Holy Jesus Christ on a cracker. That was intense. That was intense. The judge got felted? Yeah. Brian Steele says, I got more push than you got time. And Brian Steele fucking cuffed up and went in the back. It's an OG call, man. That's an OG call. Like I said, I hope I'm in that position. I never want to be in that position, but if I'm ever in that position, I hope I fucking do it just like that. All right, Judge, I'll see you in the back. Now, I might say, I'm a little fat myself. I'll be like, do I get a lunch tray? Do I get a dinner tray? The accusation is the judge tampered with the witness. They had an ex parte communication. And this was after the guy was already sworn in to testify, because he was sworn in on Friday and refused to testify. You can't do that with a sworn witness. And nobody in the defense knew about it. Yeah, Steele falls asleep listening to Annie Up. Like a real G. Yes, he did. Oh, my God. Have you ever been cuffed before? Like when I got a DUI, I got cuffed. But no, not in court. No. I generally play it by the rules. But I've never been in a situation like that. The judge has fucked this case up. Because he admits he did it. He admits he did it. I've heard of lawyers going into custody at the end of the day, never during it. Yeah, normally it doesn't happen. Normally it doesn't happen. Well, he's not going to the jail. He's going to be held in one of the holding cells in the courthouse. They're not taking him all the way over to the jail. But let's hear what happens. Let's hear what happens, guys. And if they get on with the trial, we'll go back to Karen Reed. This trial is done. That is reversible error. It is structural error. This trial is completely fucked now. This judge fucked away 88 days of trial.
All right. Mr. Adams, let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and you have done more than a yeoman's job of representing Mr. Williams. And I don't doubt that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. And an appellate court will review my decision for abuse of discretion. So I'm going to direct that you continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you to do that and continue to do that. But Mr. Steele put himself in this particular position in terms of all these. I'm not asking for any other, or you for any other information that might be privileged or any other conversations, but I need to know who told you, because that then drives other things the court needs to probably do. So he's the reason as to why we're here in this particular circumstance. So if you or he or want to disclose to me who told you that, I'll be more than happy to reconsider.
I know Mrs. Steele will not. I also will not. And I respect this court. I respect that the court has to do whatever it is appropriate. But I would ask that the court also respect my representation of Mr. Williams and standing for him when we believe that there's been a violation that affects his right to a free trial. And we believe that that's the position that we're in. And I would respectfully decline the court's order of continue forward.
Your Honor, may I address the court? Thank you. Your Honor, there are two things at issue here. And one of them, Your Honor, is that...
Can I ask from the court how it is that the state has any position in this particular conversation between the court and myself?
Before we recess, Ms. Love said that she was going to research this ethical issue because it is an ethical one. So just much like you could add to it, I'm asking the state if they wish to add to that as well, sir. Okay?
Thank you, Your Honor. Your Honor, we believe...
Researching the ethical issue. You're not allowed to have ex parte communications. There is no, research into this. There is no research. You can't do this. This is not acceptable. It's not. You can't do this. There is no research into this. You're not going to find somewhere that says it's okay for you guys to have an ex parte communication with a sworn witness without notifying defense counsel. No. And the fact they found out, that doesn't excuse what you've done. You could find out on later words, but you need to address the fact you introduced error into this trial for the millionth time. No. This is insane.
That there are two matters at issue here. One, obviously, is Mr. Williams' right to counsel of his choice during the trial of the case.
Yes.
We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not.
They know this is bad. They know this is really, 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 really bad. They're like, Judge, what? They're like, Judge, whoa, whoa, whoa. They're like, pull the bullets out of the gun, Judge. No. They're like, no, don't. They're like screaming at him like, Hank, no, Hank, don't do it, Hank. They're screaming at him, don't do it. They're trying to fix. They are trying to pull bullets out of a dead body right now. And I don't think they realize he's dead.
Affect his ability to have his counsel of choice represent him during this trial. We believe that it will need that. So far, this issue alone has needlessly delayed the trial of the case, and we believe that it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask that the court, notwithstanding the finding of contempt, allow both Mr. Williams, Mr. Steele, and Mr. Adams to be present while these proceedings are going on and while court is in session. Physically.
I think that would be appropriate under the circumstances. And Mr. Steele, certainly I can inquire about before the end of the day if he wishes to disclose that information that I've asked him, then he certainly purges himself of that contempt. So yes, that's fine. We'll go ahead and do that.
And the second thing that I wanted to put on the record is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may finish.
Bullshit. How do we know that? How do we know that? Oh, we promised we didn't do nothing wrong. Yeah, that ain't how this works. That ain't how this works now. The fact you get caught doesn't mean you get to come back and say, well, we didn't do nothing. No, that's not how this works. Especially not with you guys.
The matter that the state requested an ex parte audience with the court regarding was a matter to which no one to my right was a party. It was a civil contempt matter, and the parties towards that civil contempt, the state, which moved the court to compel someone to do a thing.
That's not how this works. You don't get to say that.
And the state said, Your Honor, we're asking if the court, if they don't comply, that the court hold that person in contempt. That was a civil contempt
you
matter.
don't get to do that.
Nothing substantive was discussed.
You don't get to do that.
Everything was recorded, and
sorry,
the
baby girl,
representations made, at least by persons who were present
according to you,
the state, is that
baby girl,
when questioned or queried about it, is that that person was told or asked whether things occurred, and that person relayed that no substantive communication took place during that meeting.
You don't get to decide
so
this.
That is the second matter.
You don't get to decide that.
First and foremost, we just ask that the court again allow both counsels for Mr. Williams to be present when court is in session so that we don't delay these proceedings further.
All right. That's fair enough.
Thank you.
Okay.
Your Honor,
Mr. Sharp?
the ability for the state to paint themselves as the victim constantly in these matters is unbelievable. We are the aggrieved party.
Sir, we can't hear you.
My client, Shannon Stillwell, and these other young men sitting here as defendants are the aggrieved parties. We were not present. I would like to reiterate.
But here's the problem. Here's the
Your Honor, can I just
Mr. Sharp. Here's the challenge. You got the information in a way that was not lawful to begin with. Sir, that doesn't alleviate the information or make it less valid or invalid.
How is it unlawful? How is it unlawful? They gain knowledge of unethical conduct. It's not unlawful. For you to sit here and say it's unlawful, your conduct is unethical. You're not entitled to hide your unethical conduct.
Valid. So, because we record these conversations so that they can be reviewed later. We didn't have any conversations that were not recorded. And if you heard of other conversations that were made, I don't know how you would have gotten them otherwise, because somebody had to tell you.
Okay, well, all that's
And like I said,
this is what I
when
know.
if and when the case gets reviewed, an appellate court will make those decisions. But at this point,
My client is the aggrieved party. He was not present. If that violated his Sixth Amendment right to be present.
okay, and that's your argument, sir. That's your argument. That's your argument.
One other thing, Your Honor.
That's your argument.
All I'm asking for is some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not sun. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that's the sum and substance of it.
We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Okay. Well,
So
at this point, I'm like I said, I need to have a little bit more information in order for me to kind of make some other decisions in this case. I'm not saying that you may or may not get that information, but at this point, there was nothing that was improper about in the ex parte conversations. The court's more concerned about is the disclosure.
You don't get to say that.
So, and
I understand the court's concern, but as the counsel for Mr. Stillwell, my concern is the meeting that he was not allowed to be present for.
okay, all right. Thank you, sir. Are you going to repeat the same thing again? Oh, let's try not to, because the Harvey rule's in effect. I understand everyone's opinion at this point in time.
The only thing I want to say, and to not be repetitive, but on Friday, Your Honor, this particular witness came in, he pled the fifth, his lawyer was present, his lawyer stated to Your Honor that he had spoken to his witness, his client, and
hold on,
he
guys.
stated that the witness indicated
Right now,
on
buddy.
Monday, he will
You want to
also
airdrop
be
in?
saying that he will plead the fifth. And then, Your Honor,
There you go,
was a
Steve.
2-3
Coming
hour
hot, man.
span
Cleared
this
hot.
morning, and then he comes on and he says,
That's what you
I'm
are,
gonna
guys.
testify.
Cleared hot.
That's why I believe in the application of Huey that the transcript is important.
Okay. Thank you, sir. All right. Let's get Mr. Steele out, please. You can tell him to put his tie back on.
I'll talk about that real quick, guys. We'll talk about that real quick. Then we'll get back to Karen Reed, because it looks like they're going back.
And then we'll go ahead and get started at that point in time.
Steve, hi.
Boy, did I come in at the right time.
Wow. Okay, guys. And guys, the extraordinary and well-esteemed Steve Gosney, a attorney out of the state of Florida, actually been both sides of the fence, but as a prosecutor and public defender, and a guy with a lot of insight and input I value a lot. Thanks for being here, Steve.
Well, thanks. I saw your screenshot and I was like, what? Who's being held in contempt? And then I let the lady lay it on me.
Okay, so here's what happened. So Young Thug, he's got his trial going, right? Okay, so Young Thug's got two attorneys, Brian Steele and another guy, Keith Adams. As part of this trial, obviously it's gangsters and guys in a gang. Well, one of the guys that was called in to testify on Friday was one of the gang members. And he's like, nah, I ain't doing that. And they immunized him. And he said, yeah, I'm still not testifying. So obviously, you know the answer to that after you've been given immunity. You go sit in the back. So he sat for the weekend. They brought him out this morning and he decided he was going to testify. Well, around the lunch hour, Young Thug's attorney, Brian Steele, came out and said, "Hey, Judge, I know y'all had an ex parte communication with this witness who's already been sworn under oath, because he came in and sat down and said, 'I'm not talking.'" And they put him in the back. Now, that's already a problem, because once the witness is sworn, nobody's allowed to talk to him.
Even his attorney.
Yeah,
So
even his
once,
attorney.
and let's be clear what we're talking about. Somebody swears in, they're sworn, they're put on the witness stand.
Yeah.
The person can say, "Hey, can I take a break and talk to my attorney about the answer to that question?" The answer to that is no.
No.
So so what's happened is he is sworn in, he takes the fifth, and then the attorney, they give him immunity. Now there's some questions about federal
Yes,
stuff.
and
but
there's an issue with that. With the
there's an issue with that, but let's assume that
Let's
his
assume it's
immunity
all
is good.
Yeah.
Then the judge talked to the witness.
Yes. And the
Now,
judge's first answer and the judge's first response to that was, "How did you know?"
Right. How did you find that out?
How did you figure it out? Now, I think it's very likely the answer is the witness is very sympathetic to Young Thug, and through either his counsel, which, that guy's playing with fire if he did that, but somebody in that guy's camp reached out to Young Thug's people and said, "By the way, this happened this morning."
Well, there should be there's so many ways to go with this, but the first thing I would do as a defense counsel would be file an interlocutory appeal, demanding a disqualification of that judge and a mistrial based on the allegation of contact. Now, you may need sworn testimony for that, so the source of that information may come out.
Yeah, but you don't need it though, because the state already explained what it was about. The state admits it happened.
Okay, well, the state admits it has, so that the state's that's mistrial. That should be a mistrial. That is
now the
state's
argument is because it was a civil contempt matter with this party, that technically they're the only. Now, I understand you're going to say this is a bullshit argument. I agree. But they made the argument just now, well, because it was our contempt, we're the victim. It only concerns us.
No, because you don't know what's being. There's ex parte.
Well, yes. Oh, yeah. No, that's and that's the counterpoint is we don't know what you guys said.
And the witness
is
sworn, and they're on the stand.
Yes. But their argument was that because that contempt was hurting us, we're the only victim. You guys really don't have standing. It didn't matter that you weren't there. And it's like, no, that's not how that works.
No, this is
the
terrible.
state admitted they just did that.
Yeah,
so
it's terrible.
There's no need. There's no need to mess with the record because they just admitted they did it. And it's like, well,
I would immediately ask for an interlocutory appeal. What jurisdiction is this?
This is Fulton County, Georgia.
Oh, wonderful.
So this is
Fannie Willis country.
Yeah, and the funny thing is, I've been saying this for a while now. This is a preview for the Trump trial. It's probably going to go this good.
But the thing is I'm not following this at all because I know Nick Starro is following it very closely.
It's a dumpster fire of a trial.
And I hear it's going to be like months and months and months and months. And whenever I hear a trial's going on months and months and months, there's something wrong with either the judge or the prosecutor or both.
Well, it's because it's a RICO case, and the problem is
I've tried RICO cases before.
Yes, and this is the problem. It's because these guys suck. But the other issue is in Georgia, the way RICO's set up. It's the same reason why Trump's being charged with it. RICO is if two people commit a crime. That's RICO. Not necessarily like an organized pattern of criminal activity, and you can organize a hierarchy and there's predicates. It's two people committing a crime. That's RICO.
What? No, that's not RICO. Not in Florida.
It is under their law.
Well, that's weird law. In Florida, the way it works, RICO is the Racketeering, Influence, and Corrupt Practices Act, and it's organizations as well.
Yeah, you have a hierarchy, and you can
you have to have two predicate felonies that support an organized crime.
Yeah, And they do have some of that. Their allegations are there was like a murder and these guys were running wild back in like the early 20.
Now, are you saying
14s.
that's not the way it is? Is that the way the statute's written, or is it
That's the way
just
the way the statute's written is basically if two people commit a crime, it can be
that's
RICO.
just conspiracy.
Yeah, well, I mean, at the end of the day, RICO is also just a conspiracy.
Well, but it's multiple felonies in furtherance of a larger organized system.
Yeah, but when I try to explain to people, it's always just think of RICO as an elaborate conspiracy with an actual hierarchy.
Yeah, but it still should not take
it shouldn't.
months and months and months to try a case like this.
Mm-hmm.
How many defendants are there?
There were 19. Well, there were 23. 5 have pled out. There are 5 or 6 that went their own way, and this is like the remainder of the bunch, including Young Thug and all the bigger guys.
They shouldn't. I also really think the state gets a little overly aggressive by joining defendants.
Yeah.
There's so many problems with that.
Well, here's the problem too. We're 88 days in, and the case started in November.
It's ridiculous. The judge needs to. I mean, I went back because I saw your headline, and I went back and I watched the contempt proceeding.
Yeah,
and that was garbage. And I'll say that let's just talk about how the mechanism that works. There will be defense attorneys posting bond for him immediately. All right. So, he'll spend maybe a few hours going through the system.
He's coming back out because the judges, I don't know if you saw the part here where I was explaining the state's they're like, wait, judge, he might actually have the right to counsel here.
Yes, well, see, this is the thing. This is a denial of counsel. If you take his attorney out, you have a right to counsel. He's hired his attorney. Now you've taken that person out of the courtroom, and then you're going to conduct material proceedings without that guy's lawyer. Now you've just deprived him. The judge could get kicked off the bench for that. I've seen judges get kicked off the bench for that in Florida. Down, let me see, both in Putnam County, Florida, which is my jurisdiction, and in Melbourne, Florida. Do you remember that Melbourne, Florida case where the everybody remember the public defender wasn't agreeing to any speedy trial waivers, and he's like, I'm not agreeing, and the judge held him contempt and went back and hit the public defender, and then came back and conducted proceedings. Did you remember that case?
I've heard of it.
Yeah, well, the public he didn't get the judge didn't get the boot for hitting the public defender, sucker punching him from behind. No. He got kicked off the bench for holding hearings without a defense attorney there.
Yeah. Well, and here's the thing. He has, and his Young Thug has 2 attorneys, actually. And his co-counsel stood up, and I thought this was really the epic move. He said, Your Honor, I have the same information as well. I dare you to do this to me, too.
Oh, this is the thing.
And the judge said, no, I don't want you.
This is defense attorney hero time. If I think they should all go right down the line and say, and me too, and I'm Spartacus, and I'm Spartacus.
Yeah. Well, I just thought that was epic that his dude went down there like that and was like, yeah, me too.
Well, this is why it takes balls of steel to be a defense attorney, because this is what you got to be ready to do. When that judge is wrong and you're right, and you've got your client, they were respectful. There was no curse words. There was no loud voices. There was nothing else. They just laid it out factually, and the judge didn't like it. Too bad, Judge. Their job is to stand up when everybody in the world is yelling at them to sit down, to keep standing up and keep fighting. And I fully salute the defense attorneys for going.
Oh, I do too, man. That was some gangster stuff. And I was saying it. If I'm ever in that position, man, I hope I'm half as brave as those guys were. Just saying, fine, cuff me up.
I was in that position. Let's see, I don't want to promote my book, but the trial in the trial in the latest book was based on a real trial that I was part of, in which they had teams of defense attorneys. They thought that I was going to be held in contempt every day of that trial. For 4 days, I was on the firing line, and the judge hated me, the prosecutor hated me, and I was ready to go. But the thing is that, see what this judge was at. The judge was out of line. I watched what he was doing. He just didn't like the defense attorney's accusation. Well, too bad.
Yeah, and like I said, I love his answer. The first answer was, "How did you figure that out?" Not
right.
You caught me.
No, and that's an admission of guilt. That judge should be out.
Oh yeah. Oh, he admitted it. He admitted to having the hearing too.
Huh?
He admitted to having it as well.
Yeah.
He
ridiculous.
100% admitted having it. And I'm like, well, there you go.
Well, they should move to disqualify the judge. They should they should interlocutory appeal, demanding mistrial, a lot of stuff now. And if it's funny because it seems like the judge came back and let him back out. So he's seeing the denial of counsel problem, thankfully.
Yeah.
Maybe he's grown a brain.
Well,
but there is you remove the guy's trial counsel and then you say, now keep going. That the judge could lose his seat for that. In a functioning bar. I don't know if Georgia's bar is how good they are with that stuff, but
yeah, well, I think the funnier part was the state sitting up there like almost begging the judge, like, no, don't pull the bullets out of his body. Noticing they caused the problem here. And it's just something to see. I mean, he took off his tie. It's like, fine, I'll go in the back. I know in Ohio, for example, if you remember the criminal defense bar, they have this thing called the strike force, and other states have it too, where there's attorneys who they get the call and like their wheels up coming to help because it's hard to fight this from behind bars.
Oh,
now,
yeah.
some of you guys are wondering what's going to happen to him. So here's what's going to happen. The way contempt works, and some people were wondering, and we got a bunch of questions here. And once again, thank you to Darcy for telling me about this over an hour ago. You demand, Darcy. And Miko says it's an ex parte and one president is present, not the other. Yes,
Correct.
That's the definition.
Well, ex parte means you're meeting with somebody without the knowledge of like outside the courtroom. So they're meeting behind the curtain. And the defense attorney, so the judge and the prosecutor are meeting with a witness on the stand and without the defense attorney present. That's
None of the
insane.
defense attorneys for the other 13 people either. Nobody knew about it.
Disqualified himself.
EDW says that was a game of chicken. The judge was playing and he lost. Well, yeah.
Well, we'll see.
Brian still threw down a punk card and made him pick it up.
Maybe. I mean, this is I'm glad we have cameras in the courtroom, but you don't know. I mean, it could keep rolling along. The appellate court could say no.
Well, this part here, I think Brian Steele is correct on because this is the Georgia rules of professional conduct, and this is 1.6 comment 5. And I don't know about Florida's, but I've never had this conflict. I've never had this ethical issue before, but
I have.
Well, I've kind of run into it, but nobody ever thought to ask me like, how do I have the information I have? So
that to me is terrible. How did you find? Like, no, I didn't do it. How did you find out?
Yeah, well, but I've had it where I can say things, and I'm like, nobody asked me a question. I'm just like, I'm not going to raise it. I'm not going to bring it up. That's their fault. But yes, it applies to matters in confidence by the client, but also information gained, whatever the source, because that's meant to help your client, guys. That's why he did that. It's my job.
As from a defense attorney perspective, this type of action is a real badge of honor. And I will say that you went to war and you were ready to go to jail for your client.
A lot of attorneys. I don't know if a lot of attorneys have backed down, but I don't know if there's a lot of attorneys who would have raised hell like he did, though.
Good for him.
Yeah,
you got to be.
Brian Steele's an accomplished attorney down in that area, but he got extra stripes today for that.
And the client, what I'm saying is, it's good for business because clients want you to fight for them. And if you're not willing to go to the wall, if you're willing to get cowed by a judge and say, "Okay, Your Honor, I'll just shut up and sit down," then you are not. That's what it takes. That's the balls it takes. And people like to diss us defense attorneys, but you got to be ready to go.
Yeah.
Right?
Yeah. And Squizgar says, how do they fit those balls behind the podium? I don't know. And EDW Raptor says, so is the judge and the prosecutor more or less committing a RICO violation themselves?
Yeah. No, not really. I understand.
They're doing highly sanctionable conduct, which they should be sanctioned for.
Both. Yeah. Well,
the prosecutor too, because they know better as well.
Do they?
They were trying to make that argument of like, well, we're the victims in our contempt. It's like, it's not going to work.
No victims here. That's not the question.
Yeah. Well, no, that's how they justify. Well, the state came out and justified why they had the contempt or why they had the ex parte. Like, you guys didn't have to know because it didn't concern you.
Yeah, trust me.
And it's like, no, the confrontation of a witness does concern us. Reformed Convict says they should release a
Hold on a
transcript.
second, I'm sorry.
They're going to have to come out. Oh, yeah. Sorry, Steve. And what are the options for oversight? Appellate courts. That's the only option. It's the only option. Other than that, like filing an appeal is the only way that takes care of it. Here's the neat thing. These types of like contempts, the appellate courts almost instantly decide, because otherwise Brian Steele could be sitting in jail for a couple of days. And right now he's already been forcibly detained. A court of appeals would hear this like RFN, like it's coming through the door on fire. Yeah, Sula says, get Barnes. Yeah, right. You bet on Barnes, I guess. The DA researched ethics and found out exist. Yeah. And Stop Boss B says we investigated ourselves and found we didn't do nothing. It's kind of what we're looking at right now. EDW says if we are wrong, the appellate court will tell us after the damage has already been done. And that's the part I hate when judges and courts and prosecutors do that. Well, if we're wrong, the appellate court will tell us. Why don't we make sure we do it right the first time? Well, it's like horrible crap. Unhung, can we get a replay? Well, we'll get a replay later because we got to get back to Karen Reed. Apparently it got good after a while. Fedigator says, will that attorney get a bond hearing? No, the way contempt works is, to start off with, the judge is going to bring him back, and before the end of the day, he's going to say, will you tell me who did it? Brian Steele's going to say no. So he's given an attempt to he's given a chance to purge his contempt. And then from there, yes, he would ask to have a bond, but like the judge say, well, I'm holding you in contempt, and Brian's going to ask for a bond. And the judge, I could see Judge Glanville trying to deny him bond and holding him in contempt till tomorrow morning. And then bring him in tomorrow morning. Mr. Steele, are you ready to go? What's the deal? Now, I really hope Judge Glanville wouldn't do that. It would release him and just every day sanction him, but who knows? Who knows? Who knows what's going to happen? And the only reason why I bring that up is because this is going to destroy Young Thug's ability to have a defense if his attorney is like stuck in a cell every night. And that's a shame, saying the look on Young Thug's face as Steele walked out of the courtroom was pure hard eyes. I think he realized, like, there goes a true homie. Like, that guy's a G. Lois says, who do we think the source is? The source is the witness. The source is the witness. The source is the witness because the witness is friends with Young Thug. He didn't want to testify. I mean, that's the only thing that makes sense. Otherwise, it's not the prosecutor. It's not the judge. So. Arctic saying Steele's going to get an word pass from his client for this. Yeah. But yes, guys, this will be, well, it's not investigated, but the appeal, somebody will help him file an appeal because now he's got action. He's got rights, and he has the right to immediately be heard on this matter. And that means going to an appellate court. Is this grounds for mistrial? Oh, we are already there. Speaking with a witness who's already been sworn in an ex parte manner like that. Yeah. Mistrial, structural error, reversible error. Boom, boom, boom. This is dead. This is a DOA case. There's no way to fix that. There's no way to fix that. If the judge had been able to get Steele to admit the witness was the source, what kind of penalty could the witness have suffered? Yeah, more contempt. More importantly, the issue there is Brian Steele could get sanctioned by the Georgia bar for violating Rule 1.6. Because now he's violated a rule of ethics. And you could be in trouble for that. So Brian Steele could have gotten in trouble. Robert saying, what happened to the Karen Reed trial? Well, we had to stop because watching an attorney get hauled off into jail doesn't happen every day. We had to stop and watch that. So my apologies there. Alex says, when do we go from standard mistrial to the prejudiced one? I think this is because the state voluntarily committed this error. The state voluntarily decided to have this meeting, that this is dismissal with prejudice. I'd argue there's prosecutorial misconduct here. They knew better. They did it anyway. The court committed misconduct. It's all done. It's all done. Arctic saying, even if they release the transcripts, there is nothing at issue. That couldn't fix it? No, it's too late. It's too late. We don't allow this. You're not allowed to break the rules and say, well, it turns out like that. You can't harmless error your way out of this one, chat. You can't harmless error your way out of it. Arctic, this is a good question, though. This is a very good question. No, it's done. The state and the court went behind everybody's back. Nope, done. Done. Shut it down. Too late. That's not how we do this. That's it. Bella's bringing up an interesting issue. Did the witness set this up? Oh my God. That. Wow. These motherfuckers are smart. Yes, but I guess, I mean, like, these guys are crooks. I mean, could they be this bright? Maybe. Maybe. That's fucking brilliant. That's brilliant. That's brilliant. I could see that. I could see that. That's some Lincoln lawyer shit. Yeah, that's also you could lose your law license shit. Oof. That's some Musashi, like killing somebody with a wooden sword. Or even just, you know, like Fushida said before they went to Midway. You know, one touch of an armored sleeve. That's the lawyer could set it up. That, you know what though? Here's the problem though. That's a dangerous gambit as an attorney. I mean, here's what I wouldn't, if that was proposed to me, I would not set that up. Now, if my clients did all that and other people are doing shit, what do I know? But that is a dangerous game as an attorney to play. That's a dangerous game. The witness lawyer was in on it. I doubt it. Kenny says, how can the witness be held in contempt if he pleads a fifth? Because he's been immunized. The state immunized him from any use of his testimony. Now, there's some issue that his immunity wasn't granted at the federal level as well by the U.S. Attorney's Office. But even then, if you're immunized, the idea is, well, now you have no longer anything to fear. Nothing can be used against you. Well, people still get held in contempt because now they're refusing court orders and now they're refusing an order to testify. Bella saying repeat criminals get a higher degree of criminality in prison. Sure, but that's some levels of thinking. Steve, did you hear this idea by Bella here? This is brilliant. This is brilliant about because we're trying to figure out how it came through. And I think the witness told the defense or got word out to the defense this happened.
Oh, probably. Or I'll jump in, not having heard anything you said for the last 5 minutes. But another possibility, and I will tell you, you know, there are good cops out there.
Yeah.
And there's bailiffs and there's relationships. And, you know, if there could be bailiffs that wouldn't assist.
Maybe.
Could whisper. It's like, hey, did you know what? Did you see that the judge did this?
Yeah, and this is something Zaven asked, and I thought it was an important answer. If Brian Steele had told, he could get disciplined for violating Rule 1.6. And if you violate Rule 1.6 and they get mad at, like the bar gets mad at you for that, you like that is a cardinal sin. So him talking, he could have been in trouble. So he wasn't just worrying about his client, he was worried about himself. But where is this one here? Yeah, Bella said this here. Mistrial with prejudice. I think so, because it's judicial and prosecutorial misconduct.
Well, let's talk about that, because it has to be prosecutorial misconduct.
Oh, I think it's both.
Yeah, it could, it's possible. It's possible. That's a very high bar to do. It's possible, though, because the prosecutor was in on the conversation. Now, is that significant enough to bar a retrial? Because what we're talking about is double jeopardy.
Yes.
So if a mistrial is caused by the defense attorney, then they can retry it. But if the mistrial is caused by the state, then they've sworn the jury, and that means that jeopardy has attached. And the state does something sleazy to cause a mistrial, that can potentially result in a bar, and that would be immediately appealable, because it would be so let's say there was a mistrial granted based on prosecutorial misconduct.
Yes.
Then you would bring that immediately, because that would mean double jeopardy would bar it. It would be constitutionally.
Yes. Oh, I agree. And the state would appeal it. But this is interesting here. Bella's saying it. Now, I know these guys are crooks, and they probably are savvy. But the idea is, did they set this up? Do you think the witness, the witness,
is pretty sophisticated to set up?
I mean, that's even sophisticated for attorneys to set.
Yeah, I doubt it.
But I mean, they could.
Why would the judge fall for it?
Glanville has made a lot of bad decisions in this trial so far.
Yeah.
He's done a lot of weird stuff. Yes, one touch of the iron gauntlet. Well, as they say in Japan, it was one touch of an armored sleeve. So that's what the Japanese said before they set out for Midway, and it didn't work out so well for them.
No.
But EDW saying they kept referring to the leak as possibly being a she. I believe the witness is male, so it could be the witness's lawyer. Maybe, but that's a dangerous game for an attorney to play like that, leaking that information. Because it's one thing to leak it, but if you thought unethical conduct has happened, you should be coming out and making it known to everybody in court. Like, Your Honor, I need to raise this issue.
I don't know. It's very hard to speculate, because we don't know what was said, what was heard, what was communicated.
Sure, and that's,
there's so many moving parts here. But the focus on what the issue is. The issue is the witness is sworn and on the stand, and the judge and the prosecutor are meeting with that witness and communicating with that witness without the defense attorney present. I mean, to me, that's all. It's over. You need to declare a mistrial and start again and try to pick up the pieces.
I agree. Well, I mean, this is a preview of the Trump trial. This is
Trump. I gotta say, Trump. Everybody asked me about my legal opinion on the Trump stuff. That's not legal. What's going on? It is a farce. It's a political persecution. Law does not apply.
And Lois is saying they should release a transcript. Lois, here's the problem. Releasing the transcript does not fix anything.
No.
Releasing the transcript, we just find out, okay, well, it wasn't a big deal. Well, if it wasn't a big deal, you guys threw the attorney in jail for no big deal.
And was there a transcript?
Yeah. Well, the judge is saying apparently there was. It was transcribed or recorded.
Which is even worse.
Yes, because they knew they were preserving the record.
What, you're creating a record without the defense attorney?
Well, that's what I mean. Like, you're saving a record, and
what possible motivation would there be?
And I agree, that shows further knowledge that you shouldn't be doing this, because now they're trying to cover their ass, saying, "Look, we did nothing wrong," but the fact you did that shows you knew you did something you shouldn't have done.
Well, and of course, I'm not a Georgia lawyer, so I don't. I'm translating it from Florida, and Florida is very open about these things. We have good open.
There's no way you could do this in Ohio. There's no way. I mean, oh my gosh.
Well, obviously, the judge is the judge. Something's wrong with it. I haven't watched this courtroom at all. I just when I saw a defense attorney getting called, I had to go back and jump in because. So I don't want to interrupt your show too much here, but
yes, Ninja Brand. Yes, as Stringer Bell says, are you taking notes in the middle of a criminal meeting? Although in this case, an unethical meeting. yes, they took notes of their unethical meeting, which, yeah. Oh, Jason's saying which Trump trial? The one down in Georgia. Fannie Willis's office is going to run it. This is Fannie Willis's office running a trial. This is
Obviously,
one of
yeah.
her A teams. These aren't
It's
just the
top
rum
down.
pros.
What is it? The fish rots from the top down?
Yeah, the
Head
fish
down?
rots from the head down. Yeah. Yeah, and that's the thing. Judge Glanville's denied a million mistrials. So, yeah.
And see, this is what you see a lot of times on these high stakes trials,
Mhm.
because judges have a lot of power and defense attorneys give a lot of deference, and things run really smoothly and machine-like, right? Until you run into problems, big media, big stakes, complicated trials, high, all of a sudden when people are going for their guns and the defense attorneys start asserting their rights, all of a sudden that judge has never seen such a thing before, and they view it as contemptuous, or they view it as some sort of disrespect, when in fact it's like a client who didn't do it, or you're running over my rights and I'm standing up for them, and they don't know how to respond because they haven't built a foundation of basics, of basic kind of the way you conduct yourself. Because they, most things is I take the pleas and I'm in court and I'm spending all my time kind of repeating myself. So they haven't done the hard work of how does a trial, is it conducted from the ground up, right? You have to have a solid foundation. Same thing with sovereign citizens, I must say. Sovereign citizens challenge these judges in a way when they're not used to it and they haven't thought through their foundational basis of what they're doing. And that's what I'm seeing on this judge, is that he doesn't quite understand what the defense is doing and why. And he's perceiving it as contemptuous.
Yes, and that's the thing. Yes, your actions are an assault on the court. It's like, I'm just doing my job, but it's assaulting the court.
Yeah. It's not, the court, the thing is, the court is me. I'm the court. I am the law.
Back in. We can actually see what happens here. Because he brings Brian Steele back in. So let's see what happens.
Okay.
Sorry, Steve. Let's see what this is here.
Let's see if we hear any mea culpas.
The continued representation of Mr. Williams is been brought to court suggestion that you be here until when we've at all open sessions of court and until we finish for the day. So I'm still going to hold you in contempt. You can purge that contempt by just telling me who it is that told you this information. That's all I need to know. But at the end of today, I'll ask you that question again today. We did not take up any business in your absence, other than Mr. Adams eloquently saying that he was not going to go forward without having you present with him. So, and him not wanting to divulge who the information came from either. So, with that, sir, we're going to go ahead and continue. All right.
Ask a question.
Yes, sir.
Did the court
This is Brian Steele, by the way.
Yeah, I saw it. I replayed it.
order the transcript that we can see it and have a hearing and call witnesses?
No, I'm not gonna order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that.
That's
I don't
error right
believe at this
there.
point in
That's
time,
error. It's in the
it is the
record.
court's understanding.
This is like
There's
we're having
something
now
in the
error.
record that the defense attorney can't see.
Yeah, that like he's just like, no, I'm not going to give you the record.
But
That's
it's in the
error.
appellate court. I review records in the appellate court. There's something that's in the record that the court has been involved with that you can't see. I mean, what the hell is that?
Yeah. Yeah, and I hate this mindset of, oh, well, if I'm wrong, we'll fix it later. What, like 5 years from now?
Ugh, horrid.
Oh my God, this guy is, J-Rock, I know you're out there, buddy. I know you're my bro. You guys need to go talk to this guy because Glanville has lost his damn mind.
It sounds to me like incompetence.
I think this is an overwhelming trial. I'm sure it's fried his brain.
Well, yeah, it is too much. And he, like I said, he doesn't have his foundations of trial work. Probably. I don't know what this guy's background is.
He's a career. He's a brigadier general in the JAG Corps.
Well, that could be.
So he has experience at doing like prosecuting and defending. I think he was a defense attorney prior. I think that he's just not used to being told no And it's like you said, it's just like, well, rah, 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 rah. I just don't think he's prepared for that.
Well, he's over his head from
Yeah.
in this day. Let's keep going here.
This is going to be one of these things at judge conferences. They're going to be playing this clip.
Ending of the ex parte conversation that the disclosure is the more troublesome remedy. If I did something wrong, then certainly that can be reviewed. But
No.
I'm not at this point in time going to
No,
release
they're both
any of the
bad.
transcript in terms of
In
what
fact,
may
ex
be
parte's worse.
disclosed or that was.
I mean, that's the thing.
He's doubling down on stupid.
Yeah, and that's the thing. Like, okay, somebody disclosed and snitched out you committing unethical conduct. That's actually acceptable. You're allowed to stop unethical conduct. If that's one of the ways I could break confidence is to prevent, fraud on the court. I have duties of candor. There are times where you can break confidence and you can't, if it's a breaking of the rules, like if I know somebody's breaking the rules, like you as an attorney, if you and me were like working in the same office and I know you were breaching the rules, I have a duty to report you.
Yeah, tell me about it. I got fired for that.
Yeah, but you know what I mean. But yeah,
I do. Believe me, I do. I know it very painfully.
This idea of him saying, "Oh, the disclosure is the problem." No, it's not.
No, it is not.
The disclosure.
Not.
You got caught with your pants down. That's tough shit. You broke the rules, and you don't get the right to investigate that. You should have acknowledged you're right. These are wrong. I violated the rules of professional conduct. I violated judicial canons. I need to recuse myself and, declare a mistrial.
Well, but he can't make that judgment. He's trying to make a judgment on something that he's basically intertwined with.
Yes. Yeah, he needs to say, I was wrong. I need to be out.
He needs to disqualify himself immediately.
Yeah.
And then the defense attorney, I would expect, should be asking him to disqualify himself.
I'm assuming that's coming.
He didn't double down on stupid. He went all in.
Yes, he did. He just pushed all them chips in the middle.
But this is bad black robe syndrome where they think that they are the law and anything they say that comes out of their mouth is pure and the God's gift to the law. They speak the law.
Nobody's up on the stand right now, guys. Nobody's up on the stand. Also, if you're here for Karen Reed, I am so sorry. We guys, this is
day 88. This is day 88 of this trial.
It's day 88 of this trial, and it started in November.
This is ridiculous.
Well, that's another issue with it.
No trial should be that long.
Well, to be fair, one of the parties got stabbed up in the jail, so they had to take a month off. Because he almost got killed. But otherwise, it's just been a disaster. They've burned through a lot of their jurors. They've burned through a lot of their alternates. This is the one where the other attorneys have been getting jailed previously. You probably saw the clips of that during jury selection, just basically violating rules at this point.
No, I've been.
I don't know if you've seen clips of it here or there. But
I've actively avoided a lot of these trials.
It took a year almost to seat the jury. Yep.
Who is this guy? Why is it such a big deal?
Young Thug is a rapper, and he had a record label called Young Slime Life or Young Stoner Life, whatever you want to call it, YSL. And they were a rap group, and he had other rappers under his label. And in Atlanta, they're accusing him basically operating a de facto gang and criminal enterprise, drug trafficking, racketeering, prostitution, and eventually people got killed too.
Oh, so there's murders involved. Okay, well, that raises the stakes. Now, is it actually a murder? Is there a murder involved here?
No, somebody got clipped.
Okay, well,
murder that he's.
I'm gonna back off a little bit on my criticism.
It's a murder he's accused of greenlighting, but the murder happened back in 2014.
That was actually the RICO trial that I was involved in. There was one of the elements of the RICO. One of the predicates was a murder that the gang member.
Yeah. Well, no, there's murders, there's shootings, there's all these guys were, if they did everything these guys did, these guys were being some rude boys, as they say in Jamaica. So here we go. Let's hear about the rest of this.
Said in Chambers Ex Parte at this point.
Well,
Notice he
I
admits to
was
it.
told based upon information and belief that it would affect this witness's testimony in front of the jury, because I was told based upon information and belief that depending upon how the day goes, he may go home or not, depending upon his testimony. I'd like to know what that's about. I don't know, Mr. Steele. I don't know. I mean, that's why I would like to know.
I don't know. He's lying right now.
Oh my God. How do you
That
not
judge is-
know if
this
you were
judge is
there?
lying. He just committed a lie right there. I don't know. No, yes or no, that was said. Or he could say, I'm not going to discuss it. For him to say, I don't know, you're now denying what you said on the record. Oh my God, this guy's he just talked himself into a hole. Wow. Chat, like, I'm not joking. This is like,
Yeah, I don't know what to do about these crazy jurisdictions like Fulton County and Manhattan DA, you know, that where everything is corrupt from top to bottom.
am I
mean,
wrong?
almost, what?
Am I wrong in that thought? Where the
No,
guy just
you're
said,
right.
my understanding is it was relayed to him, depending on how well he testifies, he goes home. And this judge is saying, I don't know. It's like,
He is not listening to this defense attorney.
yeah.
And I get it being, you know, some judges are state favors and they're biased towards the state. I get it. But this is beyond that. At some point, you got to listen to what they're saying. And what he is saying is incredibly dangerous for the preservation of his law license, his judicial seat, and this trial, not to mention this trial.
Yes, you ever want to see a man, like, you know, play soccer in a minefield? Here you go.
Let's keep going. This is interesting.
Yeah.
Who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. I don't.
So I would like to have a hearing with the court as a witness, with the DAs as a witness, with the deputies as a witness, with Mr. Copeland as a witness, with his counsel as a witness, court reporter, transcript. And Judge, I'm not trying to be harmful.
Mr. Steele, I think that you're running a very thin professional responsibility line. I don't think you have cover at this point in time. I think you're blowing your coverage at this point.
You're wrong, buddy.
Because I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So, I
Well,
mean,
who's
but
privileged?
that's beside the point. At this point in time, we're not going to argue about that.
There's no privilege there.
Privilege? What privilege? The judge doesn't have a privilege, and the prosecutor doesn't have a privilege.
And the witness with his attorney doesn't have a privilege because there were multiple parties in the room. There's no attorney-client privilege there.
Horrible.
He's just throwing shit out now. He doesn't know what to do.
It's funny. The same trial I was talking about that was such pain for me, the judge did the same thing, talking about accusing the defense lawyers of being unethical when he was the one that was being unethical. I remember I had an appeal with that same judge, and he loved to talk about, because he was, I got stories. Let's keep going. This is fascinating.
I mean, he's already violating candor. Like,
This
the
is
judge
terrible.
has candor before his own tribunal, chat.
Terrible.
This is...
I wonder
right now, I just need the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said. I want to know who told it to you.
And I'm making it based upon information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time.
You're holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How can something, I'm not trying to be obstruction, but how can something be attorney-client privilege if it happened before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem. I mean, like I said, I don't know what was said to you. I don't.
I'm trying to get out.
That's improper at this point in time.
Why?
Because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And then you can't, and then you turn around and you say, well, I did something. The court.
No, he's entitled to that information. How you are not the one who decides privilege here
Horrible.
in this matter.
Judge is a
You're not
witness.
entitled to have it. Says who?
The judge is a witness. What
Yeah.
the hell is a judge doing
You're now a
meeting with a
party to
witness who's on the stand outside the presence? I've never seen that,
This is
except in proceedings where the judge is losing their seat. Have you
Yeah.
ever seen a judge meet ex parte with a witness on the stand with excluding the attorney?
No, I've never. I don't think I've ever heard of this because it's kind of like one of those deals where it's like,
It's obvious. You
well,
don't
yeah, but you like if you presented this hypothetical in class, your ethics teacher would have said like, well, no, because that would be completely stupid.
Yeah, I mean, it's
Like
and then
nobody's that dumb.
And then he's whacking on him saying that there's some attorney-client privilege here. There is no attorney-client privileges between the client and the attorney. Okay,
Yeah.
that's the attorney-client privilege. If a third
Yeah.
party comes in and
It's
listens
on.
in on that conversation, attorney-client privilege is broken.
And they
In
know
this
it's
case,
that, and they know that party's there,
so we have a judge and a DA that breaks any conversation.
and they know they're on the record too.
Yes. Tyranny.
You know, I kind of get the feeling I'm thinking about this, Steve. I wonder if this lawyer who was the stand-in for this guy on the stand, do you think he's got some issues too that he didn't report this?
I don't know. It's hard to sense.
It's,
But I know the judge has a problem right here.
Well, I know he's got problems, but God, if I'm this lawyer, I mean, God, a lot of people better be clenching their butt cheeks right now. This is making my feet sweat a little. Like I'm getting nervous listening to this.
It's there's a lot of judicial power sitting on that bench.
Yeah.
And it's powerful and it's dangerous. This is where government, the state, is dangerous.
Yes.
Because you get more
It's unmoored power right now.
Yes, power, and they're like judges with their look at this judge in Manhattan, same thing. You know, they think they can wield the sword of the state for their own personal benefit.
Yes. Well, I'd argue the ADA's got some issues too, but right now, Judge Glanville just called all the thunder down on himself. But let's keep going.
Georgia Barr is who's the operative.
Yeah.
Here.
Well,
I don't know.
Georgia Judicial Review people too.
Yeah.
There's gonna be a lot of people asking questions. Ooh.
Did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
What I said was it is a material part of the trial.
It's not, well,
Has a right to be at, and I'd like to exercise.
It would be just like if you all in the past have had ex parte conversations with the court. And I won't say about for what. You and Mr. Adams and others. That is your right. And that little period or that little conclave of discussion with the court protects you and protects the system. It's recorded and taken down. So if it needs to be reviewed later, it gets reviewed. But you have made something out of it that where I'm kind of at a disadvantage at this point in time. So, because I didn't invite you into that particular proceeding, and I don't think you had the right to be there.
Well, all I know is what I told you, and there's more.
Okay, well.
There's a witness testifying who met with the court and the DAs. That doesn't concern us,
Your Honor,
meaning the defense.
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna keep continuing to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may be privy to or may have been disclosed to you, they're troubling. They are. That's why I've got to find out who it is that disclosed that information. So you have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you, but I do need to know who told you. So if you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then, I'll unfortunately have to look at and waiting to get that information. So you can let me know. terms of what, sir?
I suppose contempt.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this. You will go into custody at 5 o'clock today or whenever.
I think this is more civil contempt than criminal contempt.
This is ridiculous. This judge is out of his mind. The judge is asking to get removed from the bench. This is
Well, I think the Court of Appeals is going to step in and take him up like
immediately. I'd be filing that interlocutory appeal as we speak.
And that's the thing. And I tried to explain this earlier. When that happens, that a contempt issue happens, even if it was just a random Yahoo getting contempt, the Court of Appeals for that area is going to take it right away.
Yeah,
there's not going to be a scheduled briefing out. They're going to look at this and say, like, is this legit or not? And like, if this happened at 9 o'clock in the morning, they could have an answer by 3 in the afternoon.
Yes, and contempt hearings are appealable, and it's called an emergency writ of habeas corpus.
Yes.
So you put it as an emergency, and I've done that occasionally in this type of situation where something is. I've never had a contempt hearing of a public defender that I've done, but I've had emergency petitions.
This actually is criminal contempt because you did it in front of the judge. So yeah, this would be criminal contempt in that regard. I was just reading.
And I will say also that I had a judge, Judge Attic, who I loved, who was my first judge. She was county court judge, and she never once held anybody ever in contempt, I don't think, for her entire career, because she had a lot of other tools for dealing with attorneys. There's a million steps you do before you get to that. That is a very big hammer that you're wielding, and you better damn well be sure.
It's a nuclear weapon.
And you're doing that on the defense attorney in the middle of trial, and he hasn't been contemptuous. He hasn't said anything. He's speaking in defense of his client, laying out a record for his client. What's the big hurry? You can do one day 88.
Yeah, and here's the thing: if the Court of Appeals overturns it and says release him immediately, you've just nuked the case.
It's a disaster.
Even if they uphold it, it's still going to be a massive issue. But yeah, let's see what they keep going.
Steele is not going to give in. He's got balls of steel, and
I love that. Is it written in an order? I'm not writing an order. Like, no, you have to do a journal entry. You can't do this off the clock.
Yeah, we just don't deal with a lot of criminal contempt against attorneys. I mean, it's just very, very rare. And to see it in a high-profile case in a courtroom on a murder charge, and
let's see what happens here. Let's keep going.
Have we finished? If you don't tell me what that is, tell me who that is. This is criminal contempt. I have asked you a question related to these particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not. But this is that important.
Important is important.
Okay. All right. So you got to think about it. All right.
Can I just, last thing, going forward, is over objection, because I believe that we're entitled to these information, especially with this witness.
All right, sir. I'll note your objection. It'll be a continuing objection for the time being. And I may make some other remedies depending upon what information I find later. Okay? All right.
On behalf of Mr. Stillwell, I'm going to review our Brady demand for any Brady material that came out from any conversations with Mr. Copeland, between Mr. Copeland and the district attorney's office this morning.
All right. Summon our jurors, please.
What a disaster.
Well, so guys, because the prosecutor spoke to this guy, they have the right to demand all the Brady material from that.
That's right.
And the judge just basically told them to go fuck themselves.
Unbelievable. And that's federal.
Yeah, that's Brady v. Maryland, guys. Brady v. Maryland, Giglio, Castigar, Bagley, all of them.
Unbelievable. Well, now they're going to put the guy on the stand with the defense attorney not knowing what was discussed between the prosecutor and the judge, and the guy's now on the stand. He's going to have to cross him without that information.
Well, I think at this point I would start asking on cross. And if I was one of the other attorneys, if they have a hair on their ass, they would immediately go into,
what was said.
What did you guys talk about this morning?
Yeah, exactly. Who was there?
Yes. What did you guys say?
What exactly was said? No, I absolutely, I'd be all over.
I guarantee you he'd threaten them with contempt, but I'd be like, I guess we'll share a cell.
Exactly. I mean, this is.
Although at this point, because these guys have basically their practices are getting ruined because they've been spending so much time here in court with this. I almost I think I might say at some point, just for the YouTube clicks, if I was one of these guys, being a big guy myself, I'm like, will I at least will I get a dinner tray? Like, am I going to be jailed in time for dinner? Or am I going to have to sit all night? But no, the attorneys in that area are already the moment this happened, there are attorneys in that town making phone calls and organizing a defense. Like, that stuff is already moving, and he doesn't. There's a whirlwind brewing, and he doesn't know it.
Yeah, this is not what you do as a judge. And there's a time for contempt on defense attorneys. When you've got quality defense attorneys who are making legal arguments, they're not being condemned, they're bringing up legal issues in defense of their client.
Yes. And here's the other issue. This is the witness. They brought him in this time in his jail uniform.
They're bringing the witness in now.
Yes, in his jail uniform.
Doesn't judge have to approve interlocutory appeal? No.
Some questions, yes.
Well, not this.
If it's a final appealable order, no. And holding somebody in contempt is a final appealable order.
Yeah.
There are some orders you don't have to.
I think I'm surprised one of these defense attorneys isn't moving to disqualify the judge at this point.
I don't know either. I mean, all those guys sitting like a bump on a log. I mean, normally when someone else is getting killed, you just sit there and shut up and mind your own business. But
yeah, but this is one where you line up and say,
it's all team effort. Yeah.
Yeah.
Judge, you should be disqualified. We'd ask you to recuse yourself now.
As I've gotten older, I've learned to be a lot quicker on the trigger on judicial disqualification, because when you're young, you're like, oh my God, this judge, I don't want to say something to offend him. But as you get older, you're like, wait a second, you need to disqualify yourself right now.
And I mean, if not now, when?
Right, exactly. Yeah. Exactly. See, they're being potentially criminal, Sean, man. You're the man. You know what you're talking about. You've been there, right? You know what this is about.
Yeah, this isn't it. I mean, Steve, you ever play the game Soul Calibur?
No.
Okay. Well, it's like when you fire up the game, it's an older game, and it's like, welcome back to the stage of history. It's like, dude, you are out there. This is what the world's gonna like. These other attorneys, like this, you're on TV, man. Like you're out there in the Super Bowl. Like, are you gonna stand up and throw down?
Right. That's right.
And like now I saw a couple of attorneys who are gunslingers and a couple are bumps on a log, and it's like, well, I know who the gunslingers are.
No, I love that. I love this guy Steele.
Steele, Keith Adams, the other guy, the bald guy in the back. Like those three dudes are they're G's.
And see the thing, a good judge will thank, and a good prosecutor will thank the Lord for a great defense attorney.
Yeah.
But instead they get offended because they're objecting.
Yes. Well, it's because I say it all the time. Like when I'm at a trial, like the closing arguments, if I hear and I immediately object, I've gotten to the point where like I don't wait for them to hear something. I just say the defense. You know what? And you're right. You have to just say I'm gonna protect my guy the way I protect my guy. And the one thing I always try to make him say is, I don't want to ever hear my client's name out of your mouth. I don't want to hear the word defendant out of your mouth, generally speaking. You have to, like you said, you got to be quick on the trigger. Yeah. And it's better. You know what? If I accidentally shoot too soon, oh well, we could, then it gets fixed. Remember, harmless error.
Believe me, don't have to remind me of that one.
The judge earlier said the meeting was recorded, but it wasn't clear that everything that was said in the record. Possible the judge or someone said something aside from the meeting on the record that he's nervous of. No, I think what Brian Steele said there, that he was told, depending on how well you testify today, you might go home. And I'm sure the prosecutors said that. I'm going to give the judge a lot of credit here that he didn't say that, but he should have immediately said, nope, that is not what we're here for. Well, he should have said, we're not doing this anyway. But he should have said something like, his silence is basically an acceptance of that statement.
Yeah, that's the kind of promise that influences testimony that
Mhm.
you need to have as a defense attorney to cross him in front of
Yes.
the jury.
Yes. And
Yo,
guys, we're gonna
isn't it
watch-
true that you were promised to go
Yeah.
home if you gave what the state? That's what you want to ask that question.
Yeah.
And he's preventing the defense from having that information right now.
And we're gonna go a couple of minutes, although I think he's in the state side of the argument. So I don't think, you know what, we're probably gonna go back to the Karen Reed trial in a minute. And then Spiral Overlord, thank you for the super chat. Is saying, sorry for being off topic. But is that Proctor guy in the stand today the one who was looking for Karen's nudes along with the other events tomfoolery? Yes, that's the same detective. If so, I look forward to your review. Yeah, we're gonna get to that, Spiral. But yeah, looks like this guy's taking the stand and he's finally gonna testify. So let's just double check and then we'll probably head back to Karen. Let's see here. Look at him just spinning around in his chair like a little kid.
Can you hear me? Can you hear me?
Okay, yeah, we're into the process. We're still in the prosecution part. We're gonna stop here.
Yeah,
we're gonna
okay.
stop here.
And I think I'm going to bow out because I haven't been
Okay.
following either of these trials. But when this was my kind of, this was like red meat. So
Yeah.
thank you for the invite, Sean.
Yeah, Steve Gosney, guys, stevegosney.com, guys, buy a book. Steve, thank you for being here. It's nice to I'm not wrong. I'm not just I'm not making this up as I go. Like I am right.
You are right. And can I promote something real quick?
Sure.
I will tell you, I'm probably this Thursday, going to do a new book release party.
Okay.
And it's called Death Penalty Designs, Maximum Due Process, which this is not the final cover. This is a proof of it, but I'm going to release it on June 21st. And I've been working on this for about 2 years. And this is an analysis, a legal analysis of why Florida's death penalty statute is unconstitutional, along with the history of the death penalty in the United States, a federal overview of the death penalty, and then an application of that to Florida's death penalty statute. June 21st, I'm going to release this, and it's a follow-up book to Death Penalty Debates. Debates is the public policy argument. This is the legal argument. So I wanted to release it before I went to the state attorney's office.
Yes.
So I'm probably Thursday-ish. I probably will have a book release party, and hopefully you can pop in.
Sure. And Steve, you need to use this as an example of listen, knuckleheads. Does anybody see a problem with the prosecutor did here?
Yes. Well, I'm
See
going.
if anybody's willing to raise
I'm
their hand.
going to Miami, and hopefully I'll be training prosecutors and advising them on these Brady issues and whatever else. The leadership team down there is very. I was very impressed by the leadership team about the ethics and everything.
Yes.
And so I'm excited about it. They're excited about having me.
You've got a brilliant example of a clip to use right here.
Right on.
Just give it to the new hires. Be like, what do you guys think is wrong here?
Right on. Right on.
Yes. And somebody just wanted to say, Arctic says, where do you find the time, Steve?
Well, this one here I've been working on because I do criminal appeals and I'm doing death penalty. And I was training myself to do death penalty appeals. So this is a book on how to challenge the Florida's death penalty statute as an appellate lawyer. And I'll talk all about it in my next, but you're the first one that's actually seen
the cover.
This baby here. This is a proof copy. See there, not for resale.
Yes.
And I'm going to change the cover. It's going to be much prettier.
Well, and I was going to say, the bigger thing is somebody's asking how you do it. It's easy for, you've got all this going and you write and it's all, when you're in that flow state, it happens.
Well, some of these things though, you work a lot of time writing is I've been working on it for years. And then then I finalize it and it's released. So I don't know how much more I've got in me after this one. But we'll see.
For now. You say that, but
I know.
Brucey Goes to Miami would be a pretty good one.
All right, man. Hey, God bless you. Thank you for allowing me on.
Thank you, Steve. Steve Gosney, everybody. SteveGosney.com and Steve Gosney here on YouTube and Rumble. Thanks, Steve. Wow. All right, guys. Woo! That was some hot shit. I don't think you guys get it. That was fucking intense. That was intense. So we're gonna head back to Karen Reed here, chat. Karen Reed. I'll have to clip all that out because we'll just run it. We'll do it later. Karen Red Trial Day 22. Catch up. Okay. All right, we got to fix the sorry here, guys. We're gonna get going here. You will never see that again, I don't think, anytime soon. Maybe in this trial, but you're not going to see that everywhere. Like, you should appreciate what you just saw, chat. See, would an appeal be filed tomorrow? Oh, I'm sure people are working on that ASAP. The judge seemed more nervous to me than the attorney. Yeah, Glanville got caught flat-footed, man. He got caught flat-footed. He got caught flat-footed. So, all right. So let's go back to Carry On Reed. Here we go. Let's go with Sergeant Bukaki.
Pause there, Ms. Gilman. In that area just waited before the jury, that is when the vehicle was brought in by the tow truck driver from the flatbed from the driveway video into the Sally Port area, correct?
That's correct.
Okay. Sergeant, I'm going to direct your attention to the person that just opened the driver's side door. That's the tow truck driver, is that correct?
That's correct.
Just ask you to take a look at the door, and in particular the snow on the door when he closes that door. Gentlemen, if you could. Your pause just one moment. Sergeant, if I could direct your attention back to the ring video. I think it was video 153 from Exhibit 6. And you were shown that video on cross-examination and asked about any movement that you saw on the driver's side rear tire, things of that nature. Do you recall that?
I do.
And do you recall that portion of the video when it's alleged that Ms. Reed's vehicle came close to or made contact with Mr. O'Keefe's vehicle in the driveway? At that point, did you observe any snow coming off of Mr. O'Keefe's car when they came close to each other?
Objection.
I'll allow it.
I don't remember exactly if there was snow coming off the vehicle. There was snow falling, and that was captured by the ring video. I don't recall if any snow came off the vehicle.
If you could.
Here we go, chat. This is the way it should look. Isn't it funny? The state's like, we're going to show all 5 minutes now in the right orientation. How brave of them. So we're just going to watch the whole thing, chat. Just watch it. Take it all in.
Thank you. And Mr. Officer, we can have the lights back up. Now, Sergeant, that video starts at approximately 5:30 p.m. on January 29th, correct?
Correct.
Is that before or after the ring video 153 from Exhibit 6 at 5:07 in the morning at Mr. O'Keefe's house when you can see the defendant's smashed table?
Objection.
So the objection sustained. Ask the question.
5:30 p.m. on January 29th, is that before or after 5:07 a.m. When you observed the defendant's vehicle on the ring video at Mr. O'Keefe's house?
That is after.
And is that before or after you observed on the ring video the defendant, Ms. Roberts, and Ms. McCabe driving the defendant's vehicle and parking it in the driveway of Mr. O'Keefe's house?
It's after.
And is it before or after about, say, 8:22 in the morning at some point when a Canton Cruiser parks in the driveway behind the defendant's vehicle?
It's after.
And is it before or after about 12:30 p.m. or so when the defendant and her father and her brother from the videos from Exhibit 6, the ring videos on One Meadows Ave, are parked in and around the defendant's vehicle and then leave with the defendant's vehicle to go to Dyke?
It's after.
And is it before or after the video that you testified about on Wednesday in regard to the surveillance video from the defendant's father's house in Dayton when that vehicle was being loaded onto the truck and you can see the tail light there?
Okay.
It's after.
Now, again, you had a conversation or an interview with the defendant on the afternoon of January 29th when you were in Dayton, correct?
That's correct.
And during the course of that interview, she made statements about her broken tail light and when that occurred, correct?
Objection.
Do you want the instruction or do you want to come see me at sidebar?
Sidebar.
So, yeah, chat, I can only imagine what they're... Oh, just...
You are unmuted.
absolute garbage. Oh, Darcy, thanks for the read case. We appreciate it. Oh my gosh, of course. we weren't going to skip this chat, but we're not going to go till. Remember, we still got tonight too. Anyway, so we can only go so far, but we will go.
Now,
far.
Sergeant, between the version of the video that's you and the jury witnessed on Wednesday and the version that you just witnessed the entirety of right now, again, what if any difference as far as the depiction or people or places between those two versions of the video?
Outside of it being a mirror image of itself, it accurately depicts any activity or action in the Sally Port.
And at any point in time that you were in the Sally Port area of the Canton Police Department garage, did you or Trooper Proctor ever go near, touch, manipulate the rear passenger side taillight area or the rear passenger side quarter panel of the defendant's vehicle?
We absolutely did not.
Now, if I could turn you back to some questions you were asked on cross-examination about something that was reported to the Chief Medical Examiner's office. Do you recall that?
I do recall that.
And some questions about statements that you had made to the OCME at approximately 10:41 a.m. on January 29th. Do you recall that?
I do recall that.
And you were asked some questions about reporting it as a possible domestic assault, correct?
That is correct.
And can you explain to the jury what led to that statement as far as what you knew at that time and why you would make those statements to the medical examiner?
The Massachusetts General Law directs us, just as it gives the district attorney's power to and authority over all death investigations. That's the following section 4 of that chapter. Excuse me, following section from section 4, section 5 of that chapter directs all state medical and police entities to work in coordination with the medical examiner's office. By law, we're supposed to work together on the medical legal investigations that the medical examiner's office conducts. We conduct the criminal portion of the investigation. They conduct the medical portion of the investigation. Thus, I contacted the medical examiner's office and advised them that what we had learned at the time. Up to that point, we had learned that the defendant stated that she hit him. We had collected, meaning the Canton Police Department had collected a broken glass. So based on the physical evidence and the statements made by the defendant to the first responders at the scene at that point in time, I had communicated those facts to the medical examiner's office. That way they would document it, but also be prepared to investigate the case with the most up-to-date information available.
Now, at that time that you made that statement to the representative from the Chief Medical Examiner's office, had you been to Good Samaritan Hospital and seen Mr. O'Keefe at that point?
I have not.
And had you obviously seen any of the injuries that Mr. O'Keefe had sustained prior to making that statement to the medical examiner?
I had not.
Now, as far as the information that you received, you mentioned first responders indicating that the defendant had stated, "I hit him." Who was the first responder that provided that information?
The Canton Police Sergeant Good.
In addition to that, did you or Trooper Proctor speak with any of the Canton fire personnel?
Yes, we did.
And who did he speak with?
I believe it was firefighter Fleming.
So firefighter Flamati, is that correct?
That's correct.
Now, after going to Good Samaritan Hospital and viewing Mr. O'Keefe's injuries, as far as what you had earlier reported to the medical examiner, what, if anything, changed based on those observations as far as your opinion as to what had transpired?
Based on what I learned from observing the injuries, I could tell that the glass.
Objection. No, I'm going to allow it. You can move to strike it, but I'm going to allow it.
I could tell that the glass was most likely not the object, the weapon, which was used to cause the injury to the back of Mr. O'Keefe's head.
Thanks, sir. Can I have a moment?
Yes.
Thank you, sir. I have no further questions.
Any recross?
Very briefly.
Okay.
In your report to the OCME, you said it was a glass to the face, not to the back of the head, correct?
I'm not sure how they wrote it down, but I would need to be refreshed on my memory.
Okay, fair enough. May I approach?
Yes.
Last sentence. May I?
Yes.
I'm sorry. Does that refresh your recollection?
Yes, it does.
What did you say to the, or what did you report to the OCME?
That there was a possibility that the decedent was struck to the face with a glass.
You also, with regard to the phrase, I hit him, or the Sergeant Good and or Flamati telling you that she said, Ms. Reed said she hit him. When did Sergeant Good tell you that?
It would have been during our conversations at the police department.
And when did EMT Flamati tell you that?
He never told me that.
So the only thing you were going on with regard to the phrase or the statement that you claim my client indicated, where my client indicated she hit him, is coming from Sergeant Good.
That information at that time was provided by the first responders from the scene.
And Sergeant Good then relayed that to you, correct?
At some point, yes.
Is there a single report memorializing that Sergeant Good reported to you that morning before 10:41 a.m., before 10:41 a.m., that my client made the statement that she hit him?
I don't believe so.
I want to shift gears real quick to the video. A couple of quick questions about that. When did you, and I'm talking about the higher quality video, the one that was inverted. When did you receive that video? What date?
I'm not sure. It was at some point in either late April or early May.
After we had started this trial.
Objection.
Do you know?
I do not, Your Honor.
Okay.
If after mid-April, correct?
I believe so. I'm strictly speculating here.
Who asked you to retrieve that video?
I did not retrieve that video.
I'm sorry, that's a presumptuous question. At what point were you asked to secure the video, or were you ever asked to secure the video?
That video was never secured by me. I was not asked to secure it. I just was asked to review it.
Okay, so who did secure the video to your knowledge?
I do not know.
You were aware that it was, well, let me ask you a couple of different questions then, based on that. You've already testified that you knew that the Canton Police Department was recused from any investigation concerning this case, correct?
At one point, we learned that the Canton Police Department, the decision was made way above my level, and I was advised by Detective Lieutenant Tully that Canton Police had recused themselves from the investigation as far as interviews go.
And you knew that that recusal was because of a connection between the Canton Police Department and the Albert family, correct?
Objection.
Sustained.
Did you know, or were you informed that the recusal was based on the connection between the Canton Police Department and the Albert family?
Objection.
So it's sustained for the same reason. I sustain the Commonwealth's objection at sidebar, Mr. Jackson.
Last question. Who provided the video?
I do not know.
Canton Police Department, wasn't it?
You asked who? That's an entity.
Okay, what entity provided the video?
It came from the Canton Police Department.
Thank you, that's all I have.
All right, Sergeant, you are all set, sir.
Thank you, Your Honor.
Your next witness, Mr. Lally?
Yes, Your Honor. Commonwealth call Officer Nicholas Barrows to the stand.
Okay.
I don't know who this is, chat. Okay.
Please hold so the evidence here for the court and jury in the case now here to the truth, the whole truth, and nothing but the truth, so help you God. I did.
Sorry. All right, whenever you're ready, Mr. Lally.
Thank you.
There is a comment somebody was saying, Matt was saying, what's this case about? Down below, there's a description. Basically, Karen's accused of murdering her boyfriend by running him over and leaving him dead in the snow. Obviously, there appears to be a lot of issues about whether that actually happened the way the police claim it happened. So there's a little more information down below if you want to check in the description.
Good morning, sir.
Morning.
Could you please state your name and spell your last name for the jury?
Nicholas Barrows, Barros,
And how are you employed, sir?
with the town of Dayton.
And what, if any, role or what do you do for the town of Dayton?
I'm a police sergeant for the police department.
And how long in total have you been a member of the Dayton Police?
In total, started in 2011, 14 years this December.
And how long have you had the rank of sergeant with the Dayton Police?
A year and a half.
Now, if I could direct your attention to January 29th, 2022. Do you recall that date?
I do.
And were you working that day?
I was.
And do you recall what kind of shift you were working on that occasion?
I was working the 8 to 4, the day shift.
And was that the only shift that you had worked on that occasion, or how long had you been on shift by the time you came on for the 8 to 4?
That particular day, I was working from 8 a.m. to midnight. It was on a double.
Now, at some point when you first came in, with reference, if you could explain to the jury just briefly or in general terms, when you come on shift for the Dayton Police, what, if any, communication, well, first and foremost, what was your role as far as that particular shift was concerned?
I was the officer in charge that day from 8 a.m. to midnight. When I came in at 8 a.m., the outgoing shift, the midnight to 8 shift, had advised me that a resident had called the police station on a 911 call requesting a ride to Brockton Hospital to meet his daughter due to her daughter's boyfriend passing away, and he needed a ride due to the snowstorm.
And then as your shift continues, what, if any, further contact or who, if anyone, reached out to you in regard to that earlier situation?
Later on, I believe it was around 2:30 in the afternoon, I received a phone call from the Norfolk District Attorney's Office with the troopers assigned there, and they had stated that they were going to come to Dayton to retrieve a vehicle that was involved in a homicide.
And did they give you a specific address as far as where they were going?
I believe the address was 345 Country Hill Drive in Dayton, North Dayton.
And with regard to that address, what, if anything, did you recognize between that and the earlier call that you were just speaking?
That was the address that came up on the 911 call when that gentleman had called earlier on the prior shift.
And at some point, did you come to find out who the residents were at that address on Country Hill Lane?
I did.
Okay.
Who did you find them to be?
It was the Reed residents.
All right, so Sergeant, I'm going to ask you to keep your voice up, and Mr. Lally, you too.
And the Reed residence, was that a William and Janet Reed, is that correct?
Correct.
Now, as far as you received that call at about 2:30, do you know specifically who you spoke to around 2:30 in the afternoon?
Trooper Michael Proctor.
And as far as that earlier information that you were talking about with the 911 call, what, if anything, from that did you impart to Trooper Proctor?
I advised Trooper Proctor that we did receive a 911 call on the midnight to 8 shift about the resident looking to get a ride to Brockton Hospital.
And during that initial call, how was it sort of left as far as what, if anything, you were going to provide as far as assistance or with regard to the troopers on that first call?
On the first call, the troopers just had asked me if I could meet them at that residence as a courtesy since they were coming into my jurisdiction.
And what, if anything, did they indicate to you as far as where they were or when they felt they would be arriving in that area?
Trooper Proctor advised me that they were heading, I believe, from Canton, and once they were about 10 minutes away, they would recontact me so that I could meet them at the residence.
And subsequently, later in that afternoon, did you receive further contact from Trooper Proctor?
I did.
And do you know about what time that was?
I believe the first phone call was around 3 p.m. that he had called me and said that they would be there in about 10 minutes.
And upon receiving that call, what, if anything, did you do?
I had contacted, Trooper Proctor had asked me to contact our tow company to have them meet us at the residence as well. And I said, once I hung up with him, I would contact the tow company and then respond to that address on Country Hill Drive.
Is there a specific tow company that the Dayton Police uses with regard to towing the vehicles within the town?
During that period, it was Diamond Towing.
And so did you contact someone at Diamond Towing in reference to responding to that address as well?
I did. I contacted the owner and he responded.
Now, as far as that area of Dayton, if you could explain to the jury sort of what you observed as you were coming down towards that residence on that day.
Okay, so when I responded to that address, that street is off of 138. When I turned onto Country Hill Drive, I was traveling west. When I arrived on that street, I observed a black pickup truck parked on the street facing east. I was flagged down by that black pickup truck by the driver and was told that they were the troopers that I had spoke to, Trooper Michael Proctor and the other sergeant.
Sergeant that left the room as you were coming in?
Correct.
And what identification did they provide to you in reference to them?
They showed me their ID and their badges.
And then from there, where did you proceed?
I had parked my marked police vehicle at the end of the driveway since it was a snowstorm and we could not get into the driveway. And then we walked up to the residence.
So when you say it was a snowstorm and we couldn't get into the driveway, can you expound upon that a little as far as explaining to the jury why it was that you couldn't get into the driveway?
There was about a foot of snow in the driveway.
And as far as that snow that you observed when you arrived there, was that snow, how did that snow appear as far as, did it appear as if it had been shoveled or snow blown or untouched or how did it?
It was untouched.
Now, as you're going through the snow, and correct me if I'm wrong, but it's yourself, Trooper Proctor, and Sergeant from the State Police, and who, if anyone else, is going along with you?
I had an officer that was field training with me that day, and he was with me as well. And we went up to the residence.
And as you're walking up to the residence, what, if anything, did you come upon as you're going towards, say, any door or getting closer to the home?
I remained at the garage. The two troopers went to the front door and made contact with the homeowner.
Now, as far as you were there specifically for a vehicle, correct?
Correct.
Did you observe a vehicle in the driveway at any time?
Yes, we observed a black Lexus SUV in the driveway.
And what, if any, observations did you make to the rear area of that vehicle specifically?
At first, I did not go up to the vehicle. I just remained at the driveway and waited for the troopers to come back. And once they came back, they were let into the house through the garage. I had walked in with them briefly and then went back out to the garage and remained with the vehicle.
And as far as at any point in time, did you have any conversation with anyone named Karen Reed that day while you were at the house?
I did not.
Now, with respect to you come back out to the garage, is that correct?
Correct.
And the troopers are inside the house, is that also correct?
Correct.
Now, at some point, do other vehicles come down to the driveway area of this residence that you were at?
I had contacted the highway superintendent after speaking with the troopers about how to retrieve the vehicle since the driveway was untouched and had about a foot of snow. I had made the decision that I would call the highway superintendent and see if that he would come and plow the driveway so that the tow truck would have access inside in the driveway.
And just in reference to this driveway, just if you could, not exact footage or anything, but how close is this Lexus SUV parked in relation to the roadway? How long is that driveway?
It's got to be about 150 feet off the roadway, if not more.
And if you recall, from where you're standing at the point of the garage, was what part of the vehicle was facing you? Was it the front of the vehicle, the back of the vehicle, the side of the vehicle?
I was looking at the left side of the vehicle.
And at some point, did you make any observations of the right rear part of that Lexus SUV?
I did.
And what, if anything, did you observe about that area of the vehicle?
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked and a piece was missing, but not completely damaged.
And then beyond the taillight area of that vehicle, what, if anything else, did you observe as far as damage to the rear passenger side area?
Like a dent on the rear quarter.
And as far as the dent on the rear quarter of the panel that you saw, was that above the taillight, below the taillight, or something?
It's probably right in conjunction with the taillight in that same area.
And from the time that you made these observations of the vehicle, at any point did you go sort of physically up to the vehicle?
I walked up to the vehicle, correct.
And about how far away from the vehicle did you get?
5 to 10 feet away.
And as far as the sort of outside or exterior of the vehicle, you mentioned obviously there's about a foot of snow on the ground. What, if anything, precipitation-wise or weather-wise, was around or on the outside of the vehicle?
Just snow.
And in particular, in this area of the right rear passenger side and that taillight, was there any snow or ice or anything around that area that you observed?
On the vehicle itself?
Yes.
Yes, on the vehicle, there was snow on the vehicle.
And not to put words in your mouth, but sort of caked on there, is that correct?
I guess you could say caked on, correct.
So you'd reached out to the highway superintendent to have someone come out and plow the driveway, correct?
Correct.
And do you know about how long it was between the time that you made that call and the time that the plow driver came out to clear it?
Less than 10 minutes.
And the sort of clearing of the driveway and the process of that, do you know about how long that took?
I'd say another 10 minutes or so.
And as far as the time that the troopers went into the house, at some point the troopers obviously came out of the house, correct?
Correct.
You know about how long it was that they were inside of the house?
More than 30 minutes, less than an hour.
Now, at any point in time that while you were there, did you yourself or did you see anyone else touching or making any contact or manipulating or anything in that rear passenger side area of either the taillight or the dent that you
I did not.
I'm sorry.
I did not.
Can I have a moment, John?
Yes.
Thank you, sir. I have no further questions.
Okay, cross-examination? All right, Sergeant Barrows, you are all set, sir.
Thank you.
Do you want to call another witness or morning recess?
Morning recess, but, Your Honor, if I could just, either before or after, I just need to address one thing with the court at sidebar.
All right, so we'll send the jurors out. Jurors, why don't we take the morning recess?
All right, chat. So we're taking our break. No breaks for us. It's interesting though. The glass wasn't cracked. That's the interesting part. That's a very interesting thing there. No, that was the big thing. I saw that earlier, guys. I saw this comment earlier from this guy. The taillight wasn't touched. Game over. Game over. I saw the light and it was fine. I don't know what like more you can do with that.
Like,
Hold on here. Here's Trooper Proctor. Here we go. Do you touch anything? Yeah.
possible medical situation.
And based on that initial call and that initial information that you received, what, if anything, did you do?
And at that point, I knew I needed to gather further information. So I contacted Detective Lank from Canton Police Department to see exactly what transpired in the morning. He had informed me that a male party had been transported to Good Samaritan Hospital with some injury.
This is Trooper Proctor. Trooper Proctor. This is him, guys. So here we go. Here we go, chat. Use a different stream. I'm trying to avoid streams that have all the garbage on it, but I'll look for another one. Give me a second.
Detective Lank didn't have much more information, so I knew I needed to contact the paramedic at the hospital, the individual who's treating Mr. O'Keefe.
Before we get to that, if I could, I'm sorry. As far as Detective Sergeant Lank was concerned, was that someone that you called on your own, or how did you get his information, or why did you call him specifically?
I knew he was on scene, so I called Detective Lank.
So that was some information that you had received at some point earlier, and then you contacted, Detective Sergeant Lank.
Correct.
And following that, you reached out to whom? I'm sorry.
Firefighter Anthony Flamati.
And with reference to that conversation, what, if anything, did you learn from that?
Firefighter Flamati informed me that
I'm going to allow it.
Firefighter Flamati informed me that Mr. O'Keefe had some injuries to his right arm, some abrasions to his right arm, some injuries to his eyes, a cut to the nose area, and he put a 10% chance of survival for Mr. O'Keefe.
And then based on that information, who did you call next?
I contacted Sergeant Buchanan, advised him that this sounds like it's more than a medical situation.
And what, if any, decision did you and Sergeant Buchanan come to with regard to what to do or where to go or what the next step should be?
So there's a couple different steps. Number one, it was blizzard conditions, and we operate, Ford Fusions or Chevy Malibu. So we got authorization to use our personal vehicles that are four-wheel drive, and to meet at Canton PD and to speak with the responding officers.
And about what time was it that you and Sergeant Buchanan arrived at the Canton Police Department?
It was approximately 10 a.m. that morning.
And so, Trooper Proctor, if I could ask you, whereabouts were you at about 8:22 in the morning?
Home.
Had you shoveled out of your driveway at that time?
Not yet.
Had you cleaned off your car at that time?
No.
So you arrived at the Canton Police Station about 10 a.m. or so. When was it that you arrived in relation to Sergeant Buchanan? If you know?
At Canton PD?
Yes.
I don't recall if Sergeant Buchanan arrived first or myself.
But suffice it to say, at some time you both arrived around 10 a.m. Is that correct?
Yes, sir.
And where did you go with the Canton Police when you arrived there?
We spoke with the
Chat, just so we're aware, someone has informed me that there will be possibly another hearing for Brian Steele around 5 o'clock, that Ashley Merkant and all the pipe hitting lawyers might show up to, ready to go to town. So if that happens, we're going to switch back over to it just because this is huge. So hang tight. We may be switching.
Sergeant Sean Good.
And what, if anything, did you learn from Sergeant Good?
Sergeant Good informed us that while he was on scene, he identified Kerry Roberts, Jennifer McCabe, Karen Reed. He also informed us that Jennifer McCabe was out early in the night at a waterfall bar in Canton with some individuals, and that she was the one who called 911 when they found Mr. O'Keefe in the snow that morning.
Now, with regard to the parties that you just mentioned, prior to January 29th, 2022, had you ever met or were you aware of either Jennifer McCabe or Kerry Roberts, Karen Reed, or John O'Keefe?
I've never met any of them.
And at some point subsequent, did you have occasion to meet and speak with Ms. Reed?
Yes,
And do you see Ms. Reed in the courtroom today?
I do.
Just for clarification purposes, if you could identify as to where she's seated or an article of clothing that she's wearing.
She's seated between Mr. Jackson and Mr. Yannetti wearing a pinstripe sport coat.
No, just ask the record reflects identification of the defendant.
Yes.
Now, after you speak with Sergeant Good, did you speak with anybody else at the Canton Police Station?
No.
And where did yourself and Sergeant Mechanic go from there?
We then traveled to the home of Matthew and Jennifer McCabe.
Now, with reference to when I say you and Sergeant Mechanic, at how long a period of time was it that you were with Sergeant Mechanic on that day of January 29th?
It's from 10 a.m. approximately when we met at Canton Police Department until when we returned to the Canton Police Department that afternoon around 5:30 in the afternoon. So all day. And we also had a debrief meeting with just the troopers in my office at Canton PD. So at least from 10 to 6, 7, because we also went back to the office with some evidence.
And so from that entire time, from 10 in the morning until later on in the night, other than maybe short drives in individual cars, were you essentially with Sergeant Mechanic that entire day?
Yes, we used Sergeant Mechanic's pickup truck that entire day. I left my personal vehicle at the police department, and I rode with Sergeant Mechanic all day and into the evening.
Now, from the Canton Police Station, where did you and Sergeant Mechanic go?
The McCabe's house in Canton.
And who, if anyone, did you speak with it?
We spoke with Matthew and Jennifer McCabe, as well as Brian Albert.
And those interviews that you conducted, were they how were they conducted?
One-on-one, Sergeant Mechanic and myself kind of rotated out Jennifer, Matthew, and Brian. So first we interviewed Jennifer, and then once that was completed, we had her step out, go to a separate room, brought in Matthew, and then the same thing with Brian.
And for the balance of the interviews that you conducted several interviews over the course of your investigation in this case. Is that correct?
Correct.
And for those interviews, as far as individually done, was that primarily what you did with each of the people that you interviewed over the course of the investigation?
Yes, each interview conducted was either with Sergeant Mechanic or another trooper in one-on-one, with the exception of Julie and Chris Albert, I believe, were in the same room as us.
Now, with respect to, I believe you just answered it, but as far as each of the interviews that you conducted over the course of your investigation, was it at any point in time, was there an interview that you conducted just by yourself?
There was just one.
And who was that one that you conducted by yourself?
That took place just at the grand jury across the street. It was the Currans. I had some difficulty locating them, so when they appeared for grand jury, I interviewed them one-on-one by myself prior to their testimony at grand jury.
You had attempted to meet with them prior to them coming to the grand jury, is that correct?
Yes.
And they had not been responsive to that?
Correct.
However, they were responsive to the summons, and so you interviewed them before they went into the grand jury, correct?
Yes.
Okay. Other than those, as far as Mr. and Mrs. Curran, every interview that you conducted was in the presence of at least one other trooper?
Correct.
Now, as far as you mentioned one name that we hadn't discussed before at the McCabe household, a Brian Albert. Prior to January 29th, 2022, had you ever met or were you aware or did you know Brian Albert?
And I've met Brian Albert until that interview.
Now, following the interviews that you conducted at the McCabe household, where did you go from there?
After the interviews at the McCabe household, Sergeant Mechanic and I traveled to Good Samaritan Hospital for two reasons. One, we knew Miss Reed was there receiving treatment for Section 12. And two, we wanted to view Mr. O'Keefe.
And when you arrived at the Good Samaritan Hospital, was the defendant, Miss Reed, still at that facility at that time?
We spoke with the security staff at Good Samaritan Hospital. They informed us that Miss Reed was released.
I'll allow it, just as to where you went.
That Miss Reed was released several hours prior to our arrival.
And do you know about what time it was that you arrived, yourself and Sergeant Mechanic, at the Good Samaritan?
Maybe approximately 1 o'clock.
And you mentioned there was a second reason, and that was to view Mr. O'Keefe, correct?
That's correct.
And did you have occasion, or did you have a chance to view Mr. O'Keefe's body at the Good Samaritan?
We did.
And where was that within the hospital?
That was in the emergency room.
And when you went to where Mr. O'Keefe was, can you describe for the jury what, if any, observations you made of Mr. O'Keefe's body at the time that you observed?
The first thing I noticed on Mr. O'Keefe is he had abrasions on his right arm. On the top of his right arm is approximately 6 to 8, ranging from his forearm to his lower bicep. There was no injuries underneath that forearm. Both eyes were swollen and black and blue. He had a cut on, I believe it was his right nostril. Another smaller cut, I believe it was on his left eye. Those were the injuries that kind of jumped out to me.
At any point in time, did you make any observations of the back of Mr. O'Keefe's head while you were there?
I did observe blood on the back of the head. I wasn't able to tell if there's any significant trauma to the back of his head.
Now, from the Good Samaritan Hospital, yourself and Sergeant Buchanan, what, if any, items did you secure in evidence from the Good Samaritan Hospital?
So after we viewed Mr. O'Keefe's body, we observed a pile of clothes in the corner that hospital staff had cut off Mr. O'Keefe and kind of piled into the corner. The one thing that had jumped out to both of us was one sneaker. And it's fairly common in a motor vehicle pedestrian strike that...
Sustained. Next question. I'll strike from fairly common. The observations.
As far as the clothing that you observed, can you describe the clothing that you observed?
Yes. We observed one black sneaker with a Nike logo, a pair of blue jeans, a belt, boxer shorts, an orange t-shirt, and a two-tone gray light kind of hooded sweatshirt type of material.
Now, Trooper Proctor, over the course of your career responding to unattended deaths or death investigations as a member, as a detective of the unit, how many of those have involved situations where a pedestrian was struck by a motor vehicle?
Well, I've been in the unit, maybe 3 or 4, and then I've other experiences on the road.
And as far as the other experiences on the road, can you expound upon those as far as how many or over what time period we're talking about?
About 6 years I spent on the road, so maybe another 3 or 4.
And with reference to those pedestrian crashes, what, if anything, have you seen in those prior investigations in regard to sneakers or footwear of pedestrians involved in motor vehicle crashes?
I'm going to see you at sidebar reviews.
Natasha. Okay, so guys, there are a couple super chats I missed earlier here. Sorry. Stephen Cooper says, what is this garage where they search cars to do body restoration on police cars? I think the one on the bottom right's from the 60s. That's at the Canton Police Department. They have a that's like the city garage and the police garage. They have an old police car there. They probably use in parades. Stop Boss B says, is it the same Steve Gosney, the guy that did a release party with Ricada? Yeah, you know what, guys? Hey, things have changed, people change, and yeah, now I'm sure Steve would not do it again like that. But hey, we all mess up. And Darcy says, thanks for coming back to this. We appreciate it. True, you're welcome. As I said, there are a bunch of attorneys outside outside the Young Doug courtroom, including Ashley Merkett and a lot of those attorneys that did stuff with Trump. A lot of people are showing up out there at the courthouse. Natasha for $5 saying, how does HIPAA work with medical records during an investigation? Here's the neat part about HIPAA. HIPAA doesn't apply to the government. So the government cannot violate HIPAA. The government is expressly exempted from HIPAA. So that's why they can go and request all your medical records. They can get all of that. They are not bound by HIPAA. So, and Clyde's just like, he fainted. He's like, I can't believe that, but that's true. They're not bound by HIPAA. So that's how that happens. They file a subpoena and that's it. And they get them. It's a very good question, though, Natasha. Thank you for asking it. Reclining Clyde. Yes, Clyde wants a belly rub. Oh, I know. I know Nick wrote the foreword to one of Steve's books, but he hasn't done it for all of them, you guys. Jesus Christ. It's not like he's doing it every 5 fucking minutes. So, look at this comfy boy. Yeah, he's getting heavy, too. So, he's a heavy boy. Oh, but let's keep going here, chat. No updates on the Brian Steele case. Oh. You're getting too heavy, Clyde. I got to put you down, but
Proceed, Your Honor.
Yes.
Now, with reference to your prior experience with pedestrian crashes involving motor vehicles, what, if any, observations have you made on those prior occasions in regard to the footwear with respect to the pedestrians and motor vehicle crashes?
In those experiences, I've observed one, if not both, pieces of footwear remained at the point of impact.
And so with respect to your observations of the clothing, there only being one sneaker at Mr. O'Keefe's property, what, if any, significance did that have to you as far as the sort of steps you took subsequent in your investigation?
That was just a little piece of evidence that Sergeant Mechanic and I picked up that only one piece of footwear revealed the potential of a vehicle strike.
Now, in addition to Sergeant Mechanic is one of your supervisors within the detective unit, is that correct?
Yes,
And is another one a Lieutenant Brian Tully?
that's correct.
Now, with respect to the one sneaker that was found in Mr. O'Keefe's property, what, if anything, with regard to that, did you communicate to Lieutenant Tully?
Objection.
As to how it goes to the investigation,
Yes.
I'll allow it.
So Sergeant Mechanic and I informed DLT Tully that there was one shoe at the hospital.
And with respect to Detective Lieutenant Tully, are you aware that subsequently in the afternoon that there was a search that was conducted in the area of 34 Fairview Road where Mr. O'Keefe was found?
Yes.
And are you aware of what, if anything, was recovered in the area where Mr. O'Keefe was found on that day?
Objection.
I'll allow it as to the investigation.
Yes.
And what are you aware?
We were informed, Sergeant Mechanic and I were informed that CERT team and Detective Lieutenant Tully discovered a black Nike sneaker with the white swoosh logo that was a match to Mr. O'Keefe's shoe at the hospital.
Now, from these items of clothing, I'm sorry, let me just get the sign on the phone. Trooper, in addition to the shoe that you already referenced, what, if anything else, did you observe about what kind of clothing and the condition of the clothing that you observed at the hospital?
The clothing seemed, it was wet. It was pretty well saturated. The right sleeve had some cuts to it, like tears to it. There's like blood and vomit on it, if I recall. Those were the observations I had made of the clothing. And they had been cut due to rendering first aid as well, the pants area.
Now, subsequent to viewing these clothing items at the hospital at a later time, did you have occasion to observe surveillance video from a variety of places on the evening of January 28th into the early morning of January 29th depicting Mr. O'Keefe?
Yes.
And what, if anything, did you note with regard to the clothing that you observed at the hospital and the clothing that you observed in the video?
So the videos I reviewed at CF McCarthy's bar and the Waterfall bar were the same clothes Mr. O'Keefe was wearing that Sergeant Mechanic and I had secured at Good Samaritan Hospital.
Now, Trooper, I'm going to ask you some questions just in regard to
really?
securing these items specifically as evidence, but in general terms, as far as securing items and evidence within your unit. How is that accomplished? How is that done? What do you do with items that you deem of evidentiary value that you then secure?
Generally, if we take an item for evidence, we'll put it in a brown paper bag, document it, time, date, who secured that item, address, where it's discovered, and then we'll bring that back to our office, to the evidence processing area. From there, it'll go to a permanent evidence room that has triple retention. It has an actual key, a key card, and an actual access code. And only 3 members of my office have access to that room, the 2 evidence officers and Detective Lieutenant Tully.
And at this time, in January 29th, 2022, who was assigned as the evidence officers who had access to that room?
So that'd be Trooper David Achico and Trooper Jeffrey Kukowski.
Did either yourself or Sergeant Buchanan have any access to that evidence storage?
No.
Now, with reference to these items that were seized and say items that were seized subsequent during the course of your investigation, did they go through that same sort of evidentiary storage process that you were speaking about before?
Yes.
Now, with reference to, in addition to the clothing items, at some point did you come into possession and seize Mr. O'Keefe's phone?
Yes.
And do you recall where it was that you received or retrieved Mr. O'Keefe's phone from?
We received it at the Canton Police Department.
And was that prior to you going to the Good Samaritan?
After, I believe.
After. So following the Good Samaritan, where did you go from there?
So after the Good Samaritan Hospital, Sergeant Buchanan and I traveled to 345 Country Hill Drive in Dighton.
And why did you go to that location?
That was the residence of Miss Reed's parents' home. And having a brief conversation with Miss Reed on the phone, she informed us she was at her parents' house.
So you had called Miss Reed, spoken to her, and informed her that you were coming there to speak, correct?
Correct.
And just as you had done with Ms. McCabe, Mr. McCabe, you spoke to Ms. Reed within her home?
Yes.
And who, if anyone else, did you reach out to on your way there with regard to local law enforcement as you were driving to Dayton?
We contacted the Dayton Police Department just for a couple of reasons. One, it's a common courtesy. If we're in another town, we just kind of give the local PD a heads up. But also, we needed to coordinate a plow truck and potentially a tow truck as well.
And why did you need to coordinate those?
At the time, there must have been at least a foot of snow on the ground, more. And it was a dead-end cul-de-sac, so which made it difficult to navigate. So we requested the plow to clear a path for Sergeant Buchanan and I to get down the roadway, as well as clear the driveway of the residents, so the tow truck could pull into the driveway.
Now, as far as the drive from Good Samaritan, that's in Brockton, is that correct?
Yes.
As far as the drive from the Good Samaritan in Brockton to the defendant's parents' home in Dayton, about how long a drive was that, and how would you describe the weather conditions along the way?
Yeah, the weather conditions were white out, high winds, blizzard conditions. We had to travel very slow. It was almost about an hour to get there.
And when you arrived there, you're in Sergeant Buchanan's truck, is that correct?
Correct.
And where did Sergeant Buchanan position the truck in relation to the house at 345 Country Hill?
From what I recall, Sergeant Buchanan went down the cul-de-sac and turned around, and he actually had to let me out first because of the high snowbanks, and then he parked kind of along the snow, pointing essentially to Mr. Reed's house.
And at some point, did members of the Dayton Police come along and join?
Yes.
And do you recall who those people were?
I believe one of the officers' last name was Barrios.
And had you ever met that officer before?
No.
Now, with respect to the home, had you and Sergeant Buchanan approached the home at any point prior to the Dayton Police showing up?
I can't recall if, no, they had arrived first before we approached the home.
And when you approached the home, you went, what did you traverse? How did you get from the street to the home?
We walked down the driveway, and then we observed Miss Reed's Lexus parked in the driveway, the front of it facing one of the garage doors. And that's when we observed the broken taillight on the right side of the vehicle. We then proceeded to the front door. The snow was about up to our waist, and knocked on the door and was greeted by Mr. Reed.
As you're walking up the driveway towards the home, you see Miss Reed's vehicle, is that correct?
Yes.
And that's a vehicle that you later subsequently found to be registered to Ms. Karen Reed, is that correct?
Correct.
Now, may I approach?
Yes.
So I'm showing you documents, 4 pages in length, just ask you to review that after you finish. And do you recognize that document, sir?
Yes.
What do you recognize it to be?
The Registry of Motor Vehicles. It's the certified document for Miss Reed's Lexus.
Is that the plate information that's contained in there? Is that the same plate that was affixed to Ms. Reed's vehicle on that day?
Yes.
And that also details sort of the history or how long she's had possession of that vehicle. Is that fair to say?
Correct.
Going back to, I believe, 2021. Is that correct?
Yes.
May I approach, Your Honor?
Yes.
I will seek to introduce and admit as the next exhibit.
No objection.
Now, with respect to Ms. Reed, at some point you go into the house. Is that correct?
Yes.
And how do you enter into the defendant's parents?
So Sergeant Buchanan and I, after we knocked on the front door, Mr. Reed directed us around the corner, opened up the garage door for us, and invited us in.
Now, if I could take you back to, I'm sorry, just as far as when you're coming up the driveway and you're passing by the defendant's vehicle, you mentioned some damage that you observed to the right rear passenger side area. Is that correct?
Yes.
Can you describe to the jury what it was specifically that you observed as far as damage to that area of the vehicle?
Yeah, the right rear taillight had essentially large pieces missing from it.
So you proceed inside the home, and where is it that you're directed, and where is it?
We're invited into a large living room area. Miss Reed is seated on a couch, and her parents, William and Janet, are present for the conversation and kind of standing off to the side.
And that conversation goes on for approximately how long?
Approximately half hour, 40 minutes.
And when you terminate that conversation, you come back outside of the home, is that correct?
Yes.
And where is the vehicle at this point?
That is being put on the tow truck.
Now, in addition to the defendant's vehicle, what, if anything else, was taken and seized as evidence from the defendant on that morning?
After confirming the phone Miss Reed was holding was, in fact, hers, we told her we were seizing the phone and we'd be writing a search warrant for that
Now, during the course of the conversation that you and Sergeant Mechanic had with the defendant that afternoon at her parents' home in Dayton, were there some questions in relation to contact information for other people that were at bars or different establishments the night before?
Yes, we asked Ms. Reed specifically for some of the friends that Mr. O'Keefe was with at C.F. McCarthy's. One person in particular was Michael Camerano. So we observed Ms. Reed enter the passcode on her phone, retrieve Mr. Camerano's phone number for us, provided to us, and that just further confirmed that was her cell phone.
Now, through your training experience, when a cell phone is seized from a person, what, if anything, is it that you do with regard to that cell phone to preserve the information on?
Well, first thing we do is we put it in airplane mode, and then we give it to a cell phone expert in our office, Trooper Nicholas Garino, and he essentially tries to access the data in that phone once a search warrant is obtained.
Now, as far as putting that cell phone in what you described as airplane mode, what is the purpose of that?
It's to avoid if someone wants to go on a tablet or a laptop and access the information on their phone, and they can start deleting stuff off their iCloud. This prevents that.
So you secure the phone, you secure the vehicle on the tow truck, and then where did you and Sergeant Mechanic go from there?
We follow the tow truck from the address in Dayton to the Canton Police Department. We're secured in the Sallyport Bay.
And if you know approximately what time was it that you arrived at the Canton Police Department and secured the defendant's vehicle in the Sallyport Bay?
So we left Dayton around 4:16 p.m. and arrived in Canton at the police department at approximately 5:31 p.m.
And with reference to the Canton Police Department's Sallyport garage, why was the vehicle taken there?
I wasn't part of that decision, but it's my understanding that it was a heated facility. The other options were, I believe, the barracks in Milton, but that's not large enough to house a vehicle that size, and it's not heated.
And in regard to the heated, what was the sort of purpose or utility of storing it in a heated set?
Miss Reed's vehicle was covered with snow and ice at the time. It was transported from Dayton to Canton.
And with regard to the Sallyport garage area of the Canton Police Department, at some point were you inside that area?
Yes.
And what, if any, observations did you make as far as the temperature or the heating within that facility?
I don't remember the exact, I couldn't put a ballpark on temperature, but it was certainly warmer than outside.
Now, as far as the vehicle was concerned, either on scene, either in Dayton or at the Sallyport garage, or at any point in time that you were in the presence of that vehicle, what, if any, contact did you have? What, if anything, did you do or observe Sergeant Mechanic to do with regard to that damaged area you described on the right rear passenger side?
Yeah, Sergeant Mechanic and I never touched any part of that vehicle.
And as far as the moving it from sort of the tow truck into the Sallyport area, how was that accomplished?
The tow truck driver removed it from the tow truck and pulled it into the Sallyport Bay.
Now, as far as prior to leaving that Sallyport area of the garage where the vehicle was, what, if anything, did you and Sergeant Mechanic do with reference to securing that vehicle or coordinating it off in any way, shape?
We tried to set up a perimeter as best we could using caution tape, just kind of sectioned it off with caution tape.
Now, at some point, you leave the Sallyport area of the Canton Police Station, and where did you go from there?
We had a debrief meeting. So there's other troopers. There's troopers at scene on 34 Fairview Road. There's other troopers conducting interviews. So at the end of the night, members of my office met in a conference room at the Canton Police Department to exchange information as far as what everyone had learned throughout the day.
And as far as that meeting is concerned, that's just troopers from your unit, from your office. Is that correct?
That's correct.
And so there were no members of the Canton Police Department that were present for that. Is that correct?
No, correct.
And do you know why that was?
They had taken a step back from the investigation. They weren't going to participate in any interviews or anything of that nature.
And how was that communicated to you and Sergeant Mechanic?
The best of my recollection was that debrief meeting that we were informed that essentially Canton PD would be taking a step back from the investigation, and that now this is just solely a Norfolk State Police investigation.
So before we get to sort of the debriefing and all that's covered in that, as far as when you're on call, you get a call for any kind of sort of homicide or unattended death or anything like that. You then become what's called a case officer for that investigation. Is that correct?
Correct.
And can you describe for the jury sort of what the duty or the role is of the case officer vis-a-vis the rest of the members of the unit?
So essentially, a case officer is more of a facilitator. You kind of delegate out tasks, coordinate interviews. The case officer isn't the sole decision maker. I have supervisors. I have that we bounce ideas off of. I get feedback from. I also keep them updated. It's a collaborative effort in each investigation. We're a small office, so when a homicide comes in, everyone essentially drops what they're doing, and we all work on it together. So it's a collective effort to work on these cases. And essentially, the case officer is just kind of the record keeper of all the reports that come in and video that comes in. But when it comes down to decision-making time, it's a group effort.
Now, with reference to that collaborative effort that you were just discussing and this sort of debriefing meeting, so there were other troopers doing other things or other tasks throughout the course of the day of the 29th, correct?
Yes.
And so what was sort of the purpose of or not specifically what was discussed, but in general terms, what was discussed during the course of this debriefing?
The taillight piece is found at 34 Fairview Road by CERT. The one sneaker found at 34 Fairview Road. Interviews conducted, and then Sergeant Mechanic and I also shared everything we had kind of learned throughout the day as well.
And that debriefing meeting, if you know about how long approximately did that take in this case?
I can't recall, maybe half hour.
And so following that meeting, where did you go from there?
Sergeant Mechanic and I had secured some evidence, the clothing from Good Samaritan Hospital, the additional sneaker found at 34 Fairview Road, as well as the taillight pieces discovered at 34 Fairview Road, and Mr. O'Keefe's cell phone and Miss Reed's cell phone, and him and I transported those to the office in Canton.
And when you transported them to the office in Canton, what, if anything, did you do with those items?
The 2 cell phones were given to Trooper Nicholas Carino, and the clothing was laid out on top of butcher paper to dry out in our evidence intake area. And then the bag taillight pieces were set aside in the evidence intake processing area. Sergeant Mechanic and I didn't have access to the permanent evidence locker area, so we just secured them in the temporary intake area.
And that leads me to my next question. As far as the area that you're talking about with regard to the clothing items and the other items that you secured beyond the cell phones, that was in a secure area of your office, is that correct?
Correct.
And by secure, I mean restricted access to the troopers within your unit, correct?
Correct. It's you need a key card, and it's also equipped with an alarm.
Now, following that, as far as these items of evidence and other items of evidence that seized throughout the course of an investigation, how is it that they go, or what, if anything, is done, if you know, between the time that they go from this temporary storage area to the permanent storage area?
Yeah, I'm not an evidence officer. I never have been. My understanding is once it's in the evidence processing area, it gets put into the permanent evidence room that only, like I said, two troopers and the detective lieutenant have access to. And it's the evidence officer's responsibility to process that material when they see fit.
Now, sir, if I could turn your attention to February 1st of 2022, were you working in regard to this investigation on that day as well?
Yes.
And at some point, did you have occasion to go back to the Canton Police Department, specifically in the Sally Port Garage area?
I did.
And what was the purpose of you going out to the Sally Port Garage on that?
Pursuant to a search warrant, we were processing Miss Reed's Lexus SUV.
And when you say we, who, if anyone else, was present with you, or who, if anyone else, did you contact in reference to the processing pursuant to that search warrant of the defendant's vehicle?
So we had a chemist from the State Police Lab, Miss Maureen Hartnett, as well as a trooper from Crime Scene Services, Trooper Zachary Clark. And then later in the day, the accident recon team, Trooper Joe Paul, had arrived as well.
Now, if I could just ask you a couple questions in regard to Crime Scene Services section. Can you describe for the jury sort of what their role is in regard to investigations that you do and how they're sort of contacted?
So in any scene, if it's required for it to be documented, Crime Scene Services will arrive. They'll document the scene with photographs. In more serious situations, in a homicide, for instance, they'll actually take video as well as dust fingerprints.
Now, with respect to this particular investigation, there were a number of different areas or different times when Crime Scene Services was contacted to document things, correct?
Yes.
And that would include a Good Samaritan when you observed injuries to Mr. O'Keefe?
Correct.
That would include the autopsy that was performed to Mr. O'Keefe?
Yes.
That would include February 1st in the Sally Port Garage when the search warrant was executed on the defendant's vehicle?
Correct.
That would include subsequent searches that occurred at Fairview Road, is that correct?
Yes.
And with respect to each of those instances, if you know, was it ever the same trooper from Crime Scene Services section that came out and memorialized each of those respective areas?
Yeah, it was a different trooper each time.
And is that something that you or any member of your unit has any control over whatsoever as far as who shows up from Crime Scene Services to memorialize or document a scene?
No.
Now, with respect to the search warrant execution on February 1st, what I want to ask is between the time that you were in the garage on January 29th, 2022, and the time that you're there for the search warrant execution on February 1st, had you been in that Sally Port area of the Canton Police Station at any time in between?
No.
Now, with respect to the taillight area on the passenger side of the defendant's vehicle, what if any differences or what if anything do you note sort of between your observations of the taillight on the 29th versus your observations on February 1st?
Yeah, the only difference from the 29th to the 1st was snow and ice had melted from the taillight.
So as far as the condition of that particular taillight, was it in essentially the same condition that you observed it on the 29th when you observed it on the 1st?
Yes, it was still broken and large pieces missing from it.
But as far as the broken status of it and the pieces that were missing, was it any more broken or any more pieces missing from it when you saw it on the 1st versus when you saw it on the 29th?
No.
And with respect to the taillight housing for that vehicle on that particular day, what if anything happened with it on that day, if you know?
The state police chemist, Ms. Hartnett, had it removed, which she brought to the lab herself.
So she had it removed it herself, and then physically took it with her when she left to the lab?
Yeah, it was with the assistance of a Canton police officer who had an auto body shop, so he's kind of well versed in cars, so he was able to assist the chemist with removing the housing unit.
Now, at any point in time on that day of February 1st, 2022, did you come into contact physically or otherwise with that tail light? Did you handle it in any way, shape, or form?
No.
Your Honor, if I may, with the court's permission, I would request to publish. Give me one moment, Your Honor. If I may have one moment, Your Honor.
Yes.
My apologies, Your Honor. With the court's permission, if I could publish a portion of Exhibit 34.
Okay.
The Sally Port video. Ms. Gilman, if I could have from February 1st, 2022. At approximately 9:12 a.m. You can just pause it right there. Okay. Your Honor, if I may, it may be easier and more visible with this particular video with the lights on.
Okay.
Try that.
Sure.
Trooper Proctor, directing your attention to what's up on the screen is Exhibit 34. Do you recognize what's depicted on the screen?
Yes, that's the Sally Port area, Canton Police Department, and Miss Reed's Lexus kind of roped off with yellow caution tape.
And this is the execution of that search warrant that you were speaking about before, as far as your presence and some of the other members of the state police and state police lab that you were talking about.
Correct.
And this gentleman, if you could run from here for just a minute. So while this is going, if I could just ask a couple questions as far as people within this video, do you recognize anyone in this video?
Yeah, myself, kind of the top of the screen. Trooper Zach Clark, we the one with the camera taking photographs of the vehicle.
Now, with reference to this video from the Sally Port Garage of Canton Police Department, what, if anything, did you learn over the course of this in regard to how that video is recorded or how it's, what, if anything, sort of activates that video?
Objection.
Ask it differently, Mr. Willoughby.
As far as this video is concerned, is this one continuous time frame that we're looking at, or how is it?
Objection.
Sustain.
My understanding, it's motion
That
active.
means you can't answer.
Oh, I'm sorry.
You can ask it different.
I'm not sure there's anything said.
No.
Oh, right. I'll strike if there was anything. But Mr. Lally, just ask a question, please.
With respect to this video, as far as the recording is set up, how is that activated, or how does it record?
Objection. Same question.
Yeah. How does he know that? It's sustained.
Have you watched this video or other videos from the Canton Police Department, Sally Port Garage?
Yes.
What, if anything, did you note with regard to timing? As far there's a timestamp on the video, is that correct?
Yes.
What, if anything, did you note with regard to the timestamp on this video or the other videos that you observed with regard to how time moves throughout the video?
The timestamp on the video tends to pause, indicating it's motion activated.
It tends to pause. I'll strike after that.
So I think it was running for about 9:24.
Joe, that's a very good question. Where are those pictures? I'm assuming that's, oops, they're gone. That's what the defense has said. Yeah, I saw that, guys. Updates on Brian Steele, man. I didn't realize his wife was an attorney. The appeal's already been filed, dude. Like, everybody's going to war with Glanville. If Glanville was smart, he'd bail now. I'm sure he's sitting there thinking, what the fuck did I do? But too late now.
Ms. Gomez, you can take that. Thank you very much. Now, Trooper, with regard to that taillight that was then taken by Ms. Hartnett to the lab, is that correct?
Yes.
And at some point, that was returned to the custody of the state police, your detective unit?
Correct.
And do you have that taillight housing with you today in court?
I do.
And Your Honor, with the court's permission, if the trooper could retrieve that?
Okay.
Perhaps, may I approach, Your Honor?
Yes.
Probably be easier that way. Sir, you can stay right there. Sir, do you recognize that?
Yes.
And what do you recognize that?
I recognize that to be the housing unit.
And as far as you're recognizing the housing unit, is there any sort of denotation or anything on the outside of that box indicating what's contained therein?
There's a state police crime lab sticker with the number associated with it. It also indicates fragile, and evidence tape that is initialed and dated as well when it's sealed up. And it's the sticker also says passenger side TA, indicating taillight.
Thank you, sir. Your Honor, with the court's permission, I would seek to admit and introduce that as the next exhibit.
Do you want it out of the box first, Mr. Jackson?
We could just take a quick look at
Sure.
it. Sure.
With the court's permission, if
Yes.
Thank you, sir. And Trooper, you can go ahead and put that back in the box. Thank you very much.
Paper bag ASMR.
We need to
Paper
mark
bag
that. And
ASMR.
we're going to mark it
Yeah,
twice,
we
folks. We're
love it.
going to mark the bag within the box, and we'll mark the box as well. Thank you. Nancy.
I'm sorry, Trooper, if you could hand that to Madam Clerk.
Sorry, hold on. So it's going to be 544 and 544A.
You want me to inquire, is the A the light and the 44 is bag?
We're not even putting it right on the light because it's broken.
Understood.
So we're putting 544 on the bag, 544A on the box.
Understood. Thank you.
You put that on the bag, please, sir. $544, 544A. Thank you.
Trooper, with respect to that item that's just been marked as evidence, is that essentially the condition that you observed it in both on January 29th?
Guys, you have to lay the foundation for the evidence to show that it's bagged, show that's chain of custody, and then eventually you could show it to the jury. So there's a process.
On February 1st?
Yes.
Yes.
Your Honor, with the court's permission, if I could ask just to publish what's been marked as Exhibit 147.
Okay.
Trooper Proctor, do you recognize what's up on the screen that's been marked as Exhibit 147?
Yes.
What do you recognize that to be?
That is the right taillight of Miss Reed's Lexus SUV. You can see large pieces of it are missing.
Again, is that the same condition that you observed it both on February 1st as well as January 29th, obviously minus the snow and the ice?
Yeah, minus the snow and ice, sir, yes.
Thanks. Mr. Lynn, you can take that down, Mr. Officer. You can have the lights back up. Thank you. Now, if I could turn your attention to February 3rd of 2022. In the morning hours of that date, where did you go in regard to this investigation?
Sergeant Mechanic, Trooper David Achico, and myself went to 34 Fairview Road along with Trooper Evan Brandt from Crime Scene Services to essentially dig out the snow in pursuit for more evidence.
Now, as far as you mentioned, as far as dig out the snow in pursuit of other evidence, what, if any, tools or implements did you and the other troopers bring with you in order to effectuate that on February 3rd?
We just had kind of standard snow shovels.
And with respect to that, as far as going back to 34 Fairview Road, and let me clarify as far as that's concerned. Prior to that date of February 3rd, 2022, had you been to 34 Fairview Road at any point in time in the course of your investigation?
No.
So that morning of February 3rd, that's the first time that you went?
Correct.
Now, with respect to, is that, how many times did you go to the area of 34 Fairview Road over the course of the next sort of days and weeks in regard to potential recovery of items?
So February 3rd, I retrieved items on the 8th, the 11th, and 18th, and was out there on the 10th with Sergeant Mechanic as well.
Now, as far as any of those occasions that you just described, that you went to the area of 34 Fairview Road, on any of those occasions, were you by yourself?
No.
And with respect to those other occasions, what type of people or who was with you? I know you've mentioned on the 3rd, but beyond the 3rd, those other occasions that you described, who was with you?
On the 18th, I believe it was Trooper Chico, based on the handwriting on the evidence bag. Kind of recognized his handwriting. And the other 2 dates, I don't recall who was out there with me.
Now, with respect to items that were located, starting with the 3rd, do you recall specifically what, if any, items were located on the 3rd?
We've located a black drinking straw, consistent with the one seen in the waterfall video of Mr. O'Keefe walking out of the bar holding the glass. We located his hat that had the American flag that was deep underneath the snow. As we were digging, we discovered that. We further discovered other pieces of plastic as well.
Now, as far as these return trips on successive dates to 34 Fairview Road, what was the reasoning behind that, or what was sort of the plan in reference to why were there so many different dates that you returned to 34 Fairview Road with other troopers?
So after the 29th, there was close to 2 feet of snow that had fallen. And in the days and weeks that had followed, the temperatures ranged from 30 degrees up to 60 degrees. And there was about a half a dozen days mixed in of heavy rain. So as the snow started to melt, more evidence started to present itself.
So there were items that you recovered on the 3rd and then items you recovered on successive dates that weren't visible or you didn't see on the 3rd, correct?
Correct.
Now, if I could, keeping you on February 3rd, you mentioned that there was a Trooper Evan Brent that was present with you during the search on that day as well?
Yes.
Now, in addition to going to 34 Fairview Road, where else did yourself and Trooper Brent go on that particular day?
We traveled to One Meadows Ave, Mr. O'Keefe's residence.
And is that the first time that you had been to One Meadows Ave, or Mr. O'Keefe's residence?
Yes.
Now, with respect to that residence, why is it that you and Trooper Brent went there on February 3rd?
We wanted to document Mr. O'Keefe's vehicle to show that there's no damage to it, as well as the garage doors.
And why did you want to document that?
During the review of Mr. O'Keefe's ring video, particularly the one above the garage that displays the driveway, on the 29th at approximately 5:07 a.m., Ms. Reed's pulling her vehicle out of the garage door, backing up towards Mr. O'Keefe's vehicle, and comes extremely close, if not slightly hitting the vehicle. So we want to at least go document that there was no damage to Mr. O'Keefe's car.
And Your Honor, with the court's permission, if I could publish that for the jury as far as what's been marked as Exhibit 6, video 153.
Okay.
Trooper Proctor, with regard to this ring video, how was this obtained, if you know?
So we first observed it through Mr. O'Keefe's cell phone on the Ring app, and then I wrote a search warrant for Ring itself.
And as far as the videos that you received from Ring, did they match what was on or what was viewable the Ring app on Mr. O'Keefe's cell?
The videos on Mr. O'Keefe's app, yes, it was what Ring produced, matched.
So as far as any videos that were present that you received pursuant to the search warrant, or any videos that were not present, that was consistent with what you observed on Mr. O'Keefe's app on his phone?
Yes.
Now, Ms. Gilman, if you could press play through here. Now, Trooper Proctor, with regard to this video, you've seen this before, is that correct?
Yes.
Now, at the point from this video, are you able to discern who the operator of that vehicle is?
Based off the attire, Ms. Reed driving.
Now, with respect to when that vehicle, the defendant's vehicle, if you could, there's a laser pointer up there in front of you on the desk. If you could, I would just ask you to draw the jury's attention to what, if any, vehicles you observe in this video and whose vehicles you believe them.
So right there, it's Mr. O'Keefe's vehicle and Ms. Reed's vehicle.
Now, as far as when those vehicles come close or come into contact with each other, as far as Mr. O'Keefe's vehicle is concerned, what, if anything, do you observe like on Mr. O'Keefe's vehicle at the time?
There's some snow. You can see on the back window here, the bumper and the windows here is starting to be covered in snow.
And as far as when that vehicle comes close to or makes contact with Mr. O'Keefe's vehicle, what, if anything, do you observe the snow come off of the car at that point?
I do not know.
Now, with reference to the back area of Mr. O'Keefe's vehicle, specifically in the area of the ground, as far as that area on the ground, what, if anything, did you observe in reference to any red pieces or any pieces of taillight or plastic or glass or anything in that area that you observed on this video?
So this area here is, you can see the white snow. There's no red pieces of taillight, which would show up in the contrast of the white snow.
Please tell me if you could run a for a moment. Now, as far as the damage area that you were discussing previous that you observed in the January 29th in the Sally Port, February 1st in the Sally Port, and then the item that was just marked as evidence, what, if anything, do you observe in the right rear passenger side taillight area of the defendant's vehicle from this video?
You can see the inconsistent lighting. If you compare it to the left versus the right, there's a gap right there.
If what you observed from that video, does that appear to be consistent with what you observed on January 29th at the Canton Police Department, February 1st, and in the item of evidence that was just marked?
Yes.
Thank you. Ms. Gilman, you can take that down. Mr. Officer, we can have the lights back on. Thank you. Now, sir, you proceeded to One Meadows Ave for the first time on February 3rd. Is that correct?
Correct.
And Trooper Brent from Crime Scene was with you and took some photographs. Is that correct?
Yes.
May I approach?
Yes.
So, Trooper, I'm showing you a set of 10 photographs. Ask you to view those, look up when you're finished. Trooper, just generally speaking, do you recognize what's depicted in those photographs?
Yes.
And what do you recognize them to?
The first picture is the front door of Mr. O'Keefe's house, and it's also Mr. O'Keefe's Chevy Traverse.
May I approach, Ron?
Yes.
I'm up to introduce and admit as the next 10 exhibit.
No objection.
Okay.
5:45 to 5:54.
Thank you.
Your Honor, with the court's
Might be
permission, if I could
happening in the Young Thug
just
trial.
have permission to publish just a few of those photos for the jury.
Okay.
Ms. Gilman, if I could have photograph 7752. Trooper Proctor, do you recognize what's up on the screen? It's now marked as exhibit 546.
Yes, Mr. O'Keefe's Chevy Traverse vehicle.
And with respect to this particular foreground here, if you could describe to the jury what we're looking at there.
So that is Mr. O'Keefe's driveway. You see two garage doors there that lead into the house. And above those garage doors is the Ring camera.
With respect to the rear of Mr. O'Keefe's vehicle, from your viewing of the video from Exhibit 6, from the Ring video, video number 153, if you could, using that laser pointer, direct the jury's attention to where it is on this vehicle that there's contact, if any, between this Reed's vehicle and Mr. O'Keefe's.
It would have been in this general area here.
And as far as your observations on that date,
What's the, hold on.
Maybe approach, please.
Okay.
All right, guys. So do you guys want to, we need to switch over to what's going on with Young Thug because some shit just going down. Holy cow. All right, we're switching over real quick. This has to be dealt with. What channel is this? Fox 5 Atlanta. Actually, you know what? We're going to hold on because so the guy that was in custody, the guy who failed to testify, is being released. Shocker. Shocker. But I don't know what they're doing about Brian Steele. We'll find out in a second. We'll keep going Karen Reed, though. All right, chat. We're gonna go ahead and do this. We're gonna go switch over to this real quick. This is epic. So well, here.
Kind of tells
Okay.
you you're able to authorize
go.
you to do that.
Let's catch up here. So here we go.
All right, Mr. Copeland. Sir, over here. Over here. It's me. The state has filed an order of request asking that you be relieved of your custodial portion of this particular contempt on the condition that you just continue to come back and give your testimony, okay?
That's
So,
exactly what Brian
I
Steele
will
said was going to
release
happen.
you from the custodial portion as long as you come back tomorrow morning. Fair enough? If you're not willing to do that, I'm going to leave you where you are. So the choice is yours, sir. The state's asked me to sign the order saying, hey, if you'll come back tomorrow morning, all I want to know is if that's the case.
I'll be back.
All right, 9:30 tomorrow morning, okay?
All right.
All right. All right, we can let Mr. Copeland be released and processed. Say again? Yes.
I'm weak, man. Y'all can speak to me when I get out.
Can you go back there? Right. You can see him right there. All right.
That order, I'll go ahead and sign it and
Such
I'll also make
bullshit.
a copy of it as the next.
Steele
course of
confirmed they
order,
were telling the
and we'll
truth, that he knew what was going on there.
this evening, okay? All right.
Cedar Rose, we're going to be back to Karen Reed in a minute. This judge is in deep shit, and I don't think he understands that, or he's flailing.
This information to you.
Unbeknownst to me, Gactyl is here, but they're not being allowed into your courtroom. I presume they're outside. So I'll wait on them to come.
I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
Well, I didn't call them, but.
Okay, I mean, and that's,
Let me just finish.
okay.
Because you said to me that you figured out somebody told me this information and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just.
Or they're not in your courtroom.
We just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that will fill up our benches at this point in time, that won't violate our security protocols, but that 8H is available. And they're
8H
He's entitled to have counsel. You're accusing him of committing a crime.
then has to have right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right. Well, we'll let Miss Merchant in. That's fine.
Ashley Merchant.
Yeah,
Ashley Merchant, baby. Let's go, chat. Let's go.
All right. Miss Merchant, good to see you as usual.
Some ass.
I have told your client, you represent Mr. Steele, is that correct? Yes. For the purposes of the contempt, I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedeas bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court and is very.
Once again, it's not what they did. It's about what you did. It doesn't matter where he learned it. All that matters is you fucked this up. You broke all the fucking rules. You got to fucking take it like a man and fucking bail. But guys, it's not only that he is a judge, but he's a general officer. He's a brigadier general in the Army Reserve. So he's definitely pompous as fuck. He's got that air of him. How dare you accuse me? He better be fucking scared. And I don't think he realizes how fucked he is.
Since it was a ex parte communication, we won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
Get him. Get him.
Judge, can you come up to the microphone? Sorry.
Please.
Where would you like this?
Microphone, it'll pick up, madam.
Thank you so much. Just for the record, Ashley.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
And with criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
Conversation.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And
well, no,
notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215.
215.
Georgia App.
Georgia App.
372.
Okay.
Also 215. Georgia App 349.
Okay.
That's Adams and Hasty.
Baby girl came in hot. She's just like, she fucking tooled up. Let's go, girlfriend. Ashley Merkin's coming for that ass. Every defensive.
You have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding. So most of the cases are a little bit older. But I do have other.
Uh-oh. Oh, chat. He needs to back down. It's too late. It's too late. Nope. Judge can't just say never mind now.
Judge,
nope.
I'm not the only one here.
Nope.
Too late. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I have space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H and they can certainly watch the proceedings from there.
Securitize my
And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
They still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom. So we would ask that they be allowed
I
to.
don't want them in my jury box, okay? No.
I understand.
What a pussy. Pussy Glanville. fucking pussy-lipped.
May one additional attorney come in, then Alex Susser. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
He's allowed to have counsel. You can't deny it.
Yeah, I certainly may, sure.
Great. Alex
His
Susser.
right to counsel.
Alex Susser. Thank you, Judge.
Now, guys, you're wondering, hold on.
Henry
here.
Adams,
Every defense bar has a strike
it has
force.
two issues. One is
And the strike force is basically a team of fucking attorneys. If shit goes down, they got your back. Shit like this happens, they will show up. They're all over the state, and they will rally and show up ASAP. They drop what they're doing and show up. And there's enough of them that that's what this does.
the motion for disqualification. Okay. And that's
Senga girl, you're right. Oh my God. This is fucking appropriate. It's raining fucking sharks right now. It's
and I
raining
think
sharks.
the judge went ahead and did some other things that caused there to be that issue presented. So I'm open, Adam. I'm gonna take a look at the other case. That was Henry Adams. That was 215 Georgia 372. I'm gonna
Yes.
look at the other case just a second.
And there's several others when you're ready.
Okay, J-Rock. Okay. Okay. No, I'm not that good. I'd like to be at some point, but not right now. I'd help out wherever I could, though. Let's skip ahead for the dead space. Also, guys, if you are here and you are new, 369 people watching, I apologize. We stopped Karen Reed because in the Young Thug trial, one of the attorneys, Young Thug's lead attorney, has been held in criminal contempt and has spent a little bit of time in the back. And the judge is threatening to jail him for the night if he doesn't provide information to an illegal ex parte conversation had between the judge, the prosecutors, and a witness. And the defense was never told about it. So the judge is being a little bitch right now. Also, hello, J-Rock.
Yes. It may be one I have too.
It's day 88 of a trial that started in November. Hobby's saying, could the judge do this? Isn't this misconduct? Yes. This is misconduct of the highest order. Misconduct of the highest order. He might lose his seat for this. This is really fucking bad. Like, this is bad. This is bad. And there's no backing out now, chat. The judge is stuck. He's already fucking fired a cruise missile. It's too late to say it was a practice or say, oops. Like, he's committed. He's fully committed the moment he went down this road.
Hasty's conduct didn't rise to a level in this thing warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So I distinguish your two cases that you've given me thus far.
Oh, those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also.
You said 279 Georgia what? I'm sorry?
Georgia 13.
Georgia 13?
Mm-hmm. It's a 2005 case.
Right.
And it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
I'll open your present tonight.
See, but you all are covering under Let me see.
I'm sorry, Judge.
Hold on. Just a second. Pardon me.
Yep, guys, this Ashley Merkant, she is from the Trump case, and she's the president of the Georgia Association of Criminal Defense Lawyers. He's Dunsky, chat. This is it. This is Euro Glanville's death ride. Everybody that's new here, yes, we are covering the contempt hearing for Brian Steele, Young Thug's lead attorney. He is being held in contempt for not revealing how he learned the court committed an illegal ex parte communication with a witness.
The contempt is directed. Trial court has the power after conforting the contempt door to opportunity
Yes,
to
she has
speak in his
single
own
video,
behalf.
yes.
Announce punishment
She's very well
summarily
endowed,
without
very
further
good at
notice
what
of
she
hearing.
does.
I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm going to disagree with you. Okay.
I believe that the court has put him in that position.
No,
he cannot be held in the law states McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody. It goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him this to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them. by nature.
Okay. well,
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also
But you got the
summarily hold them in
information,
contempt.
but here's the thing. You got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay. I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute, but I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt.
You're a fucking
At
idiot.
this point in time, is there anything else you want to tell me?
Yes, Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness.
Exactly.
You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that.
Oh, you bitch.
Anything else?
No, we'll file a notice of appeal.
Okay.
We have the order reduced in writing.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact,
Yes, this case is all done. No.
has filed, and I will.
Have you ever seen a dumb fuck literally implode a case because his pussy got hurt? Here you go. He fucked around, he got in trouble, and he got mad. Case is done. This case is toast. It's done.
Note this is part for the record. In this case,
This is it. Well, the prosecutors did it too.
he's filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
Just the case law on that is in
hold
Ray Hughes.
on.
Right.
The superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, and that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that, in fact, I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of law.
It is. Hold on. One second.
Wow. Wow.
Give you two cases. One is it's Untema. It's UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there's another case that I'd invite your attention to, and that is Henry Syverson. It's SYVERTSON, and that is 368 Georgia Appeals, Georgia App, I should say, 865. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant him a supersedious.
And so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he, when he tells me what the basis of the conversation was, who, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil,
Judge. That's civil contempt. That's civil. And that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client.
Paramount.
So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk.
You can't violate confidentiality like this.
That is an untenable position to be in.
Hard.
And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story.
I'm not doing that. The reason being is because that that takes away the whole point of criminal contempt. And that is, you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who the person. Okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out. I'm gonna think about it.
Thank you.
Okay, all right. So we'll be in recess about 5 minutes.
Oh, we're taking a 5-minute break. We're taking a 5-minute break. I think someone, you smell that, chat? Smells like pussy in that courtroom, and it ain't coming from Ashley Merkant. We're taking a 5-minute break. Yeah, he's gonna go make a phone call. That's the thing though. This is an abuse of power, chat. This is truly, you like watching What the Hell is a judge is running amok. This is a judge running amok. Unchecked power. And his power is he's unmoored. It's a barge floating loose on the river about to plow into a bridge. His power is completely unmoored at this point. Stephen Cooper says, I don't think this judge knows what contempt is. He just doesn't like being told no. And yes, Holy Ralph of Male Empire says 5 minutes to consult ChatGPT. Oh, I could see that. I could totally see that right now. Yes, this is a Cope recess. This is Copenhagen. Yeah, he's going to call in a bomb threat. He's going to go outside and pull the fire alarm. Everybody go outside. I guess we'll do it tomorrow. His last 5 minutes of freedom. Jeff says his boss better set him straight. He doesn't have a boss. He's a judge. J-Rock says criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish the disobedience of its orders. Yes. But he does have the right to appeal. The judge is saying he doesn't. He does have the right to appeal it. There's a couple things he didn't do right here, so are not so good. Yes, civil contempt is different. And civil contempt, guys, is normally stuff that happens. I think we mentioned this before. There's criminal. There's two types of contempt. Civil contempt, criminal contempt. Civil contempt, this one here, you do something outside of court, or you didn't comply with something. You're told to show cause. Okay. Criminal contempt is like you come in there and you tell the judge, fuck off. Or you were like, let's say you pulled your dick out. Or you just completely broke the rules of ethics in front of the judge. They could hold you in contempt. And that's where we are. This judge believes that Brian Steele broke the rules in his presence. So that's criminal contempt, direct contempt. And he's allowed to discipline if it really was contempt. The problem is it's not contempt. Is he a diversity judge? No. He is actually a retired brigadier general in the JAG Corps. So he's not a fucking idiot. It's just, I think his emotions got a little bit better of him. He got a little antsy in his pantsies. And he just can't handle his shit. It's easy. Like once you start fucking up and you start doubling down, it's really hard to stop. You can't get past his own pride, pretty much. How dare you tell me no? Well, he just fucking did. And now the problem is, guys, it's too late. There is no stopping this. This is like a nuclear missile. It got fired. There is no you can't recall it. He did this. He's stuck. You're along for the ride now. J-Rock says in the damn head notes of the case the judge cited. Yeah. What are you saying? Sorry, J-Rock. I think I missed something here. Sorry. Yes, suffer. The judge is about to suffer. Ashley has a gotcha bitch moment. Oh yeah, she's gonna take down a judge in there. J-Rock says Henry Hughes order holding attorney contempt pursuant to the Georgia statutes. Otherwise, was improper because inter alia trial court immediately imposed punishment and did provide the opportunity to speak on his or her behalf. Well, he did allow him to speak. Further, the attorney was not put on notice that continuation would have constituted contempt. He did actually do all that. He let Brian Steele talk earlier. But I still think he's in trouble. SB Sellers has still got to be a chief judge, though. Nope. Okay, so the way it would work in a courthouse like this, you're gonna have a presiding judge who's like in charge of like the courthouse stuff from time to time, and like all the emergency stuff comes to them. That's the presiding judge. But he has no authority over the other judges and their dockets like that. The Court of Appeals is the only people that have authority over him. J-Rock says Court of Hughes, the Georgia Court of Appeals, First Division, July 14, 2009. So it's 299 Georgia Appellate 66. Those are citations there, chat. The judge is in contempt. The judge is violating the rules of professional conduct. This is civil contempt. Yeah, I would argue it's, you know what, J-Rock, that's actually a fair point. This happened outside the presence of court. This happened outside the presence of the court. I think I get. Yeah, you're right. This is civil. This is civil. So, Squizcar is saying, what is his ability to have been a judge advocate general have his ability to do a civilian judge? Well, I mean, he's not just some jack off that was doing like ambulance chasing. He does have some expertise. He does have some knowledge. It's hard to advance through the JAG Corps. It's hard to get into it. They don't just let anybody in there. Like I applied for the JAG Corps in law school and I was a lot skinnier then. They still didn't take me. It's not easy to get into. It's not easy to advance through it. So that's just the point. Yes, J-Rock. Yes, the distinction between civil and criminal. Yes. Have I ever seen anything like this? No. Not like this. No. Nope. This is Revan is saying, is it not a practicing judge? No, he's actually got like Judge Glanville. Yeah, no, he's got an accomplished record. Yeah, okay. Well, actually, you wanted hear something funny, chat? He is the chief judge. So you guys were like, they should go to the boss judge. He is the boss judge. So he's been a judge since 2005. Since 2022 to present, he's the chief judge of the Atlanta Judicial Circuit. And from 1995 to 2004, he's a magistrate. He has his master's from the U.S. Army War College. His Juris Doctor is from the University of Georgia. He got his bachelor's in history from Georgia in 1984. He's a brigadier general in the United States Army Court of Criminal Appeals, which that's not easy to get onto. He was the commanding general in the NATO support of the rule of law / the support mission and the rule of law field group out in Afghanistan. So he was the leading attorney out there that was advising NATO on what the rules of war, the laws of armed conflict are, which those are pretty important. Geneva Convention compliance. So he's got experience. He was a senior trial prosecutor in the solicitor's office in DeKalb County. He was a senior prosecutor in the JAG Corps. He was a defense attorney. And this is the other side of the JAG Corps, the U.S. Army Trial Defense Service. So, I mean, he's done shit. He's not just a mope. And if he's a brigadier general, that's a career thing, which he probably did out of law school. That's a 30-year career there in the military. So, there you guys. You wanted to know about him. There you go. There you go. So, he's not a rum-dum. And I wouldn't call him a diversity hire. This judge and Barnes will be big buddies, yes. Yes. Your Honor, I have a right to sneed! Yes. Oh, great, a NATO fag. Well, like Kaz, if he got deployed as, but yes, the U.S. military is part of NATO. He's not NAFO. He was in NATO. So, guys, here's what happened. Earlier today, so yesterday, a guy in Young Thug's trial was testifying, and he said, "Fuck y'all, I ain't talking." He was given immunity, and he still said, "Fuck y'all, I ain't talking." So the judge held him in contempt and took him to jail. This morning, there was an ex parte communication, meaning a meeting between one side of the aisle, meaning the prosecutor, and the judge, which is already a no-no, and that witness and his defense attorney. And the defense was not invited to that meeting. And Brian Steele found out about that meeting, probably either through the attorney who was there representing his client, or if the defendant or that guy himself got word out, the witness got word out that this happened. And the gist of that meeting was an allegation that depending on how well you testify, you get to go home today. Shocker, the guy went home today because he testified and complied. Brian Steele confronted Judge Glanville about that, and Judge Glanville's first words weren't, "You're right, I was wrong about that." His first question was, "Who told you about that?" Ex parte communications like this are a massive violation of the rules of ethics. Massive. More importantly, this witness had already been sworn in. Once a witness is sworn in on the stand, you can't communicate with them like that. No one's allowed to talk about any substantive matters, and they did. So this is a whole big mess of fuck the judge and the prosecutor created, and Brian Steele found out about it and called him out and said, "This is bullshit." And Judge Glanville held him in contempt for not telling him what happened and how did he find out. And that's where we are. Brian Steele was taken into the back. The judge said, "Fine, you're getting cuffed up." He had him taken to the back for about 15 minutes. And then had him brought back out because, Young Thug's missing his attorney. So the judge said, "Fine, I'll give you till the end of the day to tell me what happened." And Brian Steele is still not saying who did it. He's staying an OG. And all these attorneys showed up to defend him. So, yeah. That's how we are. Judge is about to get felted. Not right now, but the Court of Appeals will felt his ass. Cassie, that doesn't make it any better. Okay, fine. Answer this question, Steele. Who said it, Steele? Yeah. And Steele's no snitch, and Steele can't talk. Brian Steele has an obligation under the Georgia Rules of Professional Conduct. And it's Rule 1.6. Rule 1.6 in every state is confidentiality. Rule 1.6, chat. This is a big fucking deal. Like, if you mess this up, you can get disbarred. You can get disciplined for this. The bar could punish you for violating confidentiality. It is sacrosanct. We are one of the few countries where your confidentiality is paramount. Like, you go to Japan, if you guys have been watching Mindset with the stuff in Japan, there is no such thing as confidentiality. In many other countries, you could be compelled to testify against your client. But the big issue here is Rule 1.6, Comment 5. Okay? And here's the part. Rule 1.6 applies not to merely matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. This was information gained in the representation of his client. It has to be protected. It has to be protected. Because it's for his client's benefit. Do you think this prosecutor will be censured as well? She should. She fucking knew better too. He says Clark v. State is the gold standard in Georgia. Okay. Contempt of court may either be civil or criminal, and civil contempt either direct or indirect. The last time the judge said 10 minutes, it was an hour. Yeah. J-Rock saying a direct criminal contempt relates to contumacious conduct, whether by word or deed. God, that's a $20 word. Committed in the actual presence of the court. Yeah. Steele needs to get to tell the judge in the county stitches get stitches. Yeah, that too. J-Rock says an indirect or constructive contempt consists of the contumacious conduct outside the presence of the court, which amounts to an obstruction of the administration of justice. This doesn't stop them. And as the attorneys pointed out, they kept going. They kept the guy's testimony going and they let him go home. So J-Rock says, all right, no more sites. I'm going to the iPhone now. Oh. Thank you, J-Rock. Great, great friend of the show here. J-Rock has a link to get the attorney from Atlanta version. Joe Biden saying, I can see Sean slowly moving towards the nose guarding sweeping side. It's not good to see, and he's been called. Where the fuck have I been nose guarding? You tell me where I've been nose guarding, chat. Tell me. Tell me where I've been nose guarding. Huh? Tell me where I've been nose guarding. Whoever thinks their nose guarding is fucking high and they're sharing coke with Nick. Whoever thinks I'm nose guarding, nibba, please. Nibba, please. Triggered? Yeah, you're accusing me of sweeping for Nick? Yeah, I'm a little offended by that. Oh, Bella, I don't act like nobody, I don't view anybody as good or bad. I'm just saying. The farm's right about Nick all along. Put on the Baldo. I will never put on the fucking Baldo. You know Nick's in the chat. What else could he do? Well, I know Nick's in this chat. If he's out there, geez, he's got to be balding. Joke's on you, haven't seen my balls in 15 years. Well, I don't need to do that when your mom's there for me. She tells me what's going on. The best part was the 88 trying to stop the judge from going off the rails. Yes. The judge was like saying, Your Honor, come back. Don't let it happen. You're going too hard. Yeah, well, I will say out of this whole thing, Viva's probably the most disappointing fucking person out of all this. Really, of like all the people. Holy shit, that was pathetic to watch. Jarek says, now you know how I feel. Sweep accusations. Well, I'm just saying, man, yours is questionable. Yours is questionable. Oh. Has this trial been super contested the whole time? Yeah. Brad, this is day 88 of the trial, and the trial started in December and November. 88 days in, 6 months later. Oh. Keen says the corn harvest must flow. And yes, it will. And guys, once we get the information about Riley's arrest, we'll talk about it. But for right now, I don't have any of the documentation. What did Viva do? Viva sucked Barnes' dick while Barnes just fucking went off on everybody. Like a fucking retard. And Viva just sits there and laughs at it all. Like, that was a little disappointing from Viva. This has been a long fight. Yeah. This has been a very long 5 minutes. I know. Judge Glanville. Judge Glanville, where are you? Cool Guy 27 says, "You really think someone would do that? You really think someone would do that? Just go on the internet and tell lies." Mhm. What happens if the judge doesn't come back? That would be great. He just like pulls a Homer Simpson. And he just walks out the door of the chambers. He walks into his chambers and he just opens a window and he's like, "Ah!" And he runs out to his car and takes off. Oh, that would be good. That would be good. Oh my God. Oh. The judge is running for the border right now. Yeah, Beaver held Barnes a snack tray. That was the sad part. Like I said, that was that was disappointing. The judge sneaks out. I think the judge sneaked out the back. You can just hear him just and ran into his car and took off. I mean, what else could it be? Have you heard of gunshot in the audio? I mean, I've heard gunshots on audio recordings. Not sure what we're talking about. Hmm. Isn't it like almost 7 o'clock Eastern now? Yeah. Oh, yeah. Yes, it is. It's 6:53 in Hot Atlanta. Yes, it is, chat. Yes, it is. Yes, sir. Yes, sir. 6:53 in Hot Atlanta. It's going to be sitting in Atlantic traffic till 9 p.m. anyway. Jeez. Ninja Bread Man. Is there anything he could do at this point? Nope, it's done. The cake has already been baked. This trial is a disaster. He's introduced reversible error. This trial's fucked no matter what happens. D is saying for $10. I forget to inform you, once a Canadian, always a Canadian. Even if they move to Texas or Florida, they will still be a sweeping Canadian. Source, family who are snow Mexicans. Yep. Yep, that's it. The Court of Appeals is watching this screaming no. Oh, I guarantee you there are judges all over the state screaming no at this. You know. Yeah, what happened to the 5 minutes? Like I said, he's out hiding. He's out like he's texting Nick. Nick, how do I freebase this Coke? He's like, what do I do? What do I do, Nick? He's gonna be texting Nick. Nick's gonna be like, Nick's already out of it. Nick's advice is to throw it on the ground. Yes. He gets presented with the motion to recuse. He's like, throw it on the ground. The shoveler. Yes. So the judge had an ex parte meeting with a witness who was on the stand this morning. With the prosecutor, did not include the defense. The defense attorneys found out about it, and now the defense attorney who found out about it is sitting in jail because he won't tell the judge how he found out about it. Is the judge going to come back with powder on his nose like Nick? Yes. Judge Glanville's going to come back. You know what? Who I hold in contempt? These goddamn Scandinavian incel prudes. I swear to God, they're the reason why this happened. The Scandinavian prudes wiretapped everything. They're the reason behind this trial. Is there anything in this legal? No. This is entirely illegal. He should be getting disciplined by the state bar and the judicial branch. This is fucking awful. So, yes, he'll come back a powder on his nose. It's going to be like Riley, call Nick! Yeah, I'm sure that's going to help. Yes, Fat262, yes. There's been an amicus brief filed by Anime Sucks Copensneed Esquire. To be clear, there's a joke about the judge. The judge is an honorable man. Yes, I understand, J-Rock. I also understand you have to mind your P's and Q's in Georgia. I don't, though. I can say all kinds of shit about him. He might be an honorable man, but he is fucking fagging this up really bad. So, also, chat, apparently, we're going to find out that Nick is acting like a spurg to Keanu Thompson on Thursday. So that'll be fun listening to on Steel Toe when she comes on. So that'll be hilarious. Because it'll be somebody telling Nick no, and Nick will be screaming at him. Nick acting like a spurg? Well, I mean, that picture he took. God. That Keanu woman is a skeleton? Oh, well. Let's see here. Yes, you miss all the shots you don't take. Signed, Gary Plauché. Yes. Maybe Nick will call in. Yes. Well, hold on here. Hold on here. High Place Drifter says, I've won like a pound of silver. Free silver this 2024. Can't always be laughing at the cuck. Furs and power. Hey, Sean. Thanks, man. You're welcome, I guess. I'm not sure what I did to help you get all that silver, but congrats. I did my part. So. Let's see here. Did I catch up on everything? Steven said, I think this judge smoked his breakfast. Yes. 4M says, thanks, Sean. You're very welcome. Thank you for being here. On the FAFO scale, what would you put this at? Like a 30. On a scale 1 to 10, a 30. Steven says, I don't think this judge knows what contempt is. Yeah, that's kind of where we are with this. So, yes, let's see what happens, though. Show us the new Nick pick. All right. Let's see here. Oh, Jimmy, you're saying, yeah, Keanu's an OnlyFans girl? Oh, well. Nick's still a fucking lunatic for screaming at people. What the judges to back down? Well, he's going to get removed from the case. Nick Dev says, did they go through a stress test? No, but I mean, a lot of judges are going to fuck this up. This is the problem. These types of cases are disasters. They shouldn't be tried. And it's gotten the best of him. It's literally gotten to him. But I'm assuming he's pretty good otherwise. But yeah, this broke his brain. And that's the problem with trials like this. Oh. Can he remove himself? Yeah, he can bail right now. He can quit. He can recuse himself right now and disqualify himself if he wants to, but it's too late. He's still going to get in trouble. Ugh. When's my flight to Minnesota? Won't be any good. He won't fucking listen to me, so. I get enough people down here who don't fucking listen to me. I don't need him too. I don't need that. That's not a joke. Just in the back crying. He already broke himself. Oh shit. My bad, chat. We kind of just messed up here. Oh wait, he still hasn't. I had it paused and he still didn't fucking come back. Ah, what a tool. What a fucking toolbox. What a toolbox. He's still not back even though I hit pause. Can you review the 2 new filings of the Whitmer appeal? We'll work on that. We'll work on that at some point, yes. How come this judge can get in trouble, but the judge in the Karen Reed case with an obvious conflict seems not to? Because she's kept her shit under control. Karen saying 24 lawyers showed up for Steele. Oh, 100%, I guarantee you. I guarantee you any attorney who was free and didn't have his kids to take to shit showed up. I mean, like, attorneys legitimately taking their kids to piano practice and swimming practice and stuff. Not like fake swimming practice. You wonder how that went. Like, Nick's like, oh, I gotta take the kids to swim. I gotta take the kids to swimming practice. The kids are like, yay, we're going swimming. He's like, no, you're not. What? Aw. Isn't this just begging for a mistrial? Oh, yes, it's a mistrial. It's a structural failure in the case. You heard I'm representing Nick pro hoc vice. What? Well, oh, you mean pro hack vice? Yes. I'm a pro, he's a hack, and he's got a lot of vices. Or maybe it means I'm a pro, he's a hack, and Vice is going to watch us. Musta says, I know you don't hear this much, but if at all, but I love you. I hear it enough, don't you worry. I'm good. And you deserve to be happy. I think I am pretty happy. Kathy Rustin said at least 15 lawyers are in the gallery now. Oh, I bet they are. They're forcing their way in there. Sean Pro, Nick Hack, Vice live streams. That'd be great. Have a shot on us. What could go wrong? A lot. Am I going to air in Vices? I'll air in everybody. Vice will write an article explaining how this is white supremacy. Yes, they will. What the fuck is that? That was a weird noise. I might have to go check that out. No, I've never been in a case this weird. If I was, you guys would have seen it on TV at some point. Lawyers must love it when they have a judge by the balls. Oh no, they're not enjoying this. I mean, like they're gonna enjoy fighting the fight, but like not for what they're gonna have to do. So all right, yeah, hold on one second, Chad. I'll be right back. I gotta Did not flush my stash, chat. Anyways, come here. Ah. I called. I'm answering the Baldo. Yeah. Well. When's the body cam? Don't know. Some like guys remember. They said it was gonna take like 2 to 3 weeks, so it's gonna take a little while. Cass says, I thought she said you didn't flush. What? No, I didn't go to the bathroom. I just like the dogs were out there playing with something and it was weird. You just a woo for everyone? Aw, that was so cute of you. Thank you, Clyde. Give everybody a woo. You do it again and go woo. That's when he when he stretches. He goes woo. It's so cute. Sean brings Clyde in to light the white powder off his nose. Yes. You missed a little something on the end of your nose, huh? Thank you. Hold on here. There we go. We're all good. Yes, and Joe King Lee, yes, they do it. It's funny. This little discussion they have with the witness, they did it onto the record without defense present, which really is bad for them because if they know it's on the record, they should know that everybody should be present. So there's a lot of problems here for them. And I don't, yeah. Is the judge having an oh shit moment? I think so. I totally think so. I totally think this judge is realizing, uh-oh. I'm sure he's got a fucking phone with like a million messages of like, bro, what are you doing? What the fuck is this? Like, homie, this ain't good. Luke says, let's be real, I'm not doing amphetamines. I know, I'd have to cut that shit with butter to make it work. Miss Sun says, my dog died on her birthday 4 months ago. Well, I'm sorry to hear that. Miss her a lot. She's my best friend. Well, you know what? You should get a new dog. There's all kinds of dogs out there. You might find a dog like Clyde sitting in a shelter. There's some dog out there that needs you. So go get one. Go get another one. Your dog will feel better that knowing that you got a new one anyway. And then that dog will be happy that you picked him out. What happens if the judge doesn't declare a mistrial? Well, they're going to challenge that. They're probably going to try to get him recused. And then otherwise, there's going to be a bunch of shit on appeal. Yes, this is turning into a Nick Rekieta bathroom break. He's going knocking on his friend's door. Yo, how's it like? What are you doing? How you fucking my wife tonight? Hello? When am I starting the gym regimen to beat Nick? Well, I've already started a little bit of it this week. Hopefully by the end of the week, we'll be in full swing. But yes, Nick's going to bulk up. Hold on. Yes. Bulk up. I'm not sure what the fuck that means to him, but fuck, I can get skinnier than he can get straightened out. So we're going to do that. Are the other judges writing him in the back for fucking up? Well, I'm sure they're like, bro, you're ruining this. Stop. I'm sure they're just like begging him, like, please stop. Stop. Did you check to make sure we're not paused again? Yes. We're live. We are live. We're live. Nick says, so what is he going to bulk up? I don't know. Yes, I started by healthily laughing. That was my cardio because that's how funny it was. Got a good core workout. Just almost having it again. Anybody guess on who might have told the lawyer where he doesn't want to say? Probably the attorney for the witness or the witness himself or his people got word out. Nickel started van life to hide the divorce arc. Yeah. So what do you guys... They referenced a she, yeah, but I don't know exactly what it was. Why would it matter who told the defense attorney? It doesn't matter. The judge is just being a dumb fuck and doesn't realize he broke the rules. It doesn't for him, it's the reason that someone violated something he was trying to do. Not that he did anything wrong. So that's the difference here. Yes, and Joe Kingley is right. We did it, but who told you? Two Scoops says the attorney learned through his client. It's privileged. Easy to stand on that. If he learned it at all, it's privileged. Remember, we covered this, Rule 1.6. It applies to not merely matters communicated in confidence, but also information gained, whatever the source. So it's not just things your client tells you, it's things you learn otherwise. All kinds of shit. You get the tea about something, you have to hide it. You can't just give it away. Yeah, I can allow. Anybody can redirect to me. Anybody. Everybody can come in. Everybody. 536 viewers, guys. Yeah. We are waiting to see what happens. So, let's see. After he changes pants, you think he'll come back and just recuse himself? I mean, if he was smart, he'd fucking do it now. But I don't know. I don't know, chat. But I mean, he's literally destroyed this trial. Hold on here. Guys, talking to somebody on Twitter real quick. Hold on. Yeah, guys, I'm just looking at Twitter right now and this is just so bad. Like, there's attorneys that I follow, especially out of Georgia, and these guys are just like losing their fucking minds over this, and I don't blame them. So there has been a motion filed, and we could take a look at that real quick. So this is a motion from the wife, Brian Steele's wife is also an attorney. And this was filed check out the time this thing got filed. 5/16. So it's a motion to set aside contempt. And they're trying to show that he's the counsel of record for Jeffrey Williams, also known as Young Thug. The jury trial commenced January 4th. It is ongoing. Okay, my bad. 88 days in, and we're at June 10th. So the court, along with the prosecutors, engaged in an ex parte hearing with the sworn witness for whom an order of immunity was issued. The witness had previously asserted his Fifth Amendment privilege and was held in contempt. The court and the state admitted the proceedings took place. The attorney for defendant Jeffrey Williams, Brian Steele, commenced proceedings in open court by disclosing the defense had knowledge of the information and demanded the same and proceeded to make a motion for mistrial. Okay. That's all good so far. You can do that. You totally can do that. There's nothing wrong here. And then it just snowballs from here, chat. And they are loading down for bear. You know, the second part of this is the judge wanted to know how Steele came into possession of the information and expressed outrage he knew of it. And now we talked about this here with Rule 1.6, confidentiality of information. That's the big one here, chat. That's the big one. All right. Comment 5 says here, this is the big thing. Rule 1.6 applies to matters not just communicating in confidence, but all information gained, whatever its source. A lawyer may not disclose such information except as authorized by the Georgia Rules of Professional Conduct or other law. So the judge can't force him absent an actual law or some obligation there, and there isn't one. Then we get the next page. And then, yes, that's the point that the court repeatedly demanded he reveal the source, claiming the information was unlawful. Well, it's not really. And Brian Steele declined to provide it. This information was never deemed to be confidential by a court order placed under seal or subject to a protective order like a gag order. So there was no gag order under seal, anything that would stop this from happening. Is the judge busy retaining Ty Beard? Yeah, he's trying to get a telephone notary done. Also, it sounds like some guys from Nick Starro showed up. Hello, everybody. Hello. Get this judge as a guest. Funny boys. Nick Kreuzer is saying Rekieta does not have the will to commit himself to something as initially uncomfortable as fitness. He will fail spectacularly. Well, he's got his heat allergy. Okay. Like you drop him off in the desert, will he just die? I'm dying, it's too hot. The court held Steele in criminal contempt for refusing to provide the information. Based on information and belief, Mr. Steele will decline to disclose the information. Based. The court stated he could only purge the contempt by telling the court where he got information that he shouldn't have had. Well, that's not how that works, Judge. Thus, the court has imposed an illegal and inherently inconsistent punishment. That's some alliteration. Illegal and inherently inconsistent punishment for this criminal contempt. Moreover, the court, now notice, notice the court has been lowercased. That's a sign of disrespect. Because normally you type it, you reference the court you're in front of, it's capital C. So. So the judge, they go here to talk about how should this contempt be done. Where the announcement of punishment is delayed and where the contumacious contact was directed toward the judge, where the judge reacted to the conduct in such manner as to become involved in the controversy, the judge may give the attorney notice of specific charges But the hearing, including the attorney's opportunity to be heard, must be heard by another judge. We didn't have that today. He has not been afforded due process, including a right to notice and be heard. Yeah. And then they cite some case law here that an attorney may not be held in contempt for statements made during court proceedings only after a court has found that the attorney's statements and attendant conduct interfered or imposed an imminent threat of interfering with justice. The attorney knew or should have known that the statements exceeded the outermost bounds of permissible advocacy. And then because contempt is a crime, the evidence must, of course, support these findings beyond a reasonable doubt. Yeah, I don't know if it's going to work. And they say to the extent this court believes contempt is civil, there must be a clear and unequivocal order of the court that Mr. Steele is deemed to violate that needs to be addressed. It certainly cannot be the law that every time a judge asks a question, the failure to answer lands you in jail, especially when counsel has a colorable basis for declining to answer the question. And he does. He does. He has an entirely reasonable basis for answering the question. And it was filed by Colette Resnick Steele. So good for her. Standing by her man. Also, chat, the judge is still not showing up. I think he ran off. Chat. I'm surprised. He got a little scared. Oh. Excuse me, chat. There's also another motion that was filed, or another notice. And that was the notice of appeal. And that was filed a little earlier. They filed that at 4/24. So it's a notice of appeal saying the Georgia Court of Appeals, they're going to order of contempt by the criminal contempt. And they're going to ask for the transcripts of evidence of the proceedings be included. That includes the secret recording of the secret meeting that was had. So we're all going to find out what happened. Which is probably not good for the judge. The Court of Appeals has jurisdiction over this case, and it's June 10th. Colette Resnick Steele. So Steele's got his he's got his boo in there working this. Oh, Nick is saying, meet Ray. Good night, folks. It is 1:22 a.m. there. Well, good night, Nick. Thank you guys for being here. Nick Starro, Trial Watch, guys. You know, he's been covering Young Thug. And, yeah. Always a good time to watch, especially if you want to follow Young Thug. He's covered all the time. Loch Ness Monster says, are we still being a cringe lord over here? When are we not? I mean, it's like you haven't fucking figured me out yet. Come on now. Oh, geez. Nick Ricada, yeah. Judge is gonna say, Nick Ricada told me I could, bitch. I'm sure Nick's gonna say, Nick told me I could urinate on the defendant. All that practice in law out there. Jared looks at the camera and he says, you're all in contempt of court. I hold you in contempt. It's like in Coriolanus with Ray Fiennes. He's like, no, you shun me. I shun you. Is April in the judge's chambers? Yeah, maybe. Is that a meow I heard? What a pussy. Oh, could the judge have his own counsel right now? He could be conferring with his own attorney. I'm assuming he's talking to other judges. Garrett's a potential cringe lord, of course. Of course, I wouldn't have it any other way. Yes, 2 days later, he's going to file a motion. Yes, ladies and gentlemen, I'd like the parties to know that a gentleman named Eric July did this with the help of some meddling children from rural Minnesota. I have not violated anyone's constitutional rights. Signed, Judge Glanville. Clinical decision. Yikes. I've been noticed by Sean Pye. Could the judge have called everyone in chambers to continue discussion and we're all just waiting for nothing? Or can they cut the feed? No, nobody's going into chambers. This is going to be all done on the record. I'm sure the attorneys would say, no, we're doing it on the record. Don't pull this shit. But if everybody was done for the day, the court would have just closed up and gone home. And so would the news guys. Because this is going to be a pain in the ass for them because they're stuck there. Yeah, like, let's see if we can. Yeah, guys, it's still working. I don't know what's going on though. I'm gonna try to do a little more Twitter sleuthing here. See if we can figure some stuff out. Let me see here. Let's see. All right. I mean, guys, like everybody's saying this is fucking insane. It's completely insane. Oh. And while we're talking about insanity, I still understand Nick's hateful legal mindset. Because Nick mindset gets to go around and have fun and fuck all the women he wants, and Nick can't. Or Nick wants to go fuck all the Thai lady boys too. I don't know. He's just upset. Yeah, Long Crime and these other channels are not cutting the feed until ordered, which I think is good for them. This is good stuff. So we do have some Nick things we can look at. If you know what? We're going to A-log Nick Rekieta right now. We're going to A-log it, chat. Uh-oh. I see movement. Uh-oh. Calling it right now. Look at that face. Look at that face, chat. Look at that face. Look at that face. Bitch made. I'm sure he's going to release him right now and be like, you're all good. Calling it now, chat. Calling it now. And he's going to bail. Let's see.
All right, thank you, madam.
Buck broken, yep. That's not a good face.
Yeah.
For you, perhaps. For you. For you. Completely felted. I think so, chat.
That's what we're using.
I think he got felted. Judge pooped. Oh, he got some clarity there. Yeah. Yes, the file rises. The file rises. Yes, the felt is meeting.
Sergeant Brown, is everybody present? Needs to be present? All right, thank you for your patience, counsels. The court's had an opportunity to reflect and,
Listen, he's reflecting. Let's go. He's reflecting on the ball sack on his face. Oh, he reflected like a bitch.
Mr. Steele, if I could ask you to take the podium, please, as well. Now stand next to your attorneys.
Uh-oh, he's gonna give it up. He's gonna give it up. Look at him. Look at him strolling up there.
Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar, Judge.
One more time?
Susar.
What, spell your last name for us?
SUSOR, Sierra, Uniform, Sierra, Oscar.
You're a good man. Good man. Okay, all right. Okay. All right. Thank you, sir. Okay, Mr. Susar as well. All right, counsels, I've made a clarification or to the order of contempt. Mr. Steele, I am going to hold you under, still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. And you may take whatever steps you and your counsel deem appropriate after that. Okay?
You little faggot. You little faggot.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass,
that is
you have my support. I will talk with our sheriff and we may be able to make that work. Okay. If that should occur. Okay. All right. Okay. All right.
Uh-oh.
All right. Is Miss counsels, I'm done with this unless you have anything else. All right. Thank you. Thank you, Miss thank you, Miss Merchant and Mr. Susar.
Thank you.
Okay. All right.
Wow.
Yes. In fact, the clerk is going to file a it's going to be e-filed. It'll be on the e-file system momentarily. You should be able to get a copy of it from there directly, download from there.
Get his
Judge, Ms.
bad
Merchant and I
ass.
will file entries of appearance on behalf of Mr. Steele.
Sure. That would be great. Thank you so much. Okay. All right. All right. State, is there anything else we need to, or any defendants, is there anything else we need to take up before tomorrow morning? Mr. Copeland is going to rejoin us tomorrow morning, so we'll continue with his testimony. Where's Miss Bumpus?
Your Honor, I have a matter.
1 second. Where's Miss Bumpus? She hasn't been released yet.
I'm not certain, and Ms. Hilton is attempting to determine her whereabouts.
Uh-oh. One of the DAs left.
All right,
Uh-oh.
you could call her Miss Hilton. Thank you.
Oh, no.
All right, Mr. Sharp, sir.
Oh, no.
Your Honor, I have to prepare for my cross-examination of Kenneth Copeland over the next few evenings. And I would ask once again for the court to release the transcript of what occurred earlier today so that I may prepare my cross-examination.
I'm not going to do that, sir. Not at this point in time, respectfully. Okay?
You can't do that.
Your Honor,
that's
respectfully,
error.
and
That's not
if it's
legal.
not released by the time that we cross-examine Mr. Copeland, our
do
defense will be hindered. in that
Sure, that'll be an issue you can certainly raise then and that now, but I'll think about it. But at this point, I'm not inclined to release the transcript of the court's ex parte hearing because of the way it was the way it was disseminated. That's why I'm not inclined to do it.
And I would also, I understand the court's ruling. I would also ask for the release of any audio tapes regarding that hearing as well.
Well, the only audio tape that I know of is maintained by Miss Weaver, who tapes her proceedings in order for her to prepare a transcript. So
100% an elite. Well,
okay. Well, I don't know if she may not have any, but we'll see. Okay.
Good evening, Carson Matthews, on behalf of Mr. Cooley. We were making that same request, Your Honor, for that transfer. We believe it potentially could contain some breaking material.
Sure. Okay. All right. Unless there's anything else, counsel?
Tell him to recuse. Tell him to recuse.
I join that, and I also believe I advised the court the reason that I also want for confrontation cross-examination is supposed admissions.
We're live right
Mr.
now.
made
Live.
about our case outside our presence, and based upon information and belief, the court handed Mr. Copeland allegedly the long false swearing and perjury. And if that's true, I'd like to also talk with him, if he'll talk, about how that came about. I'd like to read the transcript. So I'm joining in, but also it goes to matters that are discussed about the case based upon information belief.
Madam.
Your Honor, there was no matter to which
you are now a witness. You are now a witness, prosecutor. They have the right to cross-examine you now.
Either counsel for either of the defendants was a party. There was no matter to which either defendant in this case was a party that was had or held outside this courtroom. So
this right here are two witnesses, W1 and W2, talking to each other about something they both saw and experienced and engaged in. This should not be happening. I'd almost stand up and say, she can't talk to you because she's a witness. Witnesses aren't allowed to confer like this. This is problematic. Seriously, and like I said, I'd like to think I'm saying all the things Ashley. I hope Ashley Merkin and all them are wanting to say all this shit. But hopefully I don't sound like a retard out there, chat. I don't know. I'm trying not to.
we would ask that the court deny what is being requested of the court, because that is something to which neither defendant is entitled.
Entitled.
On the witness stand. The witness is on the witness stand. The witness is testifying under the RICO Act, which covers all of the defendants. It's our understanding upon information belief that that particular witness has stated again on Friday that he was not going to testify. Today, it was a different scenario, and based upon it, we believe that we should be entitled to that on the Brady because we believe it's Brady material.
All right, sir.
And it's covered under the RICO. He's testifying against all of these defendants under RICO. So we all are part of this witness's testimony.
Your Honor, I would additionally point out that the question to which Mr. Copeland asserted a Fifth Amendment privilege was, how old are you?
On Friday.
Yes.
Yeah. All right. I'm going to deny your motion, Mr. At this time, Mr.
It doesn't matter because you guys talked about shit behind closed doors. God knows what you talked about. The allegations are you talked about if you testify, you'll go home. And then also apparently the judge handed him a document relating to the state law and perjury, well, we have a right to see all of that. That's all Brady material. It's all exculpatory. It all leads to bias that he was motivated to testify so he could go home. These guys are asking the right questions. They all need to keep beating the drum right now.
Matthews.
Your Honor, I don't understand the state's argument that we are not a party. This gentleman was sworn in as a witness against all of our clients. He is sworn in as a witness specifically against Mr. Stillwell.
Exactly.
Conversations with that gentleman were occurring apparently ex parte without our knowledge, without my client's presence. And I don't understand how the state with a straight face can possibly say we are not a party to matters concerning a witness sworn in trial to testify against our clients. We are certainly a party.
Okay.
And we were denied the right to be present.
All right. Thank you, sir. I'm still going to deny it. All right. Anything else?
We would ask for a copy of that transcript since it's germane to the contempt. So we will be asking for that in the court order as soon as this court order, since that is.
It's an ex parte matter, so you're not going to get it unless the appellate court wants to see it, if it's accepted. So, but I'm not going to give it to you at this point in time.
I assume the Harvey rule applies.
Yes, sir.
Thank you.
All right. All right. See y'all tomorrow morning, okay? 9:30 for an anticipated 10 o'clock start time? Okay, we're recessed.
Wow. Wow, chat. Wow, 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 wow. Crazy shit, man. Here's the thing. He didn't triple down. He didn't triple down. He gave him till the weekend to start the sentence. That gives him time to kind of wipe his hands of it and let the appellate court take it away from him. That's a bitch out. He bitched out, but he did it like on the down low. He slinked away on his own. Forever Cali Girl, hello. I think you're a new face around here. I want to say hello. Yes, this is some shit. Yes, this is some shit. This is just fucking crazy, guys. This is fucking crazy. Did the prosecutor agree this knowing a mistrial is possible, asked Sven? Throw the case? Well, if they agreed to this, it's prosecutorial misconduct to have an ex parte communication with the once that witness is sworn in, and on Friday he was sworn in, you're not allowed to speak to witnesses. So they engage in prosecutorial misconduct intentionally, then that's a mistrial with prejudice and a dismissal with prejudice. So this is that was fucking disgusting. That was actually a travesty of justice that you guys got to see there. I'm fucking embarrassed. I'm embarrassed that man's an attorney. That man went to law school and he just did that. That is fucking embarrassing. Yes, anyways, I don't understand Nick's legal hate for mindset. It's because legal mindset's dick works and Nick's won't because of all the coke and the drinking. Alex has completely felted. Oh yeah, he just got felted in there. Ag's been a member for 14 months saying the judge pooped. AK says, can the prosecutor be in trouble? 100%. She could get sanctioned for this, but yeah, but like Fanny's not going to fire her. This is Fannie Willis's team. So, Neo Dark Matter says, made us wait an hour for that bitch statement. Yeah. Yep. Yes, going to jail with your client is badass. That is fucking hilarious if they get to sit there and hang out in the pod working on their trial together. And the neat thing is Bryant Steele's going to be like, nobody's going to fuck with them because he's a defense attorney. And they saw him tell the judge to fuck off like that. He's going to, those dudes would fucking shine his shoes in there. It's an illegal hearing. It's unconstitutional what they did. I wouldn't call it illegal, but I get your point. Yeah, it's fair enough to call it illegal. J-Rock says, I did a murder trial with Max back in the day. Max is that bald guy in the back who kept on speaking up. Max is a warrior. Yup. A lot of these guys got fucking good attorneys. Young Thug and Trump. Both cases have really good fucking attorneys in them. They have the best attorneys in the Atlanta area. Sleazy says, but Sean, it's worse in Somalia. Yes. Unhung Hero says, oh, I'm gonna come after all this fun. Well, yeah, don't come. Don't come. And Forever Cali Girl 89, thank you for the sticker. I appreciate it. And then Ghost says the appellate court has the appeal. It was filed. And then the appellate court, here's the thing, kind of like what happened in the Richard Allen case where the judge had that secret transcript she wouldn't release. The appellate courts can demand that, and you will provide it. And they've asked for the transcript, and the appellate court's going to be like, yeah, we should see what happened. And they're going to demand it. And that judge can't tell them to fuck off. So the appellate court's going to throw this out. He'll be fine. He will not set a foot. I could see Brian Steele wanting to set a weekend in the jail just as solidarity for his client, because those guys have been in jail for almost a year and a half now. I could see him still wanting to go, but the Court of Appeals is going to go too fast on ruling on this. He's going to gain so many clients after this. I hope so. Man, Brian Steele's going to go to the mattress like that for you. Oh yeah. Mr. Potato said, would the RICO case be retried? Or would it be considered double jeopardy since they fucked themselves? Oh, this is done. There's no way you can redo this trial. It's a disaster. No, sir, is saying, was it a mistake of the lawyers not to demand the recording was preserved? No, because the judge already admitted there's a transcript and a record of it. So I don't think that's going to work. I don't think it's going to work. There's already acknowledgement that there was a record in place. Is the lawyer's jail time billable hours? Certainly, but if Brian's smart, you'd eat those because that just makes you look like a gangster, so he wouldn't be charging for that. He just became lawyer of the year in the state of Georgia by doing all that. Do you think the judge will get sanctioned? Oh yeah, he's not walking away from this one. This was disgusting. This was an embarrassment. The Court of Appeal, the courts and the governing bodies will punish him appropriately. Ken says, what would happen if a judge ignored appellate or Supreme Court procedure, something like that? What are the consequences? They can be sanctioned. It's not immediate, but they will be punished. They have to follow rules too. And there's always a bigger fish. Yes, he can go anywhere in Atlanta. He'll get free everything. Yes, even free rims. Jesus. But no, I mean, he's going to be like, that's a hero right there. That guy just did some gangster stuff. Like, amazing. Revin says, what possible punishments? He could be removed from the bench. He could be suspended. He could be forced to take CLEs. They could publicly reprimand him, make him write a letter of apology. They could remove him from the bench and say you're no longer a judge. They could suspend his license to practice law. They could disbar him. They could do a lot of things to him. Fanny's wiping all over the place. Yeah. Holy Ralph Mill says he's had a long career. He'll just retire. Doesn't matter. They will go after him. They will take away his judgeship. He will no longer be allowed to be considered a retired judge. They'll strip that from him. They could strip his law license. They will not let you don't get to. It's not like cops where they fuck up and can retire right off into the sunset. The bar and the Supreme Court will sink their claws in you and drag you back to remove your honor. So will this result in a mistrial or is there a wiggle room? No, this is done. This is done. There's no coming back from this. There's no coming back. Because you've got this is bias. This is horrible error. This is done. What are the chances the Court of Appeals rules in his favor? Like 0%. Unless they all have strokes. This is done, guys. This is done. He may have lost judicial immunity. No. Nope. Nope. That is not going to happen. He still has that. He still has that. So, they didn't think they get caught. No, they didn't. They didn't think anybody would find out. Lone Wolf says federal courts don't fuck with ethics. Yes, but we're in state courts. This is not federal court. So they got to file a writ or a summons. I'm thinking they're filing a writ. Well, they're filing a notice of appeal, but I'm assuming they're also putting together like an emergency habeas petition, like a writ of habeas corpus as well. They're probably doing just a regular notice of appeal. The prosecutor's 100% in trouble, in my opinion. They're both in trouble. The judge even more so. Jessica Reloaded says, my inner Ghazni mentor wishes I was in the courtroom to argue with the judge. Yeah. Well, if I was one of the other attorneys, I would have been being more of a belligerent asshole at that point. So, is the ADA going to be sanctioned? No. You think Fanny's going to punish one of her people? Fanny's going to say, good job. MLP says, can it be tried in federal court? I could see that happening. I mean, yes, ultimately, because there's separate sovereigns. But the fact this case... Like, this doesn't meet RICO under federal guidelines. This doesn't meet the federal definition of RICO. So I don't think so. I really doubt it. Lone Wolf, I think he's talking about the federal RICO case for a young thug. I don't think it's going to matter. Gene Hughes saying, I just subscribed the first time here. Love your reactions. Thank you. And coming back for round 2. Well, don't call it a comeback. He's been here for years, chat.
Boy, in and out, man. Hey, I didn't want to, I don't hope I'm not interrupting anything, but.
Did you hear what happened?
So the judge held him in contempt, says he's got to report on the weekends.
That was his way of trying to like skitter out from underneath this, I think.
Yeah. So basically he's expecting for the appellate courts to bail him out.
Well, and yeah, the thing is, though, it's too late, though. Even though that happens, it's...
Well, and then the one lawyer, I was watching a replay just before I signed on your channel, and that is that then the other lawyer says, well, are you going to release the transcript?
Yeah. Once again, he said, nope.
And then the appeal, the interlocutory appeal on the thing says, it's part of the appellate record, so we want it as part of the appeal.
And the appellate court's going to demand it, and he says he'll provide it, so I guess we'll get to see it at some point.
It's a disaster. This
trial's done. This trial's done.
It's a mistrial. It's obviously
mistrial with prejudice. This is an 18 months in the making. These guys have been sitting in jail for 18 months now. Over a year and a half they've been waiting.
This is interesting because double jeopardy bars retrial when you have prosecutorial misconduct.
I'd argue the prosecutor willingly went along with this.
I don't know. It's a harder argument though because it's a judge created error.
Well, no, the prosecutor created error too, though, by willingly doing I think they both have their hands in it.
And then, of course,
because
now
the prosecutor, it sounds like part of the argument is.
See, when you screw up royally, all the issues start flying, and there's another issue of that is denial of counsel. Because it's like, well, you can be sitting there in court, but you weren't going to be able to research over the weekends. You get all your best stuff done on the weekend.
Mm-hmm. Yeah. Well, I think it's funny where he said, if you're going to send me to jail, I want to hang out with my client.
Yeah.
That was so cool.
That was cool.
That was such a smart ass comment.
The defense bench is pretty good over here.
Well, the defense bench, both all those attorneys started fighting. But that's the thing, like the Trump team, like the team in the Trump case, and then these guys, these are like the best attorneys in the city, it looks like, from what I can tell.
How did the bench get? I mean, this guy is just a disaster.
I think he kind of got a little in under. Like, I think any judge would have gotten over their head on this one.
I don't know. I've been in some great judges, and
I know, but I think he he's got a decent background. Well, he's a career, he's made his way through the JAG Corps all the way up. I mean, he's
what people don't realize about.
He's not a schmo.
I'll give you some secrets. Is that a lot of judging is ridiculously boring.
Yes, it is.
And so a lot, most of the day, you're reciting the same freaking thing over and over again. The plea, have you had a chance to consult with your attorney? You fully accept your plea. Blah, 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 blah. Next case. It's like a day's worth of repeating yourself over and over again.
Yeah, and you can get away with being kind of like middling as far as the judge is concerned. You don't have to be very smart.
Right. And you don't have to, it's actually quite a boring job.
Yes.
And the thing is, there's good judges that are into this kind of weed stuff and like really like the techniques and the foundations of trial, but a lot of them can get away with not knowing that and still being a judge.
Yeah. I mean, there's only so much you have to really know. And for the really tough stuff, you could say brief it.
Right. Well, and that's a good technique for a judge or even a prosecutor or a defense attorney is when you get in over your head, recognize it, and say, Your Honor, that's an interesting question. I'd like to brief that. So if we could have 7 days to we'll put together a memo. I'll brief that issue for you.
That's what I just had a bench trial on Friday, and we said there's some First Amendment issues involved in it, and it's a guy, he violated a First Amendment zone. And he got charged with trespassing.
First Amendment zone. I thought the United States was the First Amendment zone.
Well, there's a bunch of issues that the judge is bringing up, talking to us. And I said, Your Honor, we might as well just brief it. And I'm just going to make it facial and as applied challenge. But
and prosecutors don't like to do that because they don't like to work and research because they got a whole mess of cases and actually do a bench memo is a pain in the butt. And judges don't like it because they feel they're all impressed and they know the law and they're supposed to know the law and they're up there commanding and I'm the judge. And so it's an ego thing to say, I don't know.
This judge, though, I will say is not one of those guys. He's actually really good.
Absolutely not. He's terrible.
But no, I think Judge Glanville, I think he kind of got he got a little into it too deep. And then he didn't know how to get out.
Yes.
So
and he looks to me like he's relying on a lot of Westlaw head notes.
Yeah, and he got stuck in there. He got called out, and he's like, "Oh shit!" But this is, and this is kind of one of those things. Like anybody will do this. When you get cornered, you start fighting.
Yeah,
and you keep digging in, and
he
just kept digging and digging and digging.
That's why humility. I think I've told the story before that Clarence Thomas was. I've spoken to him a couple times, and he says humility is one of the greatest qualities in a judge.
Mm-hmm.
And this guy doesn't have any of it. He's rolling over people. He's an arrogant a-hole.
Yeah, and he's been, and I understand you guys are saying I'm giving him too much credit for his background. Okay, I get it, but my point is he wasn't just some rum-dum ambulance chaser, or he wasn't some guy who just schlepped his way through the prosecutor's office for whatever amount of time. He had to display a little bit of ability to do his job.
I don't know. I want to look him up now. What's his name again?
Ural Glanville.
Ural.
Here, I'll bring it up. He's hold on here. I'll bring it up, Steve.
Okay, here he is, Chief Judge, Superior.
Yeah, so that's the funny thing. People are like, he should go the Chief Judge. I'm like, he is the Chief Judge.
Yeah, but the Chief Judge, all that means is that
I know
all the paperwork.
But there were people here who were like, can't we go to the Chief Judge? I'm like, he is the manager. I was trying to make the joke, I want to speak to the manager. I'm like, well, that's him.
He's an Uga.
Yes. Yeah, he went to University of Georgia, which actually, guys, you may laugh, is actually a very good law school.
No, Uga's good.
Yeah, well, it's definitely better than University of Toledo. It's got a better ranking.
Huh.
He's not Nathan Wade, I guess, is the point.
Well, I'll tell you, looking at his credentials here.
Yeah.
His credentials do not reflect. Oh, yeah, you're looking at it too. I was pulling it up on his upper window.
I would not expect a guy with these kind of credentials to fuck up this bad.
Well, I guess when you get the more degrees you get, the more you realize it doesn't mean anything.
Well, yeah, you know what you don't know. Yeah. I'm just a little disappointed that this guy did this.
I'm very disappointed. This is a very disappointing performance, and it's bad for law. See, this is what people do. It's not about this guy or this trial necessarily.
Mm-hmm.
This is when you have this kind of incompetence, it's bad for the law. It's bad for the state, and law is essential for an operating society.
This is seen all over the country and all over the world. this makes it a mockery. Like, oh, you know, and yeah, we can make all the jokes, ha ha ha, you know, hee hawville, Georgia, this is going down.
It's not.
This
It's
makes-
Atlanta. It's a big city.
That's what I mean. But I'm just saying, people can go, ha ha, they're hillbillies in Georgia. This is embarrassing to me as a guy who went to law school, that people are like, wait, this is what people from law school do? Like, someone who's an attorney can, like, do this?
Yeah.
Yeah.
Well, it's clearly there's arrogance, there's no humility, and he's used to people rolling over people. And this is a big trial. I'll tell you, I'm thinking of a few judges in our jurisdiction that could have handled this case, and they would have been great. And there's no way.
I know of.
Yeah, I mean, but you got to get your best. I'm just very unimpressed.
The judges I know would have like broken the housebroken the prosecutors a long time ago, and like, narrow this down. We're not taking 6 months to pick a jury. We're not.
Yeah, they would have sidebarred. They'd say after the first hour on stupid, authentication witness.
Yeah.
They, counsel approach. Say, counselor, this is an authentic case of witness. Get to the point, ask your question, and sit down.
Yeah,
and then it continued. Hammer, right?
And the judge would have been like, "We are now in June. We are 180 days in, and we're only 88 days down." He would have been like looking at the prosecution. You have how many witnesses? You've got 30 more days, and then you're done.
Or I don't know. There's some major problems going on in this courtroom. Prosecutors
this entire trial is a disaster.
And I think it's a mistrial. Right now, it's a mistrial. And
it's 100. I don't think there's any way you can undo it.
But but the thing is how do you navigate that when the judge doesn't want to grant it? So I think that the appellate court's almost got to step in and disqualify the judge.
Yeah. Yep. And a new judge that comes in is going to be like, I don't want this. I'm out.
Well, a new judge is going to have to come in. They could bring in a successor judge, but he's going to have to say, start over. Can't bring in.
Well, that's what I mean. He's going to have to be like, he's not going to want to deal with this.
No, it's like start over, mistrial, next game. And then there's going to be a motion for double jeopardy based on the but I'm not sure, that's not as strong as what people think. It's possible that double jeopardy would not attach and there could be another trial. But, a prosecutor should learn from this. They got it. I mean, what's wrong with that prosecutor's office? They need to say, what are we really trying here? Let's
Fannie
focus.
Lewis or Fannie Lewis is the prosecutor, so
Trump's
they know.
I get it.
Yeah.
But seriously, they ought to reflect a little bit on their case and start getting a little cleaner.
And Stephen, no, I agree. This is a that's why I said this is an embarrassment for the entire country, the entire legal profession. Like, there are judges all over the country who are watching this, who probably watch this on Twitter, or somebody sent them saying, "Oh my God, did you see this?" Who are like mortified that this just happened on national TV. That was disgusting to watch.
Yeah, it was embarrassing. And this is the thing is, when you've got that defense attorney is competent, respectful, and knows what he's doing, the prosecutor and the judge should be kissing that guy's feet. Because I've seen a lot of really bad defense attorneys who are disrespectful, nasty, throwing stuff, don't know what they're doing. Those are the people that deserve contempt, not somebody who's on top of their game, who's doing their best for their client. That's a person you thank your lucky stars that person's on the defense table because that protects the record. But instead, he's threatened by the competence of the defense counsel, and he's responding with arrogance. It's a very bad combination. This defense attorney does not deserve the hammer of contempt. He is standing up for his client. He's doing what he thinks is right. The judge should be backing way off on this because he may be wrong. He may be wrong. We think he is wrong, but he needs to recognize that he's got a decision here and he might be wrong. So I'll tell you what, I'm going to hand this off to the appellate court or some higher court so you can resolve that before I impose sanctions. Something like that. He's got to back off, but instead he's doubling down.
Well, he doesn't have enough. He's too full of hubris to do that. He still wanted to hang it over this guy's head, but he's like, I'll be benevolent and give you a week to figure it out.
And it reminds me, I do remember this one judge that I had that I remember, and he was a terror on the bench, but he was an Army guy. He was an Army guy, and he was just used to everybody saluting, and he was abusive to everybody.
Well,
Off the bench, he was the sweetest guy. You'd
I
like,
think
what
that's an
happened to-
issue here for this judge because he was a general. And that's a thing. Like once you get to the higher staff levels, like generals aren't told no by people.
Right.
Generals aren't told even in a JAG setting, there's still a hierarchy. You know, the whoever's presiding over the hearing can't order you not to do something, but you're still bound by military custom. Here, Brian Steele just said, "No, I'm doing what the fuck I want," and I'm sure that didn't go well for him.
And the judges too, and a general in the military, error is really not allowed. You don't get rewarded for saying,
Well,
"Gee, I
that but
screwed
generals
up."
also don't fail. They can pawn
Right.
it off on someone.
Yeah, all the soldiers fail for him.
Yeah. AK says, could he be held in contempt if he ignores the Court of Appeals orders? Yes. They can hold him in contempt.
He could be removed.
Yes.
From the bench, not just from the case.
The Court of Appeals can get involved. They could say, they could, just like with the Richard Allen case, where the Supreme Court of Indiana threatened a judge with show cause, a trial court. They could say
they
show
could
cause.
remove him from the king and then refer him to the JQC, which was Florida's JQC, saying, answer, we also see ethical violations here. In fact, they could do that. I think they should do that. Now, I don't know how the Georgia appellate system is. Because these are also judges that get elevated to the appellate level.
But yeah, they could hold him and say, "Hey, Judge Glanville, you're going to give us a transcript, and we're going to hold you show cause. You better explain to us, either give us a transcript or you're going to tell us why you aren't going to give it up." And then he might put together some crap. They'll look at it and say, "Okay, cool. We don't care. Give us a transcript now," and they will order him to do it. And then he'll have to knuckle under, because defying them will not end well.
Yep.
Hunch the Dirty Roofer says he should name the boat he buys after the judge. Yeah, but he's not going to sue the judge into poverty. And it's good to see you, Hunch.
No,
but
this is not,
he's already getting paid by Young Thug, and Young Thug has millions, so he's already making.
My
that
son
money.
knows who Young Thug is, by the way, and he knew about the whole contempt order. It's like it was funny because I just got back from dinner. We were sitting down for dinner, and I'm like, "Oh yeah, I was on with Nick Starro and Sean about the Young Thug RICO trial." And he's like, "Oh, I know that guy." He's like, he put an album out, I guess, with his like courtroom appearance on it.
Yep, he did. I was gonna say, Steve, it's definitely looking a little. That room's looking a little bigger with all your packing up in there behind you.
Oh my God, you don't know how much packing. This whole house is disaster.
Yeah. Not Your Problem says, I think there's a competence problem. Yes.
Yeah.
I see it in my engineering career. Maybe it's just me. Yeah. And I think he thought he would say, because normally if you have information like that, or, you got privilege, I think he thinks it's like he was treating that like Brian Steele read his email and he's like, how dare you? And he didn't stop to think, oh, wait, I'm the bad guy right now.
Well, of course not. He's not the guy. He's the pinnacle of all law and
I'm
goodness.
the judge.
I'm the judge. I have the black robe. I have a hammer.
Yes. And Nicholas Kreuzer says double jeopardy, baby. Ooh. Yes.
I'm just saying it's an issue before. If there's a mistrial here, that will have to be played out because that's an immunity question. So that will have to be played out in interlocutory fashion before they can proceed.
Pathetic Hermetic is saying, could this blow open a federal or state case for an incessant relationship between the judiciary and the prosecution? Not necessarily like a criminal case, but the ethics board will get involved. And
yeah, in a perfect world, but the problem is the system is so.
Oh, I agree. And in Georgia, it's Fannie's team, so probably not. But this is sometimes you fuck up just enough that the government comes after you to,
I've been ignoring, all this, like these cases that are being you YouTube lawyers are following. I've been actively ignoring them. But when you put on there defense lawyer held in criminal contempt in this case, I was like, I jump on because this is very unusual. And I've I've seen a lot of stuff. I mean, I've had thousands of cases, right? And lots of appeals. I've never seen a judge do what this judge did.
I've never seen it either. I've never heard of this.
It's so outside the box. And he got caught. And now you're seeing the repercussions, like he's reacting because I don't know. I mean, somewhere deep down, he must know what he was doing was wrong.
Oh, I'm thinking that he was gone for an hour. He's like, I'll be back in 5 minutes. And he was gone for an hour. I'm sure his phone exploded and other people are like, dude, what are you doing? I'm sure he got emails from other judges like, bro. I'm sure he consulted with other people he knew and they're like, this isn't good, buddy.
I don't know, but ego, this guy's ego is obviously through the roof. And he's right with everything because he's the general.
Yes.
And I'm the chief judge and I'm the general and I just got reelected and I'm the black robe and I got the power in my courtroom, blah, 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 blah.
Yes. Can this affect other cases? No. I mean, it really only affect this one. I mean, it'll be tough for anybody that has him for other things and he gets nuked. It'll restart other stuff probably.
I apologize for RTT2. That's my people, my wife's that go in and out the doors.
Oh, no, that's good. It's all fine. His next album should be his lawyer on the cover getting arrested. I bet, oh my God, that would be so cool. I bet Brian Steele would let him do that.
This is major credit. You know, doing criminal law, the thing that the clients really, they are always suspicious that they think that you're in bed with the prosecutor.
Mm-hmm.
And so the lawyer that's like, my lawyer was willing to go to jail for me. He wasn't going to give it up for him. That is cred for a defense lawyer.
Oh, yeah. Hunch is saying, yeah, I know he won't sue the judge, but this gave him $5 million in billables for all the new clients. Yes. That was free advertising right there.
Maybe,
he's probably free advertising. He's now lawyer of the year in the state of Georgia. Probably on top of everything else.
Defense bar, Golden Hammer Award or something.
Yeah. Young Thug and Gunna have a song about Steele already. Steele got Gunna off another case. Yes. Gunna's another one of the guys in that group. That Brian
His crew. Yeah. But and this is another thing. By failing this bad, I mean, I'm not certain that these guys could have done it and be involved in all kinds of criminality.
Yeah. And that's the funny
part. By screwing up like this, you're going to allow the criminality to blossom and grow. Now they're undefeatable, right? I got my defense lawyer. They usually don't say, damn, I dodged a bullet on that one. I'm going to stop doing all this whoring and drinking and criminality, right?
That's the thing. Yeah. And the prosecutors, they had this and they thought they had it. And they gave it up too. It was theirs to win.
Yeah, put on a clean, efficient case, legally follow the evidence, put it on, get off. This 88 days and a year worth of trial. What are they doing?
Mm-hmm. Well, they got the tiger by the tail, and they thought, oh, we could do a RICO trial, and it's like, but have you ever done one? It's like, nope.
And they should have. I mean, having 13 defendants, I think that's a bad idea too.
It is. Yeah. Well, there's a case with 19 defendants.
That's stupid. I mean, I know that I understand kind of like, well, but see, this is obviously not the judge or the defense team or the case to be doing that on.
Mm-hmm. Fair Frozen says, you riding late tonight on YouTube? For a little bit, but I'm gonna log off here probably in about 5 or so minutes because I gotta get ready for the 8:30 show on locals. Probably more like 8:45 because I need to get a break here. I saw this shit live out of curiosity and lack of other shit to watch. Well, I'm glad that it fulfilled that purpose. Chef's kiss coverage. Well, thank you. Also, what the fuck, France? Hey, France got based. I don't know if you heard, but the National Front and then the AFD and all the groups in Europe just clobbered and ate up seats in the European Parliament. And
the Green parties suffered throughout Europe.
Yes, they did. They suffered. And then Macron dissolved the French Parliament. So
yeah, what else is new?
Yes. Not Your Problem says whoever moves to Fulton County is crazy. And Hunch is saying, is that judge going to get a finder's fee for all the clients?
Hunch.
I don't know, man. He's not going to be making money other ways.
Yeah, I got to meet Hunch, the Dirty Roofer.
Oh, you did? Nice.
Yeah, we went out to lunch. We came to one of my book things.
Okay. Yeah. Darcy says states should not do RICO. Well, they should if it's done in coinciding with the federal law. But yes, most states won't do it anyway because it's a very time-intensive thing. Although I had a RICO case once where it was 6 people. And that was actually pretty manageable. There was a lot involved in it, but their pattern of criminal activity was the they go shoplift from Lowe's A and then go to like Lowe's D in the air. They were going to all the stores in the area to massive retail theft ring. And
yeah, but you can just line. We had a blood gang. It wasn't like a national blood. It was a local kind of group. They called themselves the Bloods, and we tried them, but we tried them all separately. We went down the line, 1, 2, 3, 4. I think we had 13 defendants, and just ping, 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 ping. Got every one, and it's like, and then the final, the leader was the leader guy. We charged him with RICO, and we got him on the RICO. A couple of the cases that I nailed him on, there was some good stories trying the guy. His name was Brandon Washington. He's life in prison.
Oh,
and he was the leader of the gang. And I remember after my closing, I did a couple of his predicate crimes before the RICO case. And I remember he during it was the funniest thing. A little quick story. So Brandon Washington is the gang leader over there. We actually had him as a kid as a picture on the lap of Santa Claus, and Santa Claus was my boss in the prosecutor's office, was playing Santa Claus, and little baby Brandon Washington. And so after my closing argument, one of the cases, I'm sitting there in the prosecutor's chair, and he's over there on the defense chair, and he goes, hey, Gosdy. And I'm like, what's this? Like the defendant's calling me. I'm like, what? After my closing, he says, hey man, good job. He liked my closing.
Nice.
Oh, it was a pretty good compliment from the defendant. Oh. But anyway,
speaking of that, here's a trip down memory lane for you, Steve. Brandon Washington.
Oh, there he is. Yep. Yeah. He tried the sovereign citizen routine.
Didn't go well.
No, it didn't. He tried it for a little bit. It didn't go well. Yeah, he was. It's sad because the guy had some talent. He was. He was smart. He was likable. It's some of these guys, it's a tragedy to see him, life in prison, it's a waste of, but what do you do? He was involved in a murder, sick.
I agree. So
good find. See, that was one of my big hits as a prosecutor.
And as J-Rock says, suffer commies. Yes, all the commies should suffer. And yes, I know the AFD and the FN and the Italians are about as base as the GOP, but they're still more based than the Greens. So gotta take what you get, guys. All right. So yeah, guys, I'm sorry. This Karen Reed trial really didn't turn into Karen Reed trial day 22. We'll probably catch up at that some point this week. We're going to get behind because I've got court a couple days this week. But yeah, this is totally worth covering. This had to be covered.
Got a good, this chatter in your chat is really good. No Cure San.
Yes.
It says, have the sovereign citizen defense ever worked in the history of the U.S.? The answer is no.
There's got to be somewhere where it worked at least once, like in the 1830s.
Well, when it works, here's what happens.
Yeah.
Is these cops that aren't used to it stop somebody on the side of the road, and they get bamboozled by all the sovereign citizen stuff. The guy draws on him and kills the cop.
Yes. So, well, that part, yes. But I'm just saying the actual arguments. I'm sure that somebody bamboozled some frontier magistrate about the Treaty of Friendship, and I'm assuming it worked like in 1805 or something.
No, don't assume anything. But one thing I've learned dealing with them is that it's all irrational.
It's all gibberish. But
yeah,
I'm assuming at some point it worked for somebody somewhere.
No. Never. Have you ever heard? I've never heard.
No, well, that's what I mean, Steve. It'd have been 220 years ago, is my point.
No. Sorry. I won't even give that credibility.
Zach says Steve loves soft sits. He's also very agreeable.
You see, as I'm disagreeing with the host.
See, I love sovereign citizens too. I love the lore. I love all their knowledge. Like, I love learning all the stuff they do. It's so interesting to me.
I hate it. I hate them.
I hate them, but I think it's hilarious, like the way they handle stuff. Like the judge walks out of the courtroom, they're like, "The captain's abandoned ship."
I wish they would hire me to develop a real sovereign citizen manual, because I could like come up with a whole alternative like theory about the relationship of government, and I thought,
No, don't do that. You're going to give them the actual keys to the
yeah,
kingdom.
give them something really good to argue, rather than this like the fringed flag and admiralty law.
Yeah.
I mean, or your all caps. I mean, that's so stupid.
You're gonna get crappy emails from people like, no, Steve, don't. It's the
Yeah,
forbidden
no.
knowledge.
Well, the
You're
state
gonna help them.
is hiring me, not the sovereign citizens. But if they had enough money, I'd develop this manual for them.
Legal Vices says fun facts has nothing to do ever whatso with maritime law.
Yeah.
Says you. Says
Well, he's
you.
a maritime lawyer, man. He does the
Yeah,
maritime.
that doesn't mean he knows.
Yes, it does. I would.
No.
Would you battle vices on maritime law?
If there's a court with that, are we in a court with an admiralty flag?
Yeah.
Maybe.
Oh.
Or are we in a court with a regular flag? That's where it matters.
You'd start arguing that fringe argument. You like that fringe argument, don't
I mean, to be fair, I will say the gold fringe flag thing about being an admiralty flag, back in like the early 1800s, like back in the early 19th century, that was an actual distinction. That was for an admiralty court or for a courts martial. That really went away very quickly. Like after,
and
like,
I'm not afraid to say I have no knowledge on this thing, nor do I care.
Yes, I do think it's interesting.
Yeah.
Jeremy Carroll says, I don't think you could develop a hygiene routine there. You seem like a right pick.
I know it's not pick.
You seem like a right prick. Yeah.
I like the.
Well, I mean,
I like the guy with Orson Welles over there.
yeah. I mean, I don't think I can develop a hygiene routine. Do I look like I'm raising 5 children in Minnesota? I could develop a hygiene routine, homie. Oh, so. And this is the last thing here. We're going to end on this. Unknown Hero for $2 says, I love sovereign sits. They are an endless supply of crazy. Yes, they are. Yes, they are.
It's good content. Let's put it that way.
Yes,
I
but
will
they are
continue.
dangerous at times and horrible for people to deal with.
Very cops need to be very careful.
Well, cops are dangerous with them too. Oh, Jeremy says, I was talking to Steven, just having fun. Well, I was trying to have fun with that too.
Yeah, it was a well-intended jab.
Okay. Well, it all worked out. It's all good. It's just like Tombstone. It's like, here, put the guns on the table. Now we can be friends.
No problem.
Yeah.
All it good. Humor is it's.
Mm-hmm.
I don't take offense by almost anything. Unless it's got to be. Well, I don't want to give the weaknesses out, but I mean,
yeah,
say what you want, right? I mean, it's free speech. I don't get offended generally.
Yes. And I'll actually end on this, Jeff. This is at you. You have flags with fringe on them. Ooh. There's fighting words. So, all right, guys, that is it for us tonight. And we are going to go over to locals probably in about 15, 20 minutes and hang out, talk about this, talk about all the other stuff going on. Steve Gosney at stevegosney.com. Buy his books, chat, including the death penalty, due process.
Well, the new one is going to be
Yes.
released on the 21st. It's not really for sale yet, but I'm probably have a release party on Thursday.
Okay.
But
Death penalty designs maximum due process.
Yes.
There we
Working
go.
on it. Working on it. That's not the cover. This is a fake cover. It's just a proof copy.
It's real to me. It's real to me, Steve.
Yes.
So
thank you very much. Good to see you, Sean, as always.
Yes,
And give
and
my
that's
best to the second wife.
Oh, of course. Of course. 2.0, I'll let her know. She's out and about tonight, but I will let her know. And guys, remember till next time, even though Brian Steele may have done something, he's definitely not guilty. So good night, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't